practiced as an attorney for 15 years. 14 years, I was the sole proprietor of my own firm.
All right. Doing what kind of work?
Well, initially, being a woman at that time, the opportunities for commercial work, etc., was quite limited. So I initially started out doing criminal work, and I sort of called myself a GP, a general practitioner, that would include administration of estates, doing criminal work, which was the larger part of my work, and then the run-of-the-mill legal work such as interdicts, spoliation orders, eviction matters, everything but complex commercial matters. And I took whatever came on my table.
Yeah, as we all did.
Yes.
You were permanently appointed in this division you seek to lead now in 2006 already.
That's correct, Chief Justice.
But you had acted as a judge before.
I've acted as a judge, that's correct, first in the Northern Cape, 2 terms in the Northern Cape and 1 term in the Eastern Cape. Currently, 2 months from now, my period of service as a judge would be 19 years.
In which seat of the Eastern Cape Division did you work?
I worked in Port Elizabeth as well as Grahamstown, which was the seat of the appeal court in Grahamstown.
Right, I did not know that until I read your papers. Okay, and you have acted at the Apex Court?
I have acted for 1 full year in the Constitutional Court, that's correct.
How did you find that experience?
It was quite an experience because I was exposed to hands-on experience of the transformation agenda of our Constitution. And it made me more alive to the situation in South Africa, human rights, socio-economic conditions, and the mandate of the Constitution and its transformative agenda. So it was a very, very enlightening and educational experience for me.
Yes. But then you refused my invitation to act at the Supreme Court of Appeal.
At that time, it wasn't a suitable time for me due to personal reasons, Chief Justice.
Yeah, no, I'm just, I never forgave you for that.
There's still opportunity for me in the future, Chief Justice.
Indeed, you still have a lot of time on the bench. is it 10 years?
That's correct, Chief Justice.
All right. You've done a lot of things. You've managed to find time to write articles that were published in the midst of your busy job and family life and everything else.
That's correct, Chief Justice. I was quite busy in my younger days. I was quite energetic. You will note that I sat for the notary exams, I sat for the conveyancing exams.
Oh yes, you were admitted as conveyancer and notary public as well.
Yeah, I was quite energetic at the time, Chief Justice.
But then you were writing as recently as 2016. You'd been a judge for 10 years then, but then you stopped.
I stopped because I had to focus more on my judgment writing and speak through my judgments. But I would like to resume writing because there are many things that one can write about.
Yeah. Well, you've written many judgments in the 19 years on the bench. I'm not even going to go there on all aspects of the law. You've been very active. Well, you've been involved with a number of organizations, but notably the South African chapter of the International Association of Women Judges, of which you were an executive member for 2 terms.
That's correct, Chief Justice. I started out at NADAL. My principal was Essa Musa, who was one of the founder members of NADAL. When I started my articles there, I immediately became involved in NADAL. That is the organization I've been attached to, I think, the longest. And then 5 years before my appointment, I was with BLA. And then, of course, as a judge, I became active in the International Association of Women Judges, where I served as treasurer for 2 terms. That translates into 4 years.
Okay. You've been in a leadership position in that court for a number of years. When were you appointed as Deputy Judge President?
The 1st of June 2016, Chief Justice. I'm currently Deputy Judge President of the division for 8 years, and I've been acting as Acting Judge President 2 months, short of 2 years. So it's 10 years, almost 10 years in total. Okay.
It's public knowledge that that court is notorious for being troubled, for use of a simple term. And in fact, one of your contenders has mentioned that morale is low, and he says one of the things he would like to achieve if he is appointed is to create an environment where judges can work, speak, and just go about their way without feeling intimidated. And then there is a statement that raises a number of concerns that was submitted to the Judicial Service Commission by one of the senior judges there, Judge Ali, who lists a number of things that she says are concerning about your leadership style and the measures you have implemented, which she perceives as ruinous to the running of the court. How are things there, really? And just how are things there, and what do you have in mind to put them right if these accounts are true?
Chief Justice, short of 2 months, I have been leading that division for almost 2 years. When I stepped into that position of acting judge president, the division was in a dire state. There were no judges' meetings held for a period of 6 years. The tea room was non-existent. The morale of the judges were low. So yes, it was very challenging for me initially when I took over this division. I immediately introduced mechanisms to make the environment more conducive for judges to operate in. And Chief Justice, I can categorically say that if there is a judge who says that the division is troubled as I sit here today, that is not a correct statement to make. I've introduced judges' meetings upon my appointment. Judges are free to air their views. Judges are free to place matters on the agenda. This was mentioned in Judge Ali's comments that she's made, but I will get there later. The division is not a division where no one is talking to each other, where no one is performing, where people are, where there's mistrust and unstable environment. I think if there's anyone who says that the Western Cape division is in disarray, it is an incorrect statement to make. I have worked very hard and I have put mechanisms in place to make the environment conducive for service delivery, and I believe that I did that to the best of my ability. There has never been any bad publicity about the Western Cape High Court in the almost 2 years that I have been leading that division. So, if a judge says that that judge feels uncomfortable in that division, and that division is not running properly, and that that judge does not have a voice, it is an incorrect statement. My chambers is open. I have an open door policy. And Chief Justice and Honourable Commissioners, let me inform you as follows. Not a single judge came to my chambers to come and complain about anything. And for any judge to now at this stage make submissions to this august body that the division has problems, I am very surprised to hear that. I have an open door policy. Anyone can come and see me at 9:30 in the morning without an appointment. But let me go back to when I took over this division, I immediately called the judges' meeting. I informed the judges, we are all alive to the history in this division, and I am now assuming the seat, and we must now go on a project of healing in the division. And I allowed all the judges to articulate how they feel, what they think we should do to improve the running of the division, what mechanisms we can put in place, and we had a very productive meeting. My words at the start of that meeting was, let's have a conversation. So, Chief Justice, I dispute any statement that's trying to create the perception that that division is not functioning efficiently, effectively. If there is a judge who may have an issue, it was not raised with me. We have regular judges' meetings. I reinstalled the tea room specifically to further and to encourage collegiality in the division. The tea room was non-existent when I took over the division. The tea room is flourishing. We have a regular judges' meeting. We are communicating with each other. Judges are free to air their views, make suggestions, etc. With regard to Judge Ali, I have responded to those submissions, and I am quite happy to respond to each and every aspect that any commissioner feels I should respond to. All I can say is Judge Ali is not in leadership. She is not aware as to how my office functions and the processes that is in place. And if there's any specific aspect that any commissioner would like to clarify with me, I am most welcome to do that. But let me take one aspect that she's raised in her submissions that she has made. She talks about expedited dates, implying that I am creating a system of preferential treatment in certain matters, and alluded to the fact that I can be swayed to expedite matters. And then thereafter she states that my strategy, the manner in which I allocate expedited dates, impacts on judges who are attending to semi-urgent and urgent matters, in the sense that if a judge decides a matter is urgent or semi-urgent, and I can interfere by providing expedited dates, I would imagine bringing those dates forward or interfering with urgent and semi-urgent dates. Honourable Commissioners, that statement is entirely untrue. An expedited date has got nothing to do with urgent dates or semi-urgent dates. But when one reads those comments, it can create the impression, why would the AJP give people expedited dates alongside the concept of semi-urgent and urgent matters? But there's no connection between the two. Honourable Commissioners, an expedited date is exactly what it is. There's already a trial date allocated to those matters. So as an example, the hearing date could be scheduled for the 10th of February 2025, and the parties, and that is all the parties in the matter, may approach the Office of the Judge President to expedite that particular date. It has got nothing to do with urgent matters. People can apply for urgent dates in the normal course. The judge on urgent duty deals with those issues. Semi-urgent dates, they can go to the 4th Division clerk for a semi-urgent date. But expedited dates, which falls within the prerogative of the Judge President, is done as follows. All applications for expedited dates must be in writing, and it must be at the request of both parties. As I've alluded to earlier, the date may have been scheduled for February 2025, and what the parties then do is they jointly approach the acting Judge President to bring the date forward, and that is on that basis that a matter can then be expedited if there are legitimate grounds for that. I have been doing it as the acting Judge President for many years, and there's no magic to it. There's no fixed criteria, obviously, but it can be for many reasons, and both parties must seek and apply for the expedited date. So it is done in writing. It is a paper process. I don't see anyone, and it is assessed on its merits On paper, it can be any reason. For example, one of the parties will be immigrating, or it involves a child, or someone is very ill and frail, or very elderly. There are many scenarios. That's why there's not a fixed list as to when you allow expedited dates. So, Chief Justice, just on that score, and you've alluded to concerns raised by Judge Ali, I just needed to clarify the fact that expedited dates, semi-urgent dates, and urgent dates are entirely separate issues.
Well, she does raise other concerns,
Yes.
ranging from an allegation that whilst there are judges' meetings, no minutes are taken there, so it's difficult to keep up with what resolutions were taken, to the more serious that the system of the continuous role, which the importance of which we know too well, has been prejudiced by the manner in which, the measures you have put in place, causing delays in work output. And then there is another concern, another serious concern, the general impression, in fact, that one gets from this submission, that the judges there do not have a voice, really. You impose your views and decisions upon them. You don't consult. That's what comes out of this.
Chief Justice, the last statement, I'm the one who introduced judges' meetings. Judges are free to place any items on the agenda, and that is how we've been running. I have an open door policy. I'm most certainly not a dictator. I can reassure this commission any judge can come and raise any issue with me. I did not actually get the impression that she was saying that judges don't have a voice in her comments. The fact of the matter is, I re-established regular judges' meetings. I re-established the tea room to promote collegiality, and any allegation that judges don't have a voice, I must refute those allegations. It is most certainly not true. With regard to minutes of meetings, Chief Justice, since 2010, no minutes have been taken at that meetings. I've made submissions on that regard. I was the last scribe of judges' meetings. A resolution was taken in 2010 that no minutes will be taken any longer. Judges should be free to express themselves. I have made written submissions on that point, that I requested the Judge President to stand down because I was the official scribe, and a judge was designated, a female judge, and then a debate ensued as to why only female judges should take minutes. The debate ensued, and Judge Ali was very vocal about it, and ultimately a decision was taken not to take any minutes in judges' meetings. That was 2010. So since 2010, no minutes were taken. But when I assumed my position as AJP, I took it upon myself to record my notes. I wouldn't call it minutes, it's my notes, because ultimately as a leader you must make notes as to the way forward and which matters should be actioned, etc., etc. This statement that there are no record of minutes and recordals of decisions taken, that is entirely untrue. I was the scribe last in 2010, and I'm still the scribe, Chief Justice. I'm still the scribe, because as the leader, you must know, you must action things. Some matters are referred to the practice committee. By the way, I also established the committees. There was no committees when I took over the division on the 14th of December 2020, so I re-established the tea room. I restored the meetings, and I then also re-established certain committees, the IT committee, building committee, library committee, etc., etc. So, commissioners, picture this. You have the freedom to air your views, to place a matter on the agenda. You have the freedom to air your views and say what you want to say and make proposals. In our very first meeting, the proposal came out. We only have 40 matters on the motion court roll. Let's increase it to 100 matters. That was at our very first meeting. Who says how can judges say they don't have a voice? And we implemented that. And if there were any other issues, we would decide how to action it. It would go be referred to the building committee, it would be referred to the library committee, or it would be referred to the practice committee in terms of how we action matters, or it would be something that management will raise with the chief registrar or with the director of court operations. Chief Justice, I can reassure this commission, there are indeed a record of each and every meeting that takes place there. It may not be visible to others. I was the last scribe, and I am still, in my capacity as AJP, still keeping minutes in that meeting. Then, with regard to a continuous role, the continuous role is very much alive in the division. But Chief Justice, we all know what happened to that continuous role during the COVID era. When I took over as the acting judge president on the 14th of December 2022, more than 80% of the judges were involved in crime. Only 20% of the judges were available for civil allocations. 80% of the judges were part of the criminal backlog project. Now, what do you do as a leader when 80% of the judges are all busy with crime? What happens to the civil role? What happens to the continuous role? How do you navigate your way around that? 80% of the judges in crime. And the 20% who were seized with civil matters were bearing the brunt of civil matters, and they were all overloaded with civil matters. They hardly had any space in their diaries. 20% of the judges had to carry that load, and Western Cape High Court has a heavy civil load. So with 80% of the judges in crime, 20% of judges busy with civil, Chief Justice, the reality is there cannot be a continuous role. The criminal backlog project obliterated the idea of a continuous role, and I had to navigate my way around that. So if anyone tells this commission, writes to this commission and says that the AJP interfered with the functioning of a continuous role, it means that they don't have an understanding of the state of the division. I did an audit of the state of the division when I assumed the position of AJP. And with 80% of the judges in crime, it was very difficult to maintain a continuous role with only 20% of the judges in crime, in civil. The idea is to allocate a matter and let one judge take the matter to its completion. That is the idea. But honourable commissioners, when I say 80% of the judges were in crime, you must understand that those 80% of the judges did not only deal with one criminal matter. They had more than one criminal matter each. And when I took over that division, the number of part-heard criminal matters that had to be completed in piecemeal fashion for various reasons. If one judge was in the criminal backlog pool, had 3 part-heard matters to attend to, they then had to align their diaries with defense counsel, with the state attorney, and align their diaries with the result that those part-heards were completed in a piecemeal fashion, which further obliterates the idea of a continuous role. The idea of the continuous role is an ideal in a normal situation where the court is functioning normally and where there are no backlogs and where you don't sit in a situation where 80% of the judges are seized with crime and you have a small number of judges who can then proceed with civil matters. So, Chief Justice, this idea that I ran this division not according to a continuous role, there's no merit in that. One must be alive to the realities of the situation following the COVID-19 pandemic, and our division is currently still dealing with the aftermath of that in terms of the finalizing of our criminal matters. The Western Cape High Court cannot, at this stage, have a fully functional, continuous role until we have achieved a certain level of completion with criminal matters, which we have now done in this last term.
All right, point taken, AJP. But just to go back to the first part of my question about my impression that you don't consult your colleagues there, this submission pertinently states that you fail to circulate timeously to your colleagues reports, discussion documents, and resolutions requiring their input. And it lists a number of examples and mentions something quite worrisome, that you do not ask the judges for their inputs at heads of court meetings, and they are not given feedback on decisions taken at that forum.
Chief Justice, I have responded to that allegation. Judge Ali mentioned a specific meeting and what had happened at that meeting. That meeting was specifically called to give feedback on what happened at a heads of court meeting. I actually call special meetings for the judges to attend. And not all the judges attend all the time. I don't think Judge Ali attended all the meetings, but I specifically call judges meetings, and then I call separate meetings to give feedback on what other issues are of concern. I have responded to that complaint, Chief Justice. There was an allegation that I didn't circulate the first rationalization report. I've responded to that allegation. That was under the leadership of Judge Traverso and Judge Lope. That allegation is not true. There was an allegation that I did not circulate the second rationalization report. I've provided proof of that. It was circulated to all the judges. There was an allegation that I did not circulate resolutions at the judges' conference to the judges. I have circulated those resolutions, and I have provided proof of that. Chief Justice, I think this allegation of me not communicating with judges and not circulating documents, I reject that allegation with the contempt it deserves, because one of my strengths is communication, and I am an inclusive leader. I'm a collaborative leader. There is absolutely no way that I would not circulate documents to judges. And for Judge Ali to make the statement after our judges' conference that I did not circulate the resolutions, I've provided the Commission with proof that I've circulated it. That in itself, it's an incorrect statement. And I would like to ask the Commission to view that statement with caution, because the exact items she mentioned that I did not circulate, I provided the Commission with proof thereof. And I do discuss important aspects as to what happens in the heads of court meetings regarding issues that affect the judges, whether it's the benefits, motor vehicle benefits, cell phone benefits, and issues with regarding recesses, leave periods, etc., etc. I do, and I had those type of meetings. And Honourable Commissioners, those meetings where I discuss matters that would be addressed at heads of court, I involve the admin management also in those meetings. They also sit in those meetings because budgetary issues comes up. Tools of trade is discussed. Benefits, judges' benefits are discussed. And it's important for the management, and I'm saying management, I'm talking about the management who would be responsible for the budget of the court. It's important that they are there. Or if there's a shortage of staff, which was also an item that we have discussed at heads of court meeting, I raise all those issues in the meetings that I call special meetings. The special meetings would be things that's not just within the division, but things that impacts on the judges. So, Chief Justice, that statement that I don't consult is incorrect, the statement that I don't circulate is incorrect, and the statement that I don't report on what happens at heads of court meetings are incorrect. And Judge Ali, in her own complaint, referred to a meeting which was specifically called to report on what had transpired in a heads of court meeting.
Thank you, AJP. Now, you've mentioned a number of measures you say you have put in place since you took over that have worked to get the division back on its feet helped it recover from the bad condition in which you found it when you took over as acting judge president. Is there still any room for improvement in the operations of the court? And if you think there is, what ideas do you have?
Chief Justice and Honourable Commissioners, I'm not here today to only talk about what I can do for the division. I am here to talk about what I have already done. I have a track record. I almost ran that division for 2 years. I have a track record. Chief Justice, when I took over that division, the Director of Public Prosecutions were not allowed in the building for some reason. The Director of Court Operations were not allowed to enter into that building. And when I assumed office, that is the first two people who came to see me. The National Director of Public Prosecutions informed me she's not allowed to enter the building. She must work through the Chief Registrar. If there's anything she wants to discuss regarding crime, she must speak through the Chief Registrar. And that hampered service delivery because there were no meeting between herself and the leadership to discuss the criminal backlog. I am aware that a senior judge was designated to be in charge of the criminal backlog, but that judge also did not liaise directly with the NPA. So I am mentioning this because this is one of the bad things that I found when I started, when I took over the division as AJP. The Director of Court Operations were only allowed to attend certain meetings. So they were the two first people who came to me, and I immediately restored their access to the division. And I, later on, we communicated with each other, and the NPA is obviously part of the stakeholders that I regularly consult. So that was also one of the first things I did, was consulting all stakeholders, be it the family advocate, NPA, the legal profession, LPC, etc. I have given an indication of what I have done, but the most important thing to remember is that there was no handover in that division. So I assumed the leadership of the division without any handover, and I was on my own, and I ran that division on my own for one full term. I did a wellness check, and I discovered 324 files that needed to be actioned, with correspondence as far back as August 2022, and I had to action those matters expeditiously. I did a wellness check and decided to run the division on my own the first term. And I utilized that strategy because in my capacity as Deputy Judge President, I had the necessary know-how to know how the division should run optimally. But the point that I'm making is the division was not in perfect shape at the time. No tea room, no stakeholder engagement, people were banned from the building, no regular meetings. And I had to restore and work with all those aspects. When I assumed the position as AJP, the lead time of cases were, that was in the 14th of December 2022, the closest date that you could get a civil matter on the roll was two and a half years from that date. 2.5 years from that date. I arrested that date with mechanisms that I've put in place. So, Chief Justice, I've mentioned some of the things that I have done. So I've spoken about the restoration of the committees. I've spoken about our meetings. I've involved judges in the running of the division, and some of the judges who are going to present themselves here today, they are members of committees. Judge Dolari is dealing with the building and management as well as Judge Mantami. Judge Fingers is involved in HR, in the practice committee. Judge Ali herself said that she was involved in training acting judges. There's not a single judge who was left out. And if judges don't have a voice, Chief Justice, I wonder why they would get involved and sit on these committees. That is not true. They were actively participating in structures that I initiated and put in place. So, Chief Justice, your question is, what did I do? Can I just get clarification? Because I can itemize what I did do.
No.
Or is it what new I would like to do?
I was asking if you still think there is room for improvement on the operations of the court, and if there is, what are those? What ideas do you have to get the court in better shape?
Chief Justice, currently the Western Cape Division is drowning in paper. In my view, the court is functioning quite in a stable manner. The court is fully functional. You can never say a court is functioning optimally because there's always room for improvement. But the Western Cape Division is drowning in paper. So what is needed desperately now, and the most efficient way to improve the Western Cape Division currently is through digitization. So with regard to digitization, all the staff have been trained, the judges have been trained. We are currently busy embarking on reaching out to other stakeholders, grassroots community members, and any person that you could think of, LPC, the Bar Council, the profession, the man in the street. We are busy embarking on consultation with stakeholders to provide training to them. So the entire court is trained, stakeholders will be trained. We are currently in the process of finalizing our practice directives, and then we will embark on the registration of all the parties and stakeholders, and we hope to go live on 1 December this year. That is the most pressing need for the Western Cape High Court, is to digitize the court, and that is work in progress at the moment, Chief Justice. With regard to the case flow as such, I have introduced mechanisms to increase productivity. I've indicated that when I assumed my position, I observed that the Friday appeal roll there were very few cases on the Friday appeal roll, sometimes just 3 or 4 cases. There are 33 judges. That would mean that you would have 3 judges in motion court. That would leave 30 judges who needs to be allocated on a Friday. And if there are only 3 cases, that would then keep 6 judges busy. And I immediately introduced a system where opposed motions are also now heard on a Friday to make the court more productive. I've also introduced a pro bono project. Many years ago, there was a pro bono project, but I introduced the pro bono project, not only limited to Fridays, but to any day whenever pro bono counsel is available. And that is to be understood against the background that 80% of the judges were involved in crime. So I needed the necessary assistance, specifically in the civil pool, and I made use of the pro bono resource. So what happened then was that the number of opposed motions, the finalization rate in terms of our stats increased dramatically because you had judges hearing opposed motions on a Friday, which could be 20 judges, as I've just indicated, and you have pro bono judges hearing opposed motions. So the biggest impact in terms of stats during my stint as the AJP is in the number of opposed motions that virtually trebled compared to previous years. I also established the RAF court that deals specifically with RAF matters. And the purpose of that court was to try and mediate some of the disputes, try to minimize the issues, and try to facilitate early settlement of RAF matters. And that specific court dealt with PRASA and RAF matters as well. And then, of course, There's the issue of damages, medical negligence matters that could also be mediated in that court. And I myself, I am involved in mediating family matters and medical negligence matters in order to see whether those matters can be settled out of court. So the RAF court also had big impact because many of the matters became settled, and that resulted in vacant slots for other matters. And then what the project that I then introduced was, where RAF matters were allocated in a specific slot, we then approach the profession, and where matters are postponed a year or so later, we give them an opportunity to fill those slots. In other words, we brought matters forward, and that arrested the lead time of matters in the division. From where I sit here now, if a civil matter, if you require a civil trial date, we are looking at the 12th of August, 2025. If you are looking for a semi-urgent date, we're looking at January 2025. An urgent date is even sooner. So our lead times currently is excellent. For civil trials, it currently is 8 months, but the goal is to get our lead times in 6 months. So the RAF project increased productivity, allowed us to bring matters forward and to increase our stats. The Friday project plus the pro bono project also increased productivity in the division and increased our stats insofar as opposed motions are concerned. With regard to crime, the division currently have 33 parted criminal matters. Last term, 16 criminal matters were finalized, and we currently have 33 parted matters, of which 14 of the matters are in sentencing stage. So if you take the 16 matters last term that was finalized, plus the 14 matters that is in sentencing stage, we're looking at 30 matters by this term, 30 matters would have been concluded. So there is an improvement in the finalization rate of criminal matters. Chief Justice, I did mention in my papers that I have introduced the RAF directives. I have also introduced the criminal directives, and through implementation of those directives, the court became more productive, and I streamlined processes with the RAF court and with the control of the criminal courts, the criminal directives that also improve the efficacy of the court. Thank you, Chief Justice.
Thank you, AJP. So, in sum, all's well as can be in the Western Cape Division of the High Court, and it only faces the challenges that the rest of our courts have.
Yes, Chief Justice, I want to reassure the Commission. I am the Deputy Judge President of that division. I've been trained. I have been fully trained by the former Judge President. The former Judge President was my mentor. And for me to step into the position of AJP, it cannot be correct if any judge wants to create the impression that I don't know what I'm doing and I don't know what's going on and judges don't have a voice. Quite frankly, that is not my personality. So, Chief Justice, to answer your question, it is correct. The Western Cape Division has normal challenges, lack of resources, shortage of staff, in need of building maintenance, sometimes the aircon doesn't work, in need of more judges, and in need of more courts. And on assumption of my position as AJP, and as I've indicated to the Commission, I have institutional memory. And as the saying goes, you must know where you come from to know where you're heading to. So I am very alive, and I've always been very alive to the fact that we need additional courts at the Western Cape High Court. And when I assumed my position as AJP, I immediately put mechanisms in place to achieve that goal for additional courts for the Western Cape High Court. So I've put mechanisms in place and motivated for the additional courts. And on the 24th of August this year, my request was approved. So it is a short-term project, short or medium-term, 2 to 3 year project. The Public Works approved the addition of 3 new courts for the Western Cape High Court, plus a record room. Chief Justice, my answer to your question is yes. There's nothing unique in the challenges that the Western Cape High Court face. The court is functioning, judges are talking, meetings are held, judges can air their views freely, and the challenges facing the Western Court is nothing more than challenges that would face any court, and that would be lack of resources, lack of space, too few judges, and then the question of digitization of the court. Thank you, Chief Justice.
Thank you, AJP. Judge Gamble, do you have questions for this candidate?
Yes, thank you, CJ. AJP, just a couple of nuts and bolts issues before I ask you a few more probing questions. Your CV shows us that you turn 60 tomorrow.
That's correct, Chief Justice.
So how much time do you have left to offer the division? Effectively 10 years, but you could go earlier if you wanted to.
I have 10 years, but I could leave on 65 if I want to, yes.
So the provision that you leave at 65 would mean that you could offer a minimum of 5 and a maximum of 10.
That's correct, Commissioner.
I'm looking at the list of acting judges at the moment, and I see that at present, the division has 14 acting judges in position.
That's correct.
There are actually more than 14 judges. Some of them share a term, but there are 14 slots for acting judges.
That's correct.
You've also lost a number of experienced judges over the last couple of years, and another one to go shortly.
That is correct, Commissioner. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and with one retiring floor to be 12. The division lost in the last, 3-4 years, 12 judges to retirement. There are currently 4 vacancies. Yes, the pool of the skills pool and the experience pool of the judges is depleted at the moment, busy depleting.
Now, I'm looking at the list, the current list of acting judges. You probably have it there before you. You've sourced acting judges from all over. Would you perhaps like to speak to that? I see that you've even sourced acting judges from Gauteng and I think Limpopo.
Yeah.
Would you like to speak to that?
Yeah, I just can't find my list. I'm just checking if I can lay my hand on it.
I can give you the list if you
can,
like.
Yeah, you can give me that list, but what I can say is I source acting judges from the profession, from stakeholders, and names are put forward, and then in consultation with the deputy, we would then invite acting judges. The idea is to make the pool as diverse as possible. And what we have experienced was that we were struggling to find capable black acting judges to act in the division. So resultantly, what I did, I went wider than the Western Cape High Court in order to make sure that the appointments are diverse And yes, I have approached, I think, 3 African women outside of the province to come and act in the division.
Now, there's an issue that the Chief Justice raised about division and disharmony in the division. I think you need to place that in context. I don't think you've given the Commission the proper context in relation to which that division arose, because it's something that many of us have lived through. You were appointed in 2016. At that stage, the applicants for Deputy Judge President were yourself, Judge Ali, and Judge Lagrange.
That's correct, Chief Justice.
The Judge President at that stage, the former Judge President at that stage, was happy to have you and pushed for your appointment, as I understand it.
I was appointed as the Deputy Chief Justice in 2016, and Judge Ali was also a contender for the position.
What was the relationship between yourself and the Chief and the former Judge President at the time of your appointment in 2016? Your working relationship?
The former Judge President and myself had an excellent relationship, working relationship. In fact, we had different leadership styles. He mentored me, he trained me, and I provided the necessary support to the former Judge President. I can safely say that there were no issues between us, and we complemented each other, and the division was well run at the time.
According to your CV in 2018, you spent the year at the Constitutional Court, the full year.
That's correct, Chief Justice.
And while you were away, was there an acting Deputy Judge President appointed in your place?
That is correct. It was Judge Desai.
When you came back from the Constitutional Court, you reassumed your position as DJP.
That's correct.
And then at the beginning of 2020, I think it was January 2020, you took the extraordinary step of laying a complaint against your Judge President. And that received a lot of publicity at the time, and a lot of people were critical about what was going on in the Western Cape. I think you need to explain to the commissioners what the context of that complaint was.
Judge Campbell, no, we're not going to go there. Some of these matters are still subject to adjudication by the Judicial Conduct Committee and perhaps a Judicial Conduct Tribunal. And quite apart from that, I don't think it would be right to ask the candidate about things which concern someone else who's not before us to answer for themselves. So please just desist from that line of questioning.
Very well, Chief Justice. After that complaint was lodged, what was the relationship between yourself and the former Judge President like?
Obviously, it impacted on our relationship. Chief Justice, I heard your directive that it is not necessary to go too much into detail surrounding what had transpired then. All I can tell the Commission is that I was a complainant and I lodged a complaint, and subsequent to my complaint, a counter-complaint against me was lodged. The matter went through the necessary processes, and ultimately a decision was made by this body as to what should happen to that complaint, in terms of which I was exonerated. I'm referring to the counter-complaint. But if I could answer Judge Gamble's question, yes, the division, there were tensions at the time after I lodged the complaint. And would like to indicate to the commissioners, and I informed the judges the same. The dispute was between myself and the Judge President. It didn't involve any other judges there. It was up to that judge if that judge would perhaps want to choose sides, etc. I'm not aware who chose sides what, and who did what. I regarded it as a personal matter and as a matter between myself and the Judge President. Therefore, if there's anyone who wants to allude...
Acting Judge President, I already gave a directive that we shall not discuss what may or may not have happened between you and former Judge President Hlopi. Please, let's not go there.
Thank you, Chief Justice. Thank you, Chief Justice.
Thank you.
I would just like to make the point that it was just an issue between two people. Thank you, Chief Justice.
Thank you.
And then lastly, sorry, may I continue?
Yes, please, we're waiting for you.
Lastly, when you took over, what was the relationship between the Office of the Judge President and the Cape Bar as far as acting appointments is concerned, and what was the relationship between that office and the bar in general?
Chief Justice,
Sorry, during which period?
Beg your pardon?
Just repeat the question. I didn't catch it.
I'm asking when Judge Goliath took over as the AJP, what the relationship between that office and the bar was.
Relationship between the court and the bar?
Yes.
Chief Justice, Commissioners, when I assumed office, I reached out to all the stakeholders. It was very clear to me that there was no communication between the Office of the Judge President and many of the stakeholders that I had reached out to. The bar was but one of the stakeholders that I reached out to.
That is ground we traversed when I led you,
Yes.
Acting Judge President. You did tell us about what you've done, about stakeholder engagement
Yes.
and training and all of that. So
Yes.
For the sake of time, if anything, let's just...
Yes. Chief Justice, I had a meeting with the bar. I will leave it at that. I think I'm not going to comment on the nature of the relationship. Safe to say that I have re-established a relationship between the bar and bench.
And then just lastly on that score, there's a pro bono scheme in place with the bar. Would you like to explain to the Commission how that works?
Chief Justice, because of the problem with the criminal backlog and the fact that 80% of the judges were stuck in crime, and I only had 20% judges in the civil pool, the need arose to obtain outside assistance. And after I re-established ties with the bar, I approached the bar at our meeting, at our stakeholder engagement meeting, proposals were put on the table for the bar to assist. Actually, it was an old project many years ago where the bar did assist on Fridays. I just expanded it. I reinvigorated the project after many years. And currently, there are about 30 advocates at the bar who make themselves available on a pro bono basis. I have re-established that project. The project is very, very productive, very fruitful, and it is increasing, as I have indicated, our productivity and our stats, more specifically with regard to in opposed motions.
And as I understand it, that system enjoys the sanction of the Minister. And what happens is at the beginning of any particular term, a number of pro bono counsel are sworn in as judges for the term. And then when the need arises, if it's necessary at short notice, you can call upon them to come in and assist to alleviate the civil role.
That is correct, Chief Justice. That is the sole purpose of the pro bono pool. We engage with them and they would notify my office of their availability. Any date that they are available, they would notify my office and we would then make use of their services. And yes, their main role is to assist in the civil pool.
Thank you, Chief Justice.
Thank you, Judge Campbell. Mr. Boshoff, do you have questions?
Yes, thank you, Chief Justice. Morning, AJP.
Morning.
Chief Justice, I'm aware we are running quite behind schedules, but...
yeah, we still have 6 other people to
interview
but with your grace, still.
If I'm used to having my 2 questions, but I'll try and make them quick.
All right.
AJP, so just firstly on leadership issues. You're applying for a position which is the key leadership role in this division. Now, a big part of management is people management. Now, you've at length addressed the complaints by Judge Ali, or the objections rather is a better phrasing. But what I find confusing is in your written response, you make mention of the reason why minutes were no longer kept. And the objection was that it might be seen as a stifling,
Yes.
etc. And therefore there was a resolution not to keep minutes. But you've now told this commission that in fact you do keep minutes, but your words were, they might not be visible to others. Now that to me creates the impression, because the purpose of minutes is to have a record which is then circulated afterwards and everybody agrees, yes, that is indeed what was said and that is what was decided. And as management, we move forward from that base. So what purpose does it then serve to keep these minutes on your own? And to me, at least, it creates the impression that it has the potential of weaponizing these minutes for a rainy day one day. And I'm concerned that that displays a misunderstanding of the nuance of why minutes are actually an empowering tool, rather than a tool that could be used to create more mistrust, which is the last thing this division would require. And then just on that note, again in the line of people management, this complaint that you speak to your fellow judges through your registrar, and that the registrar is perceived as almost kind of being, conveyor of your instructions to your fellow judges. And please, I'm not detracting from your registrar's experience and importance. That's not the point. Just being in management myself, I think, and also having a superior, I would not take kindly if secretaries were carrying instructions to me or me to my team. It creates the impression of, well, I don't have time to talk to you, but So I would just like to hear your comment on that. And that's my first kind of general question.
With regard to the minutes of the meetings, in 2010 a resolution was taken that no minutes should be taken at the meetings. I was the last scribe. I took the last minutes. And in case it didn't come out clear, what I indicated was that I make a record of issues that are discussed for purposes of an action plan. That is the reason why I make that notes as a leader. It's not meant for circulation. It is meant for action. If any proposal is made, if any recommendation is made, I must make a note of it to ensure that it is followed through. But Chief Justice and Commissioners, the resolution was taken in 2010 that judges want to engage freely and openly, and to use your words, no minutes can be weaponized against anyone. It was a resolution that was taken. I was the last scribe. I have institutional memory about that decision. The judges need to take a new resolution that we will in fact take minutes. But having said that, as a leader, you must note down action points. If something must be referred to the library committee, I will make a note. The judges who sit on the library committee will action it. If something must be followed up with the chief registrar, for example, where we resolved, I would make a note, we resolved that from now onwards, instead of 40 matters on the motion court roll, we are increasing it to 100. Those are the type of notes that I record so that I can know exactly what the issues were that was raised and what action was taken. And then there's a second chapter to this, Chief Justice and Commissioners. The meeting will reconvene and we will do our report backs and we will discuss if a matter was not properly resolved. So the fact that there's not formal minutes taken flows from a resolution that was taken 2010 because judges want to be free to air their views. and a statement that absolutely no minutes is taken by myself as the current acting leader in that division, it's not correct, because as the last scribe, I know the importance of recording certain decisions. So although I may not have returned as a full-time scribe where minutes are taken and circulated, or perhaps I should pause there, Chief Justice, since I have institutional memory. The minutes that I took in those meetings were just for recordal purposes. The minutes were never typed out while I was the scribe and while I recorded minutes. It was never typed and circulated. That didn't happen. It was only there for record purposes. If we need to go back and see what happened on a specific day, or whether something was raised by someone, we would consult it. But it wasn't typed, it wasn't approved, no one could change it. It was just for purposes of record keeping, and that stopped after a resolution was taken. So I'd like to reassure this Commission and Commissioner Boshoff that the meeting and the salient issues are most certainly recorded in the meeting, and it is followed up. It's actioned, and it is followed up, and it is raised again if it hasn't been executed.
Thank you. AJP, then, look, I just want to preface the following question with two statements. The first is that nobody expects judges to be perfect. Everybody's human. So it's certainly not uncommon for judges to have their decisions taken on appeal and appeals upheld, etc. And then secondly, I want to just assure you I certainly don't take pleasure in the necessity of this question. But it's come to my attention there are two judgments of the SCA which have dealt with your judgments as court of first instance. The most recent one is Standard Bank v. Pygon Construction. And I suppose the first sentence of the SCA's judgment really sets the tone, in which Judge Gorvin wrote, "If the errors and their consequences were not so serious, this appeal could be said to arise from a comedy of errors." And in which the SCA then explained that there were liquidation and sequestration applications before you, and there was a counter-application to join as an intervening party and apply for business rescue. But then there was a settlement agreement which culminated in a consent order withdrawing the application to intervene and business rescue, and to place, and then issue provisional orders of liquidation and sequestration, the discharge of which would be made contingent upon the sale of a property and payment of monies, etc. That then fell through, and the parties returned to court seeking, and this now Standard Bank, seeking final liquidation orders and sequestration orders. However, according to the SCA, you then ignored the consent order, didn't deal with it at all, granted the application for business rescue, and discharged the provisional orders. And the SCA in particular stated that you, in essence, dealt with a non-existent application. And given the consent order which you issued, had no jurisdiction to hear the issues of liquidation and sequestration any further. And the SCA, I just want to quote their words. Sorry, just in paragraph 28, I think I don't want to belabor the process with further quotations. But the court said, courts are not entitled to simply wish away previous orders or to ignore them totally when they bear on a matter at hand. In addition, Where there is no application to set aside the order or the agreement, it is not acceptable to deal with either in the kind of offhand manner as was done in the judgment refusing leave to appeal, because you also subsequently refused leave to appeal. The entire approach taken to the matter by the High Court must regrettably be deprecated in the strongest possible terms. Then in an earlier 2014 matter, Pangaka v. Botha, the SCA also stated that, in which you then sat with an acting judge in a two-judge bench, that the failure of the High Court to appreciate or consider the appropriate principles, it resulted in a grave injustice to the magistrate that heard the matter initially, and it may well have irreparably harmed that magistrate's professional life. And the court again said the High Court's approach was to be deprecated. Now, as a leader, I would submit that, and especially when you yourself have now said that there is, given recent retirements, a bit of a shortage in the skills pool, a lot of new judges, and you're relying a lot on acting judges, being a leader also requires mentorship and leading by example. And the question, I suppose, is how do you propose to do that when the SCA, in quite unusual terms, it's not, or let me rather say, it's not usual for the SCA when dismissing or upholding an appeal to speak in such terms of a court of quo's handling of a matter. What confidence does that instill in the public and those appearing in your division and those acting in your division and new judges who look to you for leadership on not only management front but technical abilities?
Thank you very much for that question. I just need to respond to the previous question regarding the role of my secretary. Honourable Commissioners, it is so that my secretary is interface with between my office and the judges, and it is so that my secretary would send out emails. Say, for example, it's the motion court roll. She would say to the judges, enclosed herewith, please find the motion court roll, and she would sign it off as my secretary. Obviously, all the judges know all the correspondence that emanates from my office, from my secretary, is sent on my instructions. If it's a document on which they must comment, my secretary would say, dear honourable judges, enclosed please find a document for your attention. That is the nature of the correspondence between my secretary and the judges. I don't find anything concerning about that. My secretary does not issue instructions to a judge and says, please do this and don't do that. And it's all within a formal framework, is to convey information from our office, to send out a document for their attention, to inform them of the role or inform them of something that's happening next term, or it can be a memorial that's arranged. She notifies them that this is the time, this is the date, etc. So, Honourable Commissioners, there is no need for concern in terms of the manner in which my registrar communicates with the judges. Most of the communication is actually quite clinical and just informative, and to inform them of a situation as to when something's happening, or if there's a visit, a delegation that may come out, allocation of next term's motion court role. It's information that is being conveyed. No judge needs to respond to anything that my secretary forwards to them because it's clinical information. With regard to
just
yes,
a bit of clarity, does this secretary communicate directly with the judges or with the judges' secretaries so that they can inform their principals?
That's correct.
How does it work?
The email goes to the judges' secretaries.
Not to the judges?
No. Some of the emails is for the judges and the secretaries are included. Say it's the motion court roll. And then she will say, dear honourable judges, enclosed herewith, please find motion court roll for next term. That is how it's done. Chief Justice, there's a reason for that because our computers intermittently goes off, and at least if we send it to both, we know someone is going to get it. But that is just a clinical role that's going out, Chief Justice. There are no instructions involved. It's just clinical information, or there's a memorial service, then it will go out to the registrars as well as the judges. That is the way it is done.
I must say, though, that I find that practice quite unusual. Well, speaking for myself, I've not encountered it in my 24 years on the bench, that a colleague communicates with me via the secretary. A secretary will communicate with the secretary, then my secretary will communicate with me. If the colleague is too busy, communicate with me herself or himself.
Yeah. Chief Justice, as the acting, as the DJP in the division, that is how it is done in our division. If it's clinical information, it goes to the registrar, only if it impacts on the registrar only. Remember, our system, computer systems are off intermittently, and it happened quite often where the judges are not aware of something that is happening. And it's some time ago that the decision was made to include the registrars also in those communications because the system is intermittently off. And the judges accepted that. It wasn't a problem. But it's all clinical information. So if there's a memorial service, the email would go to the registrars. The registrars must know, because some of them attend a memorial service, and the judges would be told, this is the time you must be there, etc., etc. So that is the way it's been done. I didn't change any way of communicating the way the former judge president did it. I didn't do that, and we had lots of technical issues in the building, and it was later accepted that information must rather be disseminated two ways, that the judge and the registrar. Some issues only impact on secretaries. In those instances, the judges are not included unnecessarily. So what I did is I just followed through with the way things have always been done in the division. I didn't change anything, Chief Justice and Commissioners. With regard to the two cases mentioned, I have been interrogated about
Just before you carry on, there's a follow-up question on the last aspect from JP Mlambo.
Good morning, Acting Judge President.
Good morning, JP.
I just want to refer you, because this communication, judge to judge or judge secretary to judges, is a serious issue in the judiciary, as the CJ put it to you.
Yes.
One of the annexures to your PEC, sorry, I'm using case lines, it's page 41, 45, is an email from your secretary. Well, I take it as from your secretary. But it's signed AJP at the bottom, but it clearly comes from Elmar Sivers. I don't know if you want to look at it. Because
no,
I want to know,
no.
because
Yes.
it's headed, dear colleagues.
Yes.
Now, a secretary can't say dear colleagues to judges. But this email is sent to judges. It's got AJP at the bottom. I need to get clarity.
Yes.
Who sent this email?
Chief Justice, if it says AJP, it means I stood next to her and I dictated it to her. It comes from me. And then at the bottom, it will show that she is my secretary. Perhaps with hindsight, I should have had my own stamp at the bottom. Yes.
I don't think it's a question of having your own stamp, because when I receive emails like this from a secretary, even if it's got the judge's name at the bottom, I will respond to the secretary to say, tell your judge to speak to me. Because this is an email from your secretary. My question is, why is it not an email from yourself?
JP, I understand the issue that you are raising. When I assumed my position as DJP, the former JP's registrar would also put her name in at the bottom. And I was trained that there's an understanding that any correspondence that comes from my registrar comes with my instructions. And that is something that the former JP always instilled in the judges. But the point is duly noted. It says, dear colleagues, it means that I have dictated it to her, and I typed my name at the bottom, and then at the bottom, the secretary's stamp would be there. So what I did, I changed that where my secretary, when my secretary types matters now, she would say that she's sending an email on behalf of my office. What I can say about the fact that my secretary sends out the email, that happened in the former JP's office also. His registrar would circulate an email, no matter what it was, whether it was the role.
We are not particularly concerned with what happened before your time, AJP. So I would be happier if you just limited yourself to what you've done in that division and plan to do for that division, if there's anything to be done.
So if I can just conclude that point, when it says AJP, it means it comes from me, and then her stamp is just at the bottom as my registrar. Yes.
Minister?
Anything?
Oh, sorry, AJP, I should have warned you. There's another follow-up question.
I'm sorry, Judge Collegiality. Good morning, Commissioners. Good morning. How are you?
I'm very well, thank you.
Just a follow-up on that. In the Judge Ali's complaint, she also raises the matter of the Secretary communicating directly with the judges. And she actually says she has raised the matter online in response to the PA, who had not indicated that she was acting on your instruction. It's actually paragraph 6.12. She says, I then took the matter with the email in response, and the secretary then resent the email with the words on the instruction of the AJP. I think the way the communication, and earlier on you said you are strong in communication, this indicates a weakness in communication with your colleagues. Would you agree with me if I say so? And futuristically, how do you hope to improve on the communication with your colleagues? I wouldn't want to assume that you are too busy to send a 3-line email to your colleagues and just informing them about the unopposed motion role for the following term. And then you attach it and it goes.
Yes. That is exactly, thank you,
Could I also
Commissioner.
just follow up, Chief Justice?
Yes.
Because it's also on this paragraph 6.12.
All right.
Yes, there's another problem, AJP, which is not just communication, because I understand your point to be, if it's formal communication, there's no problem. It can be sent by anyone attaching a role, etc. Now, I understand that fully. I don't have a problem with it. But it looks like it's more than formal communication. It's actually a substantive judicial work that is being conveyed through the secretary. I think that's really the concern. So the example that is made here at 6.11 is that your secretary has taken files to Judge Ali. And then Judge Ali says to her, no, I already have a file. And then she says to her, well, why don't you do this one virtually? And she does so without even discussing with you. So I think it goes beyond, this is just formal communication, into its substantive judicial instructions that are conveyed through the secretary. So the secretary's role is elevated, which is perceived to be offensive by your colleagues. That's really the heart of what you must respond to.
Thank you, Commissioner. Commissioners, that specific incident that is referred to, my registrar does not give the judges any instructions. My registrar, because we have a shortage of ushers, so my registrar doubles up as an usher. Remember, there are 33 judges and only 16 ushers in the building. And if the criminal trials run, then the ushers are occupied in the criminal courts, and then we don't have ushers to deliver files. Commissioners, that specific incident that is referred to was not any instruction given to any judge. It was just the delivery of a file. And when I saw that comment, I questioned my registrar about it, because my registrar is quite experienced and she's very, she understands protocol very well. She was nothing more than an usher on that specific day. And it happened to be on a Friday when that happened. Opposed motions, allocations were made the Friday for the Monday. And Judge Ali received the file from my registrar. My registrar never gives instructions to any judges. That was pure and simple ushering duties. My registrar has no interest whether a judge does a case virtually or in court. And my registrar personally had no knowledge of doing that, because she multitasks as my registrar, thank you, and as an usher. It was purely ushering duties. With regard to the signing of correspondence, I can understand that someone may have an issue, but if she signs it, it's formal, it's a roll that's being circulated, or it's the reserve judgment roll that gets circulated, the registrar signs that. Some correspondence would be from me, whether I circulate the information for comment, that can also come from me, or it will say AJP with her name as my secretary at the bottom, but it will clearly say it comes from me. Formal correspondence can come directly from my secretary, but I'd like to reassure the Commission that I do put AJP under correspondence that I have dictated personally to the judges, quite often. So if I can just clarify the point with regard to my registrar telling a judge do it virtually. Commissioners, that is not the case. My registrar would not even open that file to see the mode of the trial. It was a simple case where a file was allocated with the name of the judge on, and she was just performing ushering duties, nothing more, nothing less, and she still performs ushering duties if the ushers are not available to go and deliver files. So I think that act of hers is taken out of context because she does not know the modalities and she cannot dictate to any judge how to conduct a hearing. And hence, I do dispute that allegation that my registrar attempted to tell someone how to hear a matter. That is not the case. It was a simple delivery of a file.
Yes, but she says that she never got any communication from you, which left her uncertain about whether, in fact, this had come from you or it had come from your secretary.
Commissioner, the judge won't receive communication from me with allocations. They get the file 2 days before the time. Their names are put on the file and it gets entered into the register. So I don't communicate with the judge and say, I'm sending this matter to you today, I'm sending that matter to you tomorrow. Our system works like this. We allocate in advance, depending on availability. The ushers collect the files that's been allocated with the names of the judges on, and they manage, the ushers will deliver the files. You don't email every judge every day to say, here's this matter, there's this matter. That is not how the system works. So they can receive a file today for a matter to be heard 2 weeks from now. And if there's not an usher to deliver it, my secretary will go and deliver the file on behalf of my office.
Sorry.
Is there anything else?
Commissioner Baloy? Still follow-up questions, AJP?
Yes. Thank you, Chief Justice. Good morning, Judge.
Good morning.
It's a slightly different angle, but to this topic still. The Chief Justice asked you more than once what it is that you would still do in the division by way of improvements and new things, and you were asked more than once. And in your responses, you were referring to what you have done. Now, I would have thought that a letter, this submission from Judge Ali, for example, would give you an opportunity to reflect on what you would need to do if you are appointed Judge President, because clearly, according to her, there are issues. that need to be resolved. But instead of you saying or acknowledging this, you have taken a stance that what she's saying, there's no merit to what she's saying, and your attitude is that's the end of the matter. I'm quite disappointed, I must say, by the tone and the manner of your response to this, but perhaps more seriously, by your registrar's response, where she speaks about a judge to say her statements are deplorable, that kind of language, and that you would include this without moderating it. You would include it to be put before this panel about a judge that you're going to go back to work with, and if you are appointed to the position, lead and hopefully, at least as far as we hope, have a collegial relationship with her, that you would allow, firstly, without moderating, that your registrar would speak in these terms. I'm particularly concerned about that. Because I perceive of a role of a judge president as being the moderator among equals and among staff. And so, expected that you would tell her to tone down her language, address the complaints or the issues that are being raised without speaking in this way. To me, it seems, it appears to be as absolute disrespect, and you don't seem to have noted it, that your registrar should never speak like that to any judge whatsoever, in fact, not even to her colleagues. But I'm also particularly disappointed that when you respond to Judge Ali, you come out as more defensive than acknowledging this is an indicator of issues that require addressing. The minute issue. It doesn't help to keep saying, we stopped taking minutes 10 years ago. Clearly, there's a judge now who thinks we should keep minutes. And I would expect a leader to say that clearly means there's an issue to be addressed, and I would go back and address it. Do you have any comments to that? It is concerns that I have, and they seem to me to speak perhaps to a failing of leadership.
Commissioner, I did respond to Judge Ali's concerns. It is so that she has raised issues, and I have responded to it. And if I can refer to the issues regarding minutes, I am keeping a record of what happens at the meetings. I must agree that perhaps the tone of my secretary's response could have been better. My secretary just felt aggrieved that a specific judge said that she mustn't deal directly with her, but I will concede that the tone should have been better. The issues raised by Judge Ali, I indicated to the Commission that I'm happy to respond to all of it. With regard to my registrar responding to judges, obviously that is a lesson to be learned, to the extent that my name should then rather just be typed. She mustn't just put AJP at the bottom and then her name underneath as my secretary, her stamp. It's actually a stamp. It should possibly, preferably have been my stamp. Some of the concerns raised by Judge Ali, Commissioner, I have responded to it. I don't necessarily regard it as being defensive. I will concede, I've given an explanation as to how my office functions. With regard to minutes, that is something that can be raised at a judge's meeting. Quite frankly, Judge Ali could have raised it with me earlier. All the issues she has raised there could have been raised with me earlier.
Yes, I accept, Judge.
Yes.
AJP, I accept that she could have raised the issues earlier, but they have been raised in this way.
Yes.
And what I'm putting to you is your response in the manner in which she has raised them seems to indicate a failing in a leader responding to matters raised in the wrong way, maybe. But that the instinct of a leader should be, it seems to me, to accept that indicates there's a problem that does need to be dealt with differently. But I do understand your answer. Thank you.
Yes, thank you,
Thank you,
Commissioner.
Chief Justice.
I feel that most of the issues raised could have been dealt with directly. I have responded to the issue of minutes that I do record. I've responded to the distinction between expedited dates and semi-urgent dates. I have responded to the fact that my secretary communicates on clinical issues with the judges, and sometimes the emails would go directly to the registrars, depending on what it is. Commissioners, with regard to issues raised by Ali, I did not, my intention was to respond to the issue, not necessarily to defend myself, because if there's a difference between an expedited date and a semi-urgent and an urgent date, I felt that I needed to clarify. So in that respect, I considered my response to be more clarification, because Judge Ali is not aware of all the processes that happens in my office. I have noted the comments, and obviously I have spoken to my secretary about that in terms of remedying a concern raised by one judge in the division in terms of the manner the communication gets circulated. And I just followed up on the way it has always been done through the registrar. We send clinical emails, but yes, I am alive to the fact that some judges may then take offense, and Judge Ali then expressed that she took offense to that. Is there anything else I just needed to respond to?
Wait, there's
Yes.
still more follow-up questions, AGP. Commissioner Pillay?
Thank you, Chief.
No, there are two follow-up questions before you, Commissioner Malema. I've noted you.
Thank you, Chief Justice. Good morning, AJP Goliath. I just wanted to follow up on the answer to the question posed by Commissioner Mukaitobi around the specific incident referred to by Judge Ali in her document, the one relating to the allocation of files.
Yes.
And a comment made by your
Yes.
by your secretary. Did I understand your answer to be that that's an untruth by Judge Ali?
I have raised it with my secretary, but the secretary indicated to me that she was merely delivering the file because, look, that was the instruction. She acts as an usher. And the secretary indicated that she did not instruct the judge how to hear the matter. Commissioner, the secretaries cannot dictate to a judge how to hear a matter. So obviously my secretary indicated that that was not what she had said. The file was marked and she acted as an usher, and it happens on a daily basis that my secretary delivers files to judges.
AJP, the thrust of my question is what you're saying to the commission that Judge Ali, in her comment to the commission, included a fabrication or an untruth.
I'm saying to the commissioner that I addressed that issue with my registrar, and she indicated to me that she did not indicate to the judge how to hear a matter. She was merely performing duties of an usher.
And did you have a similar discussion with Judge Ali?
No, I did not have that discussion with Judge Ali. I just instructed my registrar and indicated to her that it may be best that we rather just wait for an usher to deliver it, because it was taken, this incident had happened. Commissioners, my secretary is there for many years and she knows protocols. She will not instruct a judge.
AJP, I'm
Yes.
sorry to interrupt you. I really don't want to have a discussion about
Yes.
your secretary. I'm more concerned about what you're saying about one of the judges in your division. That's my concern. And can I just finish my question
Yes.
before you answer? You see, it ties into something you said much earlier in your exchange with the CJ. You urged us, in your words, to treat Judge Ali's comments with caution. Now, that's a very serious thing to ask the JSC to do, in particular when you're talking about a sitting judge. Now, you also, in your written responses, tie that in to Judge Ali's membership of NADAL, which is even more concerning. Now, can I ask you to please address that question? Firstly, how it is that you can ask this body to treat the comments by a sitting judge with caution. And secondly, how it is that you tie that into her membership of NADAL.
Commissioners, I have given an indication that Judge Ali and I, we were together, we were candidates for the position of Deputy Judge President. And since my appointment, it is so that Judge Ali did not communicate with me at all. It is so that at that stage, NADAL did mobilize support for Judge Ali, and she wasn't appointed. So from that vantage point, although Judge Ali stated in her submissions that she is raising this because she's got nothing to lose and she's due to retire, etc., I had a concern about the fact that it appeared as if the fact that we were up against one another, that it may have impacted negatively on our relationship, and that Judge Ali, she raised certain issues, concerns that I felt I could explain adequately to the JS in terms of the manner in which I run the office. But my main concern was, why did Judge Ali not address it directly with me? That was my concern, because Judge Ali chose to use this platform, and that was where the caution request came in, because it was something she could have raised easily with me, to take a walk up to my office, and we could have resolved any of her concerns. And that it's in that context that I asked the Commission to just be cautious, because why didn't someone do the obvious? But I understand the concern raised with regard to the fact that I now need to decide, am I believing what my registrar says and Judge Ali says? Obviously, if I can just conclude the earlier point, I must believe what a judge says. If a judge says something happened, I must believe the judge. And I did raise it with my registrar, and my registrar said, but Judge, I was just performing ushering duties.
You mentioned that, AJP.
Yes.
And can you please address the insinuation that NADAL is using Judge Ali as an instrument against you?
Commissioners, look, NADAL issued a media statement in May where they requested individuals and organizations to collaborate with them to support a candidate. And that happened. That is the reality of the matter. Judge Ali is affiliated to NADAL. They nominated her at the time. NADAL did seek collaboration from stakeholders and from individuals. It was a public document, and I didn't, for me it was unambiguous to the extent that NADAL was seeking collaboration. And Judge Ali was a long-standing member of NADAL, and NADAL did nominate her for the position of DJP in that round when I was successful. I'm not saying that NADAL is using Judge Ali for a specific purpose. I'm saying NADAL publicly did invite people to support their cause and to collaborate with them. And just the mere fact of Judge Ali's connection with NADAL, it's not an arm's length person who had no ties with NADAL at all. After all, they did nominate her. For me, it's just a factual situation. The invitation went out, and that is the ultimate strategy that NADAL called for, and people did, and they invited people to come in. Judge Ali has never been to my chamber since I was appointed as the DJP, so I would imagine that there could be a little bit of, there could be issues that she may have. Since my appointment in 2016, she's never been to my chambers.
AJP basis.
Sorry, Commissioner Pillay, in case I forget, I'm at that age. Just on this, on this last point, have you ever been to Judge Ali's chambers?
Yes.
As her leader?
Yes, I have been to Judge Ali's chambers.
All right.
Yes.
That pacifies me.
Sorry,
Carry
just
on,
the last
Commissioner.
follow-up, AJP, on the question of Nadal. Do you believe, AJP, that every person who is a member of Nadal will be biased against you?
No, definitely not. The position with Judge Ali is just, the connection is just that they nominated her as deputy and I was in the successful candidate. That's the only connection I can make. I cannot have a blanket approach and say everyone. I was also a member of Nadal. So I most certainly cannot have a blanket approach and adopt that situation. Judge Ali's position is just unique in that we were up together for the position of DJP. She has raised certain issues that she could have raised with me directly, some valid, some not so valid. I have responded to it. I've noted the Commissioner's stance that says that as a leader, I must say, how am I going to fix it? Yes, I am quite willing to fix whatever needs to be fixed, but my responses that I gave was an explanation as to how my office functions. And that is why I said if the commissioners ask me on a specific aspect raised by Judge Ali, I am happy to respond thereto. So the situation with Judge Ali is just different because we were up against each other for deputy. And that makes, for me, that makes her situation unique. That is all. Nothing more than that. And I most certainly cannot have a blanket approach to all members of Nadal. Definitely not.
Sorry, Chief Justice, sorry, I know we haven't even gotten to a response to my second question, but I really need to address this because, AJP, you're not taking this commission into your confidence.
Yeah.
The issue with Nadal is not relating to what happened when you applied both for the DJP.
No.
In fact, you've asked that one of the other commissioners recuse himself because of
Yes.
his membership or his affiliation
Yes,
with
I
Nadal
did.
because a competitor
Yeah.
to this role
Yeah.
is, I suppose, affiliated with Nadal or is their chosen or supported candidate.
Yes. Yes.
It's not about what happened in the past and
Yes.
Judge Ali has an axe to grind because she was unsuccessful. The insinuation is that you are using her, or they used her, to ensure that their preferred candidate in this process gets the nod and you don't. Which is essentially accusing Judge Ali of being part of a conspiracy, along with fellow commissioners. That is a very, very serious accusation, and it's not to do with grudges in the past. You are accusing people of essentially something that verges on criminality.
CJ, may I please
Yes.
follow up on that with your permission?
Yes, Commissioner Pillay.
Yes. While you deal with that, AJP Goliath, could you please also deal, and in similar vein, we've had an issue where you've expressed concern about the ability to remain unbiased and neutral of a senior judge of your court that was supposed to sit here who participated in the shortlisting, and you demanded, rather in fact you instructed that he recuse himself, you recused him, and you appointed somebody else to come and stand in your place as your designate. Now, the reason you gave for that is exactly the same as the basis on which you were seeking the one commissioner's recusal. It is because of their familiarity to your competitor, and so you do not trust that the judge will fairly, openly, and objectively exercise their duties and discharge their responsibility in evaluating you fairly. So could you please, while you respond to the Nadal issue, deal with that as well?
Commissioner, Judge Ali mentioned in her submissions that she has no agendas. She mentioned that herself. And when I saw that, I thought, well, why is Judge Ali saying this? It's not necessary to say this if you don't have an agenda. And the connection with Judge Ali, the fact is that Nadal, she is a member of Nadal and they did nominate her previously. I am not saying that
She was.
Judge Ali,
She can't be a member of
yeah, she
Nadel
was.
whilst the judge, yeah.
Yeah, she was, just like I was. I was also a
Me
member
too,
of Nadel.
and many of us
Yes, many of
on
us.
the bench.
Judge Ali triggered this concern by me because she said herself, I don't have ulterior motives. I've got nothing to lose. That's what she said herself. And I looked at it and I thought, but why is she saying this? If it's all above board, she triggered that concern by me. And the Nadal sent a circular around and made it clear that they support a certain candidate. There's no problem with that. The only problem I had with the circular was the fact that it created the impression that the Western Cape Division was in disarray. And I felt that that was not the correct statement to make. If that was not in the statement, I would not have had any concerns. The fact, because that is not the correct statement. It was not about supporting another candidate, whatever. The division is not in disarray. And I can assure the commissioners of that. I just need to respond to if anyone...
No, I need to make a follow-up,
Yes,
CJ.
yeah, sure.
There still is another follow-up before you, Commissioner Malema, on this very issue from President Mulemela. Or had you finished, Commissioner Pillay, because we kept interjecting?
Chief Justice, there's just so much to deal with. I'll keep
All
my-
right, thank you.
my question.
And you satisfied, Mr. Boshoff?
Yes, thank you, Chief
All right.
Justice.
President Mulemela?
I wanted to remind CJ that we spent 2 hours on this candidate. 2 hours.
I am fully aware, Commissioner William. Thank you.
Thank you very much, CJ. My follow-up. Am I audible?
Yes, we can hear you.
Okay, thank you. Yes, good morning.
Good morning,
My
Commissioner.
sister, how are you?
I'm very well, thank you.
Just to put on record that you and I have interacted frequently in relation to me requesting you to release some of your colleagues for purposes of acting at the SCA, and that has worked well.
Thank you.
Yes. My follow-up pertains to the issue of the taking of minutes. You indicated that you were a scribe in 2010, and then there was a resolution that minutes should no longer be taken. And then you took over as the AJP, and then you started making notes or recording notes for purposes of an action plan. My question to you is, well, the CJ also asked you whether there's any room for improvement that you see. And my question is whether you do not regard the issues that have been raised by Judge Ali as an indication of the need to keep proper records in accordance with standard meeting procedures and to circulate these records, especially because you indicated that not all the judges can attend meetings at all the time, meaning that if these minutes are circulated, then even the judges that did not attend the meetings would then be kept abreast of the discussions of that meeting. I pose this in relation to one of your responses to the CJ, where you said that it is evident that Judge Ali is not aware of some of the processes that you have put in place. And I mean, discussions that are had at judges' meetings, if they are recorded, even if she did not attend a particular meeting, she would know that this was discussed and this is how it is being attended to. So with the benefit of hindsight, would you concede then that the area in relation to the keeping of minutes is one area in which there could be an improvement on your side going forward? Thank you.
Thank you very much for that question. Most certainly, I agree that we can do better in that regard. Commissioners, my first meeting that I held with the judges, where I asked the judges to have the conversation, I did minute that meeting because I wanted to record exactly what it's our first meeting after 6 years, and I did circulate the minutes, and the minutes ended up outside of the building and with the secretaries. The court manager came to me and said certain things were said about her in the minutes. Minutes were circulated, and then a senior judge came to me and reminded me that there is a resolution that no minutes will be taken. So from the second meeting onwards, I only made notes in respect of an action plan. So, Commissioners, I agree with what President Malamela has indicated. We can most certainly improve on that, and it is something that will have to be discussed at the judges' meeting so that we can take a definite resolution as to how we will be going forward since there is a resolution still in place not to keep minutes. And the fact that I'm keeping an action log and actioning things and dealing with the different committees, etc., may not be enough. It would probably be advisable to have some other system in place with the concurrence of the judges, since that resolution still stands.
Thank you, AJP. But before you get to the second part of Mr. Boshov's
Yes.
question concerning the SCA's comments on your judgment, I just want to remind Commissioner Malema and the other commissioners that this is a critical leadership position in a notoriously troubled division of the High Court in this country. So I cannot stop commissioners from asking questions about concerns relating to serious matters that they may have. So if we have to take longer with a candidate, then that's just what we must do, so that at the end of the day, we know that we have chosen the right person to lead that court. So that's why we're taking so long, Commissioner Malema. Back to you, AJP. Are you ready to?
No, my follow-up.
Yes.
Oh, you had a follow-up?
Yes.
I thought you just wanted to remind me about the time.
This is why.
Ask your follow-up then, Commissioner Malema.
No, I want to just make a follow-up on 2 points quickly, AJP. The Advocate Baloyi, Commissioner Baloyi, raised an issue with you about how your secretary responded to a judge. And you said, that is not the right way to communicate, but she was angry or upset that they accused her of whatever they did. Before Commissioner Baloyi put that to you, as a leader of the court who read what she said in response to Judge Ali, did you take it upon yourself to say, but you cannot address a judge like this to your secretary? Did you say that to her?
I did not say that to her, and I think I should probably have done better in that regard. But she indicated that she wanted to make her own statement. But I think I should have done better to intervene there.
And you see, that is lack of judgment from a leader. Because a good leader would have picked that up and immediately deal with it. Do you accept that that is lack of judgment from leadership position?
I should definitely have asked her to tone down her response, Commissioner. Yes.
So, AJP, you are not in the meeting where it is alleged she was instructing a judge to conduct the matter in a particular way. And Judge Ali makes that allegation, and she denies that. And then you come to justify before us that she's senior, she will not have made such a mistake, she knows how the things work, and that we should, without you saying it, but by how you're saying it, we should believe her over your colleague, over a judge, and you have not spoken to that judge. You have just spoken to one person, who's your secretary, did not speak to the judge to verify the facts and whatever the situation might be. But your justification here is that, no, she's so senior, so experienced, she will not make such a mistake. She will never give a judge an instruction when a judge says, I was given an instruction. And we must believe her over a judge of your court, AJP.
Commissioner, the fact of the matter is that it is a problem for me to say, don't believe the judge. I'm not saying that here today. I am saying that my registrar is used to delivering files and playing the role of an usher since I'm a DGP since 2016 already. And she is alive to the fact that it is just a delivery. And if that had happened, it is unfortunate, and I cannot say today, believe my registrar, Commissioner, I can't say that. I must accept what the judge says. I just try to impress upon the Commission that the delivery of files is within the normal course of my registrar's duty. And that's the sole purpose, is just delivery of a file, not to engage judges on the matter. And quite frankly, it gets placed in a basket. Let me just clarify that to the commissioners. It doesn't, you don't knock on the door of the chambers, it gets placed in a tray by the judges' chambers. Yeah, that is how deliveries are made. The usher will do that, place it in the in tray, and then there's the out tray. The usher will collect the files. So the delivery of the file, she wasn't sent as a messenger to the judge concerned. She was merely sent to place it in the tray, in the in tray. That is all.
Sorry,
Yes.
sorry, can I? All right.
There are we still have other follow-up questions. Sorry, questions, Mr. Notyesi. Commissioner Mwimang?
Okay. Thank
you, Commissioner Williams.
Thank you, CJ. Good morning, AJP.
Good morning.
Just want to make a follow-up on the correlation that was drawn by Commissioner Baloyi on the designation of alternative on Judge Erasmus.
Yes.
And Judge Ali. On the question that was raised by the CJ around what is it that could be done to improve the stability on the division, the question that I want to ask is, don't you think that your approach on Judge Ali and also on Judge Erasmus is devoid on the quest to create stability in the division? Because definitely the insinuation that one is drawing is that your stance on withdrawing Judge Erasmus midway through the process also creates a bit of a leadership discord on how you manage the issues of court. Don't you think you should have handled the matter differently? Because now you can imagine the relationship between Judge Campbell and Judge Erasmus, I suspect, is something that you need to work on to stabilize it. Thank you.
If I can just conclude with regard to the issue of Judge Ali. I'm sitting here with a list of the stuff that she has raised now. She referred to the allocation of duty for unopposed motion role. She had a concern that when judges are involved in criminal matters, they shouldn't be taken out of crime because there's a continuous role. I have responded to that to explain to the Commission that the continuous role will be disrupted because of criminal matters, where we have 80% of the judges in crime. The allocation of the duty of the unopposed motion role is done in an equitable manner because it involves weekend duty, and it so happens that some judges were allocated to this allocation of duty in the unopposed motion role 2-3 times per term, which translates into working 2-3 weekends per term. So I have responded to that to explain that I adopted an equitable system of allocating the unopposed duty role to all judges. If they are in crime, they sit out for 4 days out of the crime during that week that they are allocated the unopposed motion role. It's an equitable system, it's a transparent system, and the majority of the judges were happy with the way I did the allocation of duty for the unopposed role. Judge Ali raised the issue of expedited dates. I have explained to the Commission that there's no list of criteria for the allocation of expedited dates. I've been doing that since I was the DJP, and that Judge Ali is confusing expedited dates with urgent and semi-urgent matters. Expedited dates are granted in a transparent manner. Both legal, all the legal representatives must apply together for an expedited date. Based on the merits of the case, it will be approved. From there, it goes to the 4th Division clerk, who will then find an earlier slot for the parties in that matter. So I've responded to that. Designation of judges as junior and senior. It is so, when we allocate full bench appeals, we try to allocate one senior judge in the higher hierarchy, and then a mid judge with middle, less experience, and then we also put what we would call a junior judge, a 3-bench judge, so that the junior judge can then gain that experience by getting exposure to different judges. So that is basically the only reference where one would talk about junior and senior. But in any event, I have responded here, and I said that allocations are done privately, and there's no discussion around junior or senior when allocations are made. Judge Ali raised the question of questionable statistics and performance tools. The stats is completely out of my hands. I have no interest in the stats. It is done by the statistician using objective criteria when the stats are computed. Failure to circulate timeously. I've responded. I've indicated that the resolutions were indeed circulated. The phase 1 was not under my leadership. The rationalization report was circulated, and the meeting that Judge Ali referred to in her papers was in fact a meeting where I went to convey to them, the judges, what issues that were raised in heads of court. Concerns that my secretary is allowed to communicate directly with judges.
No,
I've noted that. I've noted the concerns raised with that. It is so that my secretary does send out correspondence and communicates with the judges and the registrars. I have duly noted that point that was taken. No records of decision taken at meeting. I have noted that point as well, and I think based on the question of President Molamela, there is definitely room to improve. The judges need to make that decision, because I've explained when I circulated the minutes of the first meeting, it was a problem, and I was reminded of this resolution. So that is something that the judges will have to work with. With regard to my registrar's response, I concede that I should have intervened, and perhaps she should have toned down her response. Before I get to, I don't know, Chief Justice, I'm in your hands. Do you need me to respond?
There was the issue raised by Commissioner Baloyi and fortified by Mr. Boshoff about your withdrawal of your colleague's designation, Judge Erasmus, and then your demand for one of the commissioners to recuse themselves because they are a member of NADEL.
Yes. It is correct that I did demand one of the commissioners who holds an office in NADEL to recuse himself. It is so that the test for recusal is objective, and whether a reasonable, objective and informed person would, on all the facts, reasonably apprehend that someone will not be able to bring an impartial mind in the matter and in the assessment of candidates, or that that person wouldn't be open to persuasion. It was purely done on that basis, to ask the president of NADEL to recuse himself. Nothing more, nothing less. I try to, although I'm subjective, I try to put myself in the shoes of an objective person, and I felt a sense of anxiety, and it was my view that even looking from the outside in, if the president of NADEL sits here having circulated the memorandum, it creates the impression that his mind was made up and that you would not be open to persuasion. It was purely on that basis that I made that request. Had that memorandum not been, the media statement not been made, I would not have asked for his recusal. But the main reason for the recusal is not the support of a different candidate. The main reason for the recusal is the fact that an incorrect statement was made in the media statement that the division is in disarray, and the division is not in disarray. The waters are calm, the ship is sailing. It's not perfect, but it's much, much better from where it has been. So that recusal must be viewed in that light. It was a public document, it was circulated, and I attempted to apply that objective test, and I did say to myself, but if someone already belongs to this organization and it's already indicated this is the preferred candidate, I felt that perhaps it would be best if that person is not party to, sits on the commission, because I had concerns whether that person would be able to apply his mind going forward, to apply, would be open to persuasion, because a decision was made before any interviews or anything. Would that cover that?
Your withdrawal of Judge Erasmus's
Yes.
designation
Yes.
to this body?
Yes. The commissioners, the shortlisting process occurred in this manner. I was instructed by the Chief Justice to let Judge Erasmus attend to the shortlisting.
Which Chief Justice?
Chief Justice Zondo, former Chief Justice Zondo, indicated that Judge Erasmus must do the shortlisting. We are in a unique situation because I'm also a candidate. So the former Chief Justice then recommended that Judge Erasmus must attend to the shortlisting, and I abided by that decision.
Follow up, CJ, on this point. Because
No,
I think
let her finish. She's still talking.
Yes, yes. I received a call from the JSC instructing me to let Judge Erasmus attend to the shortlisting commissioners. I received that phone call. And then Judge Erasmus attended to the shortlisting. I abided. And if I can go further, then the shortlisting did take place. And then, when I saw the shortlist, I just saw someone's name on the list that has a very close relationship with Judge Erasmus. And at that stage, I didn't make any designation yet when the shortlist came out. So that was my concern, where he was concerned. It's just the fact that he's got a friend, it's a friend of his. And that was my only concern with Judge Erasmus. I thought he may be conflicted with one of his friends being shortlisted. Nothing more, nothing less. So firstly, I didn't designate him to do the shortlisting. That was on the instruction of former Chief Justice Zondo. After the shortlisting, I had a conversation with Judge Erasmus. I said to him, look, your friend is on this list. I have concerns about that. So I will not be able to designate you to attend to the JSC today. He did try to persuade me to say, no, he will be able to apply an impartial mind, but I thought, I have a concern because I know personally that is his friend on the list. And then I did my designation on the 8th of August. I designated Judge Gamble. After considering my options, I designated Judge Gamble, and that was the only designation I made. The Chief Justice designated Judge Erasmus. I did consider designating Judge Erasmus, but when the shortlist came out, I then designated Judge Gamble instead. So from where I sit, I didn't change any designation at all. I just applied my mind in terms of Section 178K after the shortlisting to designate a judge. And my motivation was to designate a judge that has no close ties with any of the candidates. None of us are friends with this particular judge, and we don't have lunch, we don't have breakfast, nothing with this particular judge. I'm not particularly close to the judge. The judge that I designated is due to retire on the 10th of November, and that judge holds no allegiance to any one of the candidates at all. So if I can then just...
Look,
Chief Justice.
before you move on,
Yes.
AGP, I just want to understand why Judge Erasmus's close connection with any of the candidates would have bothered you, because you've been a judge long enough. We all know that since the beginning of time, since this body started operating, commissioners, including the chairperson on occasion, have declared openly that they have a relationship with one of the candidates, and it's never been an issue. I recall an example where former Chief Justice Mogoeng interviewed his close friend, former Chief Justice Zondo, and he made that declaration openly before the interview started, and it was not an issue, and a fair result was achieved.
Yes.
I'd like to think. So why were you particularly bothered by Judge Erasmus's involvement in these proceedings?
Yeah, Chief Justice, look, I'm 34 years in the profession, and yes, I was concerned about that. It may not be, based on what you have informed me now, it may not have been the correct approach not to designate him, but at that stage, after the shortlisting, I had a choice as to who I would like to designate. And the Chief Justice Zondo designated him to do the shortlisting. And I exercised my discretion in terms of who I wanted to designate to represent the division. Yes, it was a concern, and I've heard what the Chief Justice had said. I just felt uncomfortable with the fact that one of the candidates was very close to him, and I've noted what the Chief Justice said. But the Commission must remember that was I, and I'm trying to understand this, is the suggestion that because the Chief Justice designated one judge that I had to stick to that judge? Because if that is the case, then I understand what the concern is about. But I thought I was just exercising my constitutional right to take someone who's not connected to anyone and who's due to retire and who can sit here objectively and represent the division.
Quick
No,
one,
what
CJ.
was odd, Commissioner Balema, there are other follow-up questions before.
I wanted to follow what you just asked earlier.
Okay.
I wanted to ask, are you aware of the incident that the CJ is talking about? As a judge, you have been on the bench for quite some time. You will be familiar with what she spoke about. And when you had those concerns would have now been put at ease by that experience, yes, which we are speaking about. AJP, you are not going to give us the second reason because you build reason as you go. Your initial and your honest reason is that Erasmus is a friend with a candidate. Not that I was exercising my rights.
Yes.
The rights is something that you are now trying to put here now, after giving us an unacceptable explanation. So, do you realize that you were wrong to remove him on the basis of the friendship with another candidate? Because that has never affected this body, and this body is not Erasmus Commission. It's the Judicial Service Commission. There's no Erasmus who's going to take a decision here alone. So whether he's got a preferred candidate or not, this body must still take a final decision as to who's going to be. Do you accept you were wrong by taking such a decision on a fellow judge and say on the basis of a friendship, this judge will never be objective and will not judge me or score me fairly? Do you think you were right by removing a fellow judge on the basis that is a friend with a candidate? Do you accept you're wrong?
I accept that, having listened to what the Chief Justice says, that you can interview a friend, an example made. the fact of the matter is that I have never designated Judge Erasmus in the first place. The Chief Justice designated him. And I was of the view that I could exercise my right to designate an alternate. And I'm hearing what the Honourable Commissioner has said. What the Honourable Commissioner is saying that I should have retained the person who had done the shortlisting. I should have retained that person there. My concern was, am I entitled to appoint a designate or not? Because I was not involved in designating anyone for shortlisting. And I suppose it is desirable to keep the person in, but is it wrong for me to exercise my right to designate an alternate that has no connection with any of the candidates? I thought that I was designating someone that I was satisfied is not connected. I've heard the sentiments that the fact that Erasmus was closely connected to one of the candidates did not justify me not designating him. I heard that statement. And at the time, I just felt that I didn't want him to feel compromised by sitting in on proceedings where one of his close friends were.
Commissioner, Professor...
As for a follow-up, Chief Justice, I'm terribly sorry.
Commissioner Marumakai...
No, but it's just to correct a fact, and I think it's a real problem.
Yes.
So I'm sorry, Professor, you know that I don't...
He's the convener of the Objections Committee, and they've been dealing with this, so he gets first dibs because of that.
Yes, thank you. I've also tried to apologize to the Professor. So the problem, AJP, is that you've now, I think, 4 times said you never made the decision to assign Judge Erasmus to attend to the shortlist. That was done by the Chief Justice.
The Chief Justice instructed me to designate him, yes. Former Chief Justice.
That's now a different spin on it. But the problem is that on the 8th of July, 2024, you wrote to the Secretariat, and your email says, our telephonic conversation refers, please be advised that Judge Erasmus will be attending to the screening and shortlisting of the candidates nominated for the position of Judge President of the Western Cape Division of the High Court. I will be attending to the screening and shortlisting of the 4 vacancies in the division. Kindly confirm the time scheduled for the shortlisting of the 4 vacancies in the Western Cape Division. So whatever was happening in the background, it was your decision to send Judge Erasmus.
Yes, I did send Judge Erasmus. I complied with the directive of the former Chief Justice. I did. And since I was a candidate, that was more reason why I complied. Yes, I did.
Yes, sorry, Chief Justice, it was just to correct the fact that Judge Zondo had nothing to do with it. It was the candidate.
Thank you, Commissioner.
Yes, I accept that I have sent that letter through, and that letter confirmed the designation of Judge Erasmus to attend to the shortlisting. I did.
Commissioner Notice, your hand was up hours ago.
Yeah, no, just, I mean, on this point, you know, I'm saying that with great respect to you, and I highly hold you in high esteem as a judge. By removing Judge Erasmus and seeking for commissioners to recuse themselves, all what you're doing, you were designing your own interview panel. That is it.
I accept
nothing else. All what, I mean, I must put it this simple so that we understand, so that everyone do understand what we're doing. Yeah, the first thing you do, you want commissioners to recuse themselves for flimsy reasons. And you, in the process, you even, I mean, for instance, I hear you say, I circulated a statement. There's simply no such a thing, and you can't say. 2, you designate, I mean, judges to interview you. That's why you interfere in a process where you are directly involved, and you don't just interfere, you actively involve yourself. The whole point is that you just wanted, you have to have your own interview panel. And that was wrong of you, as one of the lack of your judgment as a judge.
Commissioner, the Nadal issue, I have raised that already, and I have accepted the decision that you remain on the panel. I have explained that because of the media statement dated in May, that I felt a sense of uneasiness about it, and you are sitting here now. I have accepted that decision. With regard to the Erasmus issue, I could designate someone. So the main criticism is that because Judge Erasmus...
Sorry, Judge,
yes.
I know you,
yes.
I mean, I don't want to
yes.
you. The point I just spell out, or what I'm putting to you is simple, is that by involving you in this process, designating, removing persons that you have designated, all what you are doing is to appoint your own interview panel. Was that right for you? Should we have even in the first place been involved in this process, especially after you have designated a person? Must you come again and say, oh no, I don't like you, I want somebody else? And even Judge Gamble, in terms of your own, what we call, a hierarchy of judges, she's not even the second, third, or fourth in the row. She is somewhere in the level in terms of your own seniority in that division. You see, you jump several judges, senior judges, and then you point something far away. So you were hand-picking persons.
Judge who is out, on his way out, retirement. He's got no allegiance to any of the candidates. And I considered that to be a better option than someone who is close, very close friends with one of the candidates. I get your point when you say that it could create a negative impression, the fact that I've asked for the recusal of someone who's closely affiliated to Nadal, and the fact that the impression is created that I have intervened in processes insofar as I didn't designate the same person who did the shortlisting.
My point I'm making in this regard is that as a leader of the court shows for the position that we're applying that you lack judgment. You know, you lack judgment, and at times you have impulsive judgments. You just become, he was some years, he was a member of NADEL, therefore cannot be...
you already made that point, Commissioner Malema, and I just want to did I say, oh, did I say, Commissioner Malema? You see, when you're troublesome, that's what happens. Your name is always on my mind. Commissioners, on a serious note, I just, Acting Judge President Gola has answered this question from all angles.
So that the last
do you still insist on asking your questions on this one issue? I'm talking to the others.
No, I'm going. I'm covered. I'm going on this. The last point on my follow-ups. Regarding that statement, what I've picked up, what is striking to me, is that the statement by your secretary containing those, containing those assertions was written on 26th of September. Your own response was written on 26th of September. That is, they were written on the same day. Am I wrong to infer that you were part of the drafting of that statement with your secretary? You actually assisted your secretary, or you drafted with her, because they were done on the same time, and she would have received the comments from yourself. Would I be wrong? So that's the last question.
I have informed her of that comment relating to her. I did. I did not sit with my secretary and assist her to craft a response. Her husband is an advocate, and I think he assisted her with that. I didn't assist her at all with that response. Actually, I just received the response, and I think I should have sort of studied it more, but it wasn't, I didn't write the response,
Commissioner Mangen?
Thank you, Chief Justice. AJP, let's allow you some time to catch some breath. I want to converse with you a different matter.
Now, she still has to answer. She has not
She
concluded.
hasn't, oh,
She hasn't concluded.
okay. Oh, then
Mr.
I can,
Boshoff,
then I can
you-
wait. Then I can wait.
Please. Commissioner Baloyi.
Thank you, Chief Justice. It's a factual correction of fact. AJP, relating to the recusal of Mr. Njesi, you wrote to the JSC on the 18th of September. And the reason you gave is not what you're saying now, that you wanted him to recuse because of the deplorable statement or the statement that was made about your division. Your letter says, Nadel on the 27th of May issued a media statement in which it recorded its national executive had a meeting to call for appointment
Yes.
of a judge to be interviewed with you. And you say the statement was widely circulated. And then in the said circumstances, you say, I submit it would be inappropriate for Mr. Njesi to sit as a commissioner when it conducts interviews and to vote on the appointment. A reasonable, objective, and informed person would, on the above facts, reasonably apprehend that Mr. Njesi will not bring an impartial mind to the interviews and will not be open to persuasion in respect of this appointment. So, and that's really pretty much the end of your letter. So the reason that you provided on the 18th of September is Commissioner Njesi cannot sit through these interviews because he would be biased, or he's got a risk of being biased because they support a candidate. Not what you are giving us now.
Commissioner, the statement, when you look at that letter that you have quoted now, it cannot be looked in isolation. One must examine the statement. The statement called for an alternative candidate because the division is in disarray. And if that is a starting point, that is my main problem. Because an alternative candidate, in my view, the motivation for alternative candidates to say the division is in disarray, that is an incorrect assumption. And someone who's going to sit on this body is going to sit with that preconceived notion that the division is in disarray, and that is why an alternative candidate must be supported, and that is not something I can contest if that is already a preconceived view that someone holds in the appointment of an alternate candidate. So it was more about the content of the statement and the idea that the division is in disarray, which would then justify the appointment of an alternate.
All I was doing, AJP, was to put the reason that you gave us when we decided your objection or your request for recusal. This is the reason you had given us, and that's the reason on which we decided.
That is in order. I accept that because the statement was annexed and the Commission is fully alive to the content of that statement, so I will accept that.
Thank you, CJ.
Now, can we get to the second part of Mr. Boshoff's question?
Yeah. Mr. Boshoff, yes.
Sorry, AJP. CJ, can I just correct the first case I discussed was Pygon trading. I think I said construction, but it's Pygon trading.
That's right, yes. The matter of Pangaka was raised at the previous interview, involved a postponement. Yes, I have erred in that case. I have conceded that I've learned my lesson in that case to the extent that postponements should not easily be granted. I think I've dealt with that matter in a previous interview when I was asked what did I learn. It was a matrimonial dispute, and of course one party was ready and felt the other party was using delaying tactics. And I sat with a colleague and we then were of the view that a postponement should have been granted because the legal representative was had commitments in a higher court, and that was the reason why the one party wasn't represented. So I concede that my colleague and I erred in that judgment. The other judgment, Pygon Construction, I take note of the judgment and the comments that were made in that judgment. Commissioners, I'm 19 years a judge, and my appeal record is very sound. And I'm saying this with regard to concerns raised by the Commissioner with regard to my intellectual capacity to be an example to other judges. I think my record speaks for itself. 19 years as a judge, what is it, 10 matters that's been overturned? It's not that
suppose let me not repeat myself. I've stated that you can't let other factors cloud your decision when it comes to a pure application of the law, because that's what people have to rely on.
Thank you very much, Commissioner. The Commissioner also mentioned about a fraudulent transaction that was also involved in this matter, and that is a fact that I did consider in assisting, rather granting an order for business rescue. So there are lots of issues involved in that matter, and I didn't just look purely on the law, besides the fact that it was COVID, there was fraudulent transaction, there was a fight with the wealth manager. I do understand, and I concede, when you look at it from a legal perspective, I have heard, the Commission heard now that there were also fraud involved.
Wanting to get other judges from recusing themselves and formulating your own panel. I mean, how can you convince me that, and you said you are a communication specialist, that's what you said. But from what I've heard, you lack communication. You lack communication skill. You can't even communicate with your own colleagues. You can't even trust the same JSC that is interviewing me, because you want everybody to recuse themselves. So in their deliberations, how do you expect me to say, this is the person to lead the division? Can you respond to that?
Commissioner, there was only one application for recusal that I made. So from my vantage point, it only involved that the president of Nadal take up a seat here based on that statement, which I have explained. It's the content of the statement that I had concerns about. With regard to the designation itself, I exercised a constitutional power, but I've noted the Commission's concern that I made that change, because the Commission expressed the view that I should have left the person who did the shortlisting to represent the division. I have dealt with that I weighed up a judge who was very close to one of the candidates, vis-a-vis a judge who's on his way out and has no ties, not with me, with none of the candidates. We're not close, we don't socialize, nothing. The judge is on his way out. The judge acted in the Constitutional Court, an experienced judge. But I've noted the comments. With regard to communication, I do have an open door policy. Any judge who has a problem can come and speak to me about it, and they do. That is exactly what they do. I have one instance where a judge raised certain issues here at the JSC, and I've dealt with this. I've dealt with these issues that were raised, and I accept that there is room for improvement. I will accept that.
Commissioner Stanchek.
Thank you.
Thank you, CJ. Good morning.
Good morning.
Acting JP. I want to go back to the Standard Bank judgment.
Yes.
Because I think it's very important to characterize what you got wrong here. It's important because candidates should not be afraid to come here because their judgments have been overturned on appeal. High Court judges work under such enormous pressure, and to get those judgments out is very important, to get them out quickly. And if they get them wrong, well, that's what the appeal court is there for. And there are usually arguable points of law in most cases of any complexity. And it would be wrong to characterize how the SCA overturned your judgment on that basis and why this judgment has been singled out. It's not a run-of-the-mill overturning of appeal. The court says you made two fundamental errors. You granted an order where there was no application before you. There was a non-existent application, and you granted an order. And at the same time, you ignored an existing order of court. Now, those are primary and fundamental errors. They're not arguable points. So in answering the question, this is not about other judgments you might have got right or errors the judges made. This is such a fundamental and serious error that, you know, the court says the High Court must be regrettably be deprecated in the strongest possible terms. It's an exceptional situation. And I wanted to make that clear.
Thank you very much.
CJ, before the candidate answers, can I please follow up on that point? Because that's the question I wanted to raise.
Okay.
So that we can save time. Good morning, Deputy Judge President. I think Commissioner Steinberg is raising an important point, because what the SCA was dealing with, there was a settlement agreement where multiple orders were granted. One of the orders that were granted was to withdraw the business rescue application. The other one was to postpone the liquidation application. So at a later stage, there was an answering affidavit that was put up, and the matter was argued at a later date. Then what the SCA is saying, when you had the matter, you did not take into account the fact that there was a settlement agreement where the business rescue application was actually withdrawn, but you proceeded to grant a business rescue application. That is the application that the court is saying it was not before the court. And I think that is where the fundamental challenge is. Thank you very much, CJ.
AJP?
Yeah, Commissioners, I've noted the comments made. I have erred in that judgment. From my vantage point, the business rescue application was revived after the fraudulent agreement, but I accept the SCA's comments ruling that the application was non-existent because I approached it as a fresh application. But I've noted the comments and I accept that I have erred in that regard. Yeah.
Commissioners, I'm going to urge you to please think carefully before you raise your hand. We've been interviewing this candidate for almost 3 hours now. Do you still want to put your question, Mr. San? You were the first person to raise your hand.
I was, in fact, but I think in the interest of time, a number of issues have been covered.
Thank you. Commissioner JP Mulambo.
Good morning once again, AJP.
Good morning, JP.
I'm surprised you should changing yourself regarding the initiative you've taken as AJP for your court to be digitized. I think you should have mentioned that more strongly. You even sent a team to go and observe judges and court staff. Am I correct?
That's correct, JP. I'm passionate about improving the efficiency of the courts, and digitization and innovation is close to my heart. So the court is fully trained. Yeah. We are out of our starting blocks and we are expanding the training. In Cape Town, we're working on our practice directives.
Yeah. You've mentioned
yes,
that.
Yes, the Western Cape High Court is drowning in paper, so it's very much needed. And yes, I am passionate about that project.
Yeah.
Yes.
I just want to explore two things with you quickly, and you don't have to be to give a very long explanation about each in the interest of time. One is, you've mentioned several times that the 80% of the judges are doing criminal work, or were doing criminal work, and 20% doing the other work. But I'm not sure if I heard what your vision is, because from where I sit, there's always a set number of judges that do the criminal roles, and then there are the other judges do all the other work areas. I don't think I've heard you what your vision is as to ensuring that there's an equitable spread of judicial resources that attend to the work that come to the court. Are you able to give that clarification? What's your vision about correcting that?
Well, obviously my vision is for the Western Cape High Court to be a united bench, to be accessible to all, and to be a leader in efficient, effective and expedient service delivery, but through the means of digitization, which will then streamline processes and make the court more efficient and more
Can I
effective.
stop you there? I'm talking about this issue.
Of 80% in crime,
80
yes.
and 20%, yes.
Normally, we would allocate criminal matters to 12 or 13 judges. That is our normal formula, Commissioner. But because of the backlog, we have many matters that is part heard that needs to be completed. So even if you take a judge, you can take a judge out of crime only once they have completed the full hearing. The Western Cape Division is in a unique situation that most of its matters involve multiple accused. So the trials do tend to take long. So my strategy was to finalize backlog, to finalize part heads. And during that phase, 80% of the judges were in crime. We also have ad hoc judges coming in to finish their crime. And that is why I had to introduce the pro bono project to assist with the civil load. So what the strategy is to get more judges in the civil pool. But as we stand currently, we have 33 parted matters, that is of which 14 is in sentencing stage. So the idea is to have only 13 judges in crime and the rest in the civil pool. While we are finalizing, we're at the tail end of working away the old criminal matters. We're at the tail end of that. We have 102 matters on our pre-trial roll. So it's a matter of balancing how many new matters are going to start in consultation with the NPA so that we can go back to our normal figure of only 13 judges in crime. So what can happen is that you have 13 judges in crime, and then you have judges who are partial civil and partial crime. As I've mentioned, some of the cases are in sentencing stage, waiting for reports, probation office reports, or any other outstanding issues. JP, in terms of going forward, the civil matters are being attended to by virtue of the special Friday roles that I've introduced so that the civil workload does not suffer. The RAF matters are being managed and mediated, which creates slots for civil matters to be brought forward, to be finalized. So I am dealing with the fact that there are more criminal matters running. I'm dealing with the civil matters in that way.
Okay.
And in so doing, that concern that there's not sufficient manpower to attend to civil matters is no longer there. I've balanced that out with the pro bono project and the Friday project and the RAF project.
Okay. Thank you very much for that. I don't agree with you, by the way, when you say the running roll method won't help you.
The continuous roll?
Yes, continuous roll, yeah.
Yeah. Continuous roll is an advantage, JP, because if you can focus on one matter and let it run through, it is fine. But what happened with these parted matters, sometimes the judges get stuck in the middle of the matter because the counsel is involved in more than one matter, and counsel must then then first be in one court and then in the other court. And I'm specifically referring to legal aid counsel here. So sometimes a matter must stand down while the legal aid officer completes another matter. So there's this piecemeal finalization that then destabilize the continuous role. And that is what we are busy working away now so that we can actually go back to a continuous role. That is the ideal, JP.
Okay. My last question, CJ. One of the issues raised by Judge Ali is your allocation patterns.
Yes.
And the point she makes is you allocate more complex work to acting judges instead of allocating work to permanent judges. I've come across one case. You sat in a Scalabrini Home Affairs matter some years ago, and there's another one that was decided in August, I think this year, by an acting judge. It's a matter that involved issues that have already been decided by the Constitutional Court, by acting judge Manga, if I may pronounce it.
Manka.
And I ask myself, this was not an easy matter because it had to do with declaring certain legislation unconstitutional. And it touches on matters that have been dealt with by the Court and some of them by a full court in Gauteng. So I ask myself, how was this matter allocated to that acting judge? And to be fair to you, I look at your lineup of people who want to be judges in the Western Cape. This person is not there, and I don't know how many times she'd acted in your division to get the nod to deal with that matter. So I'm raising it in the context of what Judge Ali says. Are you able to deal with it? Do you know the matter?
Yes, I'm aware of that, JP. Allocations in the division, it's purely done based on availability. And the Western Cape division is a very busy division. So the judges, specifically in the civil pool, they are very busy. And sometimes you get matters that should then be allocated as an early allocation, and that was one of those matters. It was an early allocation. And it's a lot of reading. So because the judges are so busy in the civil pool, what happens is dates were allocated to that specific matter. Remember, I don't allocate the dates. So when the file comes up for allocation, I can only look at my register to see who is available to hear that matter. And if someone outside the division, if an acting judge or a pro bono judge is given that matter, it means that no one was available in the division to do that matter, because that is the starting point, is to get, if you know it's a high impact matter, is to look for a judge within the division. So sometimes these early allocations also come up a bit late for allocation. It must come up at least 10 days. That would be 2 weeks. It's 2 weeks, which means 5 days of the week plus the previous week 5 days. So it comes up 10 days before the time. And that is the time when you would actually assess the availability of judges. Yeah. Okay. And but the recipe is first see who is available inside the division before you would allocate it to someone else. It's only if there's no one available inside that it would go to an acting judge.
I see.
Outside, yes.
That tells me that there's no gatekeeping role that the leadership of the division plays when it comes to these complex matters, because you would jealously guard the jurisprudence coming out of your court, and you would not simply allocate to anyone. I do that with my DJPs, and we allocate 3 months in advance, and we know how to allocate those matters. So it sounds like in the Western Cape, it's based on availability. Am I correct? That's your answer.
That is a main consideration.
Yes.
What one can do is change the date, ask the parties maybe to shift the date, so that you can then allocate it to someone in the division.
Okay.
Yes,
Thank you.
that
Thank you
is
very
what
much.
one can do.
I've got no further questions.
Thank you very much. Commissioner Hassan?
Thank you. I actually think that there is a matter that wasn't covered in some of the questions that were already posed. AJP, I'm over here, Commissioner Hassan. Thank you. I just want to ask, maybe related to some of the elements around unity. I think there is some perceptions that in the Western Cape Division there are camps, and I say perception to be fair. So I'm very interested, AJP, in this process of building division and, of course, creating stability. And I'm going to ask a difficult question. Should you be unsuccessful today, AJP, would you be able to support and help build that unity with a different candidate at the helm of the Western Cape Division? Because we've heard numbers of things of not visiting different chambers, the tea room, there's a lot of rumors, I'll say it like that, a lot of rumors that are rife around the disunity there. So I'm very interested, AJP, what you would do should you not be appointed at the helm of this court. Thank you.
Commissioners, I am the constitutionally appointed Deputy Judge President, and my role as the Deputy Judge President is to support the Judge President. And that is exactly what I intend to do. That would then be my mandate. And when it comes to the appointment of someone else, of course, I need to be deferential, and people have different leadership styles. So I will then navigate my way around that and just provide the support as my current position dictates.
Commissioner Gosal?
Thank you, Judge. Good morning, Judge.
Good morning.
My question just relates to what JP Malamba was saying. And in your interview in the beginning, you said that you have established but also sit on many committees within the division. And I was wondering, does this, together with the burdensome job of managing a division, allow you to also sit on complex matters?
Well, initially when I managed the division on my own the first term, and I did quite a bit of court work during that term. But later on, as the time progressed, the administrative burden, due to the administrative burden, I had to reduce the time I spent in court. But yes, as a leader, you do have time. You can prepare your diary accordingly and do sit in certain matters. I think that the slap judgment that I did, I think I was in my position already when I had the slap matter. I heard matters on trademarks while I was AJP. And of course, I fulfill some role in mediating family matters before it gets allocated. I mediate all family matters and matters involving children. So yes, I do have time for judicial work, but it needs to be in a structured way, because at the end of the day, you also need to do some court work to sharpen your skills. And as a leader, you also need to set an example and go to court in certain matters.
Thank you.
Okay. President Molemer?
Yes, thank you very much. AJP, just a follow-up question. You said you managed the division on your own upon assuming your duties for the first time as AJP. You managed the division on your own. Did I understand you correctly? In other words, there was nobody acting as a DJP?
That's correct.
What motivated that decision, if I may ask? Bearing in mind that you took over at the most difficult time, and one would have imagined that you'd have a lot of administrative responsibilities. Did you not consider that it would maybe be wise to also have somebody helping you?
President Molamela, there were always senior judges, and still there were and is senior judges that you can always approach to assist you, whether it's with the RAF court or with criminal matters, etc. My strategy the first term was just to run the division on my own and do a wellness check and put certain things in place and bring things together, and then appoint during that term I then identified someone to act as the deputy. For me, my strategy was, because I was the DJP, and I knew more or less how the division functioned, I could make strategic decisions quickly without having to consult someone at that time, just to put the system in place and make sure that the most important things are done that needed to be done. And during that term, I then had discussions with different judges to make an assessment of who has the necessary skills to assist me in the running of the division.
Thank you, CJ.
Thank you, President. Commissioner Mangen?
Thank you, Chief Justice. I've got two questions for you, AJP. One is just an invitation for your comment. When Judge Gamble interacted with you regarding acting judges, you said something to the effect that you are unable to find capable black acting judges. What did you mean by that?
No,
in Cape Town.
In Cape Town.
Yeah.
Thanks for the qualification.
No, I indicated that I look outside of the province as well. That's what I said. I look outside of the province. We have black acting judges from Cape Town. That is generic black. We have, if not all of them, are from Cape Town, except for 3 African women specifically, I'm referring to women that are invited from outside of the province. So there are generic black acting judges. I just made the point that I don't limit it to Cape Town only, that I do go outside, because in Cape Town, there's a lack of African female acting judges. That is a problem. We do have, but it's just 1 or 2 African females.
And in your vision that you outlined, I did not hear you outlining in detail what plans you have to bring in more capable black acting judges.
Well, I have started that process by looking beyond the province. During my reign, 29 women acted in the division. The division is fully transformed in terms of gender, but not in terms of race. And I think there is a need to appoint more African women on the bench. I have embarked on a program to appoint more black women, which I did. I think last term we had more female or women or African acting judges than in any other group. So that is work in progress, and those judges are currently in training. In the total of 29 women that I had, I see 8 were black, 8 white, 7 colored, and about 5 Indian of the 29. I have mechanisms in place. I deal with the structures. I am encouraging African women to make themselves available. I think that is the group where the Western Cape can improve in terms of the diversity pool. So I'm actively pursuing that agenda and actively approaching African women, which I did.
Thank you. My last question, AJP. By my calculations, and you'll tell me if I'm correct, you said you were appointed DJP in 2016.
That's correct.
And that makes it 8 years. And the last of this 8 years, the last 2 years of this 8 years, you were the AJP.
That's correct.
In these 8 years that you were the DJP, where you were required to work with the then JP, obviously under what you call difficult period. Did you get an indication that you've got the support of your colleagues on the bench in your work as a DJP? Because if that was the case, why would, when an opening comes, so many of them avail themselves to do what you should have done in 8 years?
I think that is the aftermath of the issues in the tensions. Obviously, I'm not entitled to the position of Judge President in the division, and I think anyone else is free to make themselves available. As DJP, I had a cordial relationship initially with the Judge President. I did receive the support of all the judges in the division, but when the problems arose, it is so that it created division in the division in terms of split or little groups. My task over the past 2 years was to try and overcome that bridge, and that's why I introduced the tea room and regular meetings, etc. I tried to normalize the functioning of the division by committees being active and the tea room fully functional, meetings held regularly, interaction between judges. Yes, more can be done. I'm not saying it's a perfect situation, but as DJP, I did get the support of the judges in the division. I think it is normal in the aftermath of the situation between myself and the Judge President that there would be challenges to navigate. And for the past 2 years, that was my goal, to navigate those challenges and build bridges and improve where I can and try and create an environment that is conducive to collegiality, which there is currently. The fact that many judges make themselves available, I think it is their right to do so. No one is entitled to that position, and that is just the reality of the matter. That does not mean that I didn't perform my functions as the deputy or as the AJP. As AJP, I was a caretaker, and I'm satisfied that in my position as caretaker, I've stabilized the division, and going forward, this commission will then decide who is going to take the division forward, and it most certainly can be any of the 8 candidates who are all entitled to make themselves available.
Thank you, Chief Justice.
Professor Marumugai?
Thank you very much, Chief Justice. Good afternoon again, Judge Goliath. And I think it is really important, notwithstanding the discussion that we had on that Supreme Court of Appeal case, to state that you are actually a very good judge, forensically. I think that must come out very clearly. And you have penned some of the most important judgments, especially when you are in the Constitutional Court, the Rahube judgment, the veterinary medicine judgment, and the others. You have actually done very well, and I think that should come out very clearly. And again, there is one judgment. I want to take you to page 31 of your document. There's a judgment that you penned, which is one of the beautiful judgments that you did. That deals with trademark law. You done that quite a long time ago in 2015, and that judgment is one of those that really tried to illustrate the differences between trademark infringement on the one right and the law relating to passing off on the other. And I think you did very well on it. There is something that comes out, though, from the judgment. I know it was a long time ago. I'm not going to bore you with the details, but I just want to ask you a general question in relation to trademarks generally, and Section 34 of the Trademarks Act, which you deal with quite competently in the judgment. when I read the judgment, I got a sense that, can one say that the fact that the proprietor of a registered trademark fails to demonstrate significant consumer recognition be a defense to a trademark infringement claim? Because in the judgment, when you are dealing with Section 34, you quite correctly show why the person who's claiming trademark infringement should not succeed when you are comparing the two marks. But I'm just curious to know that if you fail as a person who says, look, this is my trademark and it has been infringed, if I fail to demonstrate that there is this general recognition by the public, can that be a sufficient defense to a claim of trademark infringement? And I don't know the answer, I'm just asking.
Yeah, look, I've written a number of judgments on trademarks, but if someone can't show that its business is associated with a trademark, it can become challenging to actually stake its claim if it did not use that trademark, and then that business must be associated through use of the trademark. It can become challenging. I don't think it means that you cannot lay claim to the trademark, because there may be other factors involved that may allow you to claim the registration of the trademark as your own, because it could have been used for some time, and then it was lying dormant, and then you want to revive it, and then someone wants to come and say, but your business is no longer recognized through use of this trademark. Yeah, I think there's no probably definitive question, but it will just make it more difficult to show that your business is associated with it, but it does not necessarily mean that you're going to fail to protect the mark.
Thank you very much, Acting Judge President. Thank you, CJ.
Thank you, Prof. Commissioner Malem, your hand was once up. I don't know if you still want to put your question.
Just a quick one, CJ. I always hear these councils here, where every time a decision is made, they say it has to meet the rationality test. What is your understanding of a rationality test?
When you exercise public power, you must exercise public power in a rational way. In other words, if it's the legislature or the executive or any public official, if they exercise power and make decisions, it must pass the rationality threshold, because all public power is subject to constitutional control. And the rationality threshold is very low to meet. So, for example, say it's socioeconomic rights that's at stake, and a department is being sued for not providing sufficiently enough service. The judiciary cannot interfere with polycentric decisions that's made by the other arms of state. And why I'm saying that is, if the reason for a policy or a decision meets the rationality test, that is sufficient, and the threshold is quite low, because all decisions that are made there must be a rational connection between the decision made and the purpose for which a provision was enacted.
So in exercising public power, where as acting JP, you have the right to appoint or designate. In exercising that power,
that's correct.
You look at the reasons and say it's a friend of so and so. Is that a rationality? Does that reasoning meet the rationality test, which is the lowest? I'm happy that you are saying the rationality test is very low. Low as it is, do you think the reason of in the exercise of public power to choose a designate, you say, no, this one is a friend of so and so. Does that meet a rationality test?
Well, the rationality threshold is low. It is so that someone else may feel that my reasoning does not meet the rationality test, but the threshold is low. And someone else may say that I would have exercised my discretion differently. But the fact that someone says, I am inclined not to agree, I would actually have exercised my discretion differently, is not sufficient reason to say that someone else's reason is totally irrational.
AJP, I'm not asking you about someone's decision. I'm asking you about your decision. Does it meet a rationality test? Because I'm going to argue that your reasoning does not meet a rationality test. And as a judge who's supposed to be objective, you must answer from that platform from an objective point of view and be honest with this panel. After the engagements we've had with you, in all honesty, not whether someone else will say it meets the lowest expectation or not. In all honesty, after the exercise we have gone with you for almost 4 hours now, do you think that decision meets a rationality test, which you must meet when you exercise a public power? The reason why in the exercising of the public power, you have to meet the rationality test is to avoid abuse of that public power. Because what you did is an abuse of that power. Because it doesn't meet the rationality test. But in your own standard, as a leader, as an aspirant judge president, do you think, on a hindsight now, that decision you took, based on friendship of people, does it meet the rationality test?
Commissioner, the issue is not necessarily about the reality, it's also about perception. So it is so that from a certain perspective, one may believe that it does not meet the rationality threshold because the mere connection to a friend as one of the candidates may be viewed as insufficient reason to designate a different alternative.
AJP, CJ, please, I think we've been long here. All I'm asking is, does her decision, after all of that, meet a rationality test? What she's explaining, she said it before. We've heard that. We just want to know if she says it's yes or no, that's the answer. But I must not go and second guess her in the deliberations.
Commissioner, I'm trying to explain that the fact that someone is closely connected to or a friend of one of the candidates may not meet the rationality threshold in certain quarters. I can understand that. From my perspective, in designating an alternate, I looked at the matter clinically and said, what would be the best option? A designate who has absolutely no ties with any of the candidates, including myself, or someone who is connected to one of the candidates by virtue of friendship. And I then took the decision that it's in the interest of today's proceedings to have someone who is completely disconnected to all the candidates. And that was my motivation. And Commissioner Malema, I hear you that you want a yes or a no answer. I hear you want that, but I need to explain to the Commission that I was sitting with two options, and from where I sit, I made the most rational decision to choose someone who has no connection with all the candidates.
Therefore, it meets a rationality test.
Excuse me?
Therefore, it meets a rationality test because you made a rational decision. That's what you are saying. I'm not a lawyer. You must simplify it for me.
Yes.
Your decision met the rationality test in your corner.
Yes. The threshold for the rationality test is very low. Someone else may feel that the person who is connected to one candidate may indeed be suitable. But someone else, someone in my position felt I would prefer someone who is not connected at all to any of the candidates. And that would, for me, be a more rational decision, simply because a designate who is not connected to anyone will be able to fulfill their function better, because it's not only about reality, it's also about perception.
I give up, CJ.
That is the answer, Commissioner Malema.
That's what I'm saying, I give up.
What you will. Very last question, Commissioners. Commissioner Lekhanyan.
CJ, thank you so much. Very quickly. Good afternoon, AGP.
Good afternoon.
AGP. Just to check with you, who appointed Judge Gamble as the AGP today, for today?
I designated him on the 8th of August.
Yeah?
This year, I did the designation.
It was yourself?
That's right.
Did you do it in consultation with the Chief Justice?
No, I didn't do that in consultation with the Chief Justice. The shortlisting involved the former Chief Justice, not the designation.
The cogent logic that you advanced on the matter of Nojes and Judge Erasmus, does it not apply in the case of Judge Gamble, who must be designated by you to come and participate in an interview where you are a candidate?
No, it does not apply.
Thank you so much.
Because in the first instance, Section 178K grants that power to designate, and I have exercised that power in a manner where I thought it would be best if someone represents the division who has no ties with any of the candidates on the list, not even with me, absolutely no ties. Judge Erasmus was designated to attend to shortlisting by the Chief Justice, and when the shortlisting came out and I saw that there's someone's name there that's closely linked to Judge Erasmus, I then elected to exercise my constitutional power in a manner where someone who is completely neutral to all the candidates are appointed, and someone who has no connection with any of the candidates at all. It's not my choice. I'm not a friend of Judge Gamble,
No.
and he's due to retire in November. There's no connection between us.
Commissioners' hands still keep coming up, and I've been very inconsiderate with this candidate. It's chasing 4 hours now. She has not even taken a break. We've been walking in and out, relieving ourselves, getting coffees, while she's been sitting there answering all these hot questions. I just want to say this for the last time. Please think very carefully if you really want to answer, if your question will take this process any further. Let me put it that way. Do you insist, Mr. Boshoff? All right, thank you. Thank you very much, Acting Judge President.
Thank you very
Goliath,
much. Thank you very much to all the commissioners. Thanks.
You're excused. All right, 12:36 is the time. Lunch is at 1. We still have 6 candidates. How do you want to do this? Press ahead, take a short comfort break, take one candidate, then take lunch?
CJ,
Sorry?
I suggest we take lunch and then come back.
It's not ready. That's the
Oh, it's
thing.
not ready.
It will be ready at 1:15.
Oh.
Okay, let's take a comfort break quickly and come back and
Okay.
just start with the next candidate. Okay, 10 minutes. So, yeah, that's a record.
It's a record, I'm sure.
Yeah. Oh, there it goes. How do you pronounce your name?
My surname is Legransi.
Legransi, I thought so. Okay. I had Judge Gembro refer to you as Legransi, and I thought, or something like that. Okay. How are you?
I'm fine, thank you, Chief Justice. And how are you?
Good, thanks. I must just apologize for keeping you waiting for so long. We were a bit tardy in the first step of the proceedings. But I doubt very much that you will sit there for as long as the previous candidate. This is a silent plea to the commissioners. You hold 3 academic qualifications in the legal field. A B Juris you obtained from the University of the Western Cape, right?
Yes, I've obtained my B Juris and my LLB.
And the LLB.
And then my BCom Honours at University of Cape Town.
All right. You started out in the Department of Justice as a public prosecutor in 1988.
That's correct, Chief Justice.
Then in 1993, you joined the magistracy as an additional magistrate and worked your way up to regional magistrate by 1998. How long were you a magistrate?
I was a magistrate for 5 years and a regional magistrate for 8 years.
All right. Then you started acting as a judge in the Western Cape Division of the High Court.
That's correct, Chief Justice.
In 2005. You acted for 2 years straight?
Except for the recess periods, but approximately 2 years, straight years.
All right. But then in 2007, you were appointed permanently in the division.
That's correct.
To date.
Yes, Chief Justice.
You were appointed as acting deputy judge president in April last year.
Yes, Chief Justice.
You still hold that position?
Yes, I still hold that position, and my appointment is until the end of this term.
What kind of functions do you execute in this capacity?
The acting judge president has given me specific functions, and that is to deal with the criminal division and also to deal with all matters falling under that division, namely petitions that come to the court in terms of Section 309C, where I will then allocate these petitions to the different judges. I will also allocate criminal matters to the judges. I'll deal with the circuit courts, and I also deal with surrogacy matters and any other matter which he deems fit to send to me for management, whether it be litigants or practitioners that seek directives from the Office of the Judge President. I will deal with that.
And I take it you have enjoyed the experience, because here you are in front of us.
Well, it was interesting and also hard work, but yes, here I am.
Okay. Assuming that you have a vision for the court, what you'd like to change, improve, or, I don't know what you have in mind for the court. Would you just take us through what's in your mind at night when you think about your day and how the future should look for that court?
Chief Justice and Commissioners, I've been at that court now for almost 19 years, beginning as a junior judge, then as a senior judge, and now in a leadership position. I am of the view that, and I think the Commission is well aware of the difficulties that we've gone through in that division. My vision for the division is a short-term vision, a medium term, and also a long term. In the medium term is a period of starting off until about 6 to 12 months. Long term is about from 12 months to 24 months, and obviously a long-term vision thereafter. I've got about 8.5 years left before retirement, and I would like to build a court that is stable. I would like to see a court that delivers quality justice and access to justice. And I would like to see a court that embraces new technology. I would also like to see a court that do things a little bit different, because in terms of approach and in terms of views, obviously I've got a different approach and different views as the AJP, and that is why I'm sitting here today. With regard to my short-term vision, there is no magic wand in regard to build a division that had all these problems. But one can at least start somewhere. And somewhere where to start is to have an open debate amongst the colleagues within the division. And I firmly believe that being there for so long has given me an insight into the division. I know the division like the back of my hand. I know the administrative side. I know the officials that work in that division. I know the legal profession that practice there on a regular basis. I interact with the various organized profession bodies on a regular basis. So I've got a deep understanding and the complexity of the division. And for me, one of the issues to do in a very short term is, for instance, to have a weekend away under the auspices of SAJE, so that we as colleagues can have an interaction within a private environment, confidential environment, and have a one-on-one talk. Because I don't know if it was mentioned by the AJP previously, but when she started, it was the first meetings that we had last year in about 6 years as judges. We never had meetings before. It just suddenly stopped. So the issue is, how can you run a division effectively if you don't have judges' meetings? But more importantly is to have not only judges' meetings once a term, but often as possible, so that we can have debate, raise, because judges have always got different views and perceptions, and we need to talk about it. It's only then that we can learn from one another. So that is the first thing that I will do, but it will not be once off, because we need to build a team. We need to continuously build in terms of our collegiality, in terms of how we see things and how we're going to do it. That's the first thing that I will do. The second thing I will do is change the way we allocate our matters. We still have an old system of manually allocating matters to judges. And it's not as we don't have the capacity or the technology, it's there. So what we need to do to dispel this notion of there might be unfair allocations, or somebody get more work than others, or I saw somebody walking in the corridor not being in court. The simple solution, as far as I'm concerned, is to have a program. We go on OneDrive, and a judge that wants to see what he or she has been allocated, click on the laptop, open up, and can see what they've got for the day or for the next 2 weeks, what Judges A has got, what Judge Y has got, and so forth and so on. Those are the things that I will immediately introduce. In terms of my interaction with the judges, I've got no controversy with any of my colleagues. I've got an open door policy. In fact, I'm sitting here today because a number of colleagues, junior and senior, has came to me before and said, please put up your name. Not only that, I had the support staff coming and ask that I must put up my name. I've also had, as you can see from the nomination letters, people from the legal practice or the organized profession, to put it that way, that said I must put up my name. And I think that the reason for that is as a result of my interaction and the respect that I've gained during this period of time on the bench, not only from the organized profession, but also from the public in general, and also from my colleagues at large. In terms of my medium plan, our court currently functions on paper. So if you want to file a document, you must file it at what we call room 1. Our storage facility is limited. We don't have sufficient storage facilities anymore for those files that's there. So from that perspective, what is the solution? Case on lines. We have been introduced to it. We have had our training, and Judge President Malambo was so kind to come out one Friday, and we were sitting from 2 o'clock until about 5:30 to train the judges as to how to use case lines. And that is the answer. So we can go electronically, the attorneys and the public can file it electronically. It will assist on more than one level. It will assist that we don't have to worry about files getting lost. It will assist where parties blame one another for not filing timelessly, because once a document is filed, it's there, it's up. So that for me, in the medium term, that is from 6 to 18, 24 months period, that should be introduced within the Western Cape High Court. And I will drive that particular process. With regard to my long-term vision, our division currently relying on acting judges. And I've supported the AJP with regard to compiling a list for candidates to be appointed as acting judges, because we have got 5 vacancies currently. And our establishment is 33 judges. So currently we've got 28 judges, of which 1 has been recently recommended to the Supreme Court of Appeal. We've got 3 judges that's going to retire within the next 18 months. Collectively, if you take into account the judges that already retired in the past 4 to 5 years, those that are going to retire in the next 18 months, and those that have been elevated to a higher court, we have lost about 200 years of judicial experience. We need to get judges, permanent judges. Now, with regard to the acting judges, and this also impacts on the reserve judgments, is you get those that has got no interest in permanent appointment, that are only there to help and assist with backlog. Then you've got those acting judges that's not sure whether they've got the temperament of a judge. I would like to experience a term or half a term to see whether they have it, what it takes to be a judge. And then those acting judges that tells you up front, I would like to become a judge, therefore I would like to come and act. So those are the scenarios that we've got. And we've also got the pro bono system in place. For me, it is how do we go about appointing the acting judges? And what are the criteria that we are using currently to get the people on board in terms of the transformation, in terms of gender transformation, and an overall perspective of getting people that can also do the work. And in that instance, I will, if I do get appointed as a medium-term vision of mine, is to get more input before appointing acting judges. In order to go to the judges, the permanent judges, say, I've got a list, I've got 9 acting judges that I need to appoint for next term. Here are the list of 15 people. What's your input on that? And from that discussion, whether they want to talk in a meeting freely or whether they want to come and see me personally to say, yes, this person has appeared before me or that person has got an issue, then I ultimately will make the final determination. So from that perspective, we have to look in terms of how we're going to go about. We can also not only limit the acting judges to advocates or to attorneys or only to magistrates. The academia is there. Some of these practitioners are professors. They are expertise in the field and would like to come and act. And we need to have that in order to give them an opportunity. And some of the CVs are there, but they don't get appointed. So those are the things that I will change, and that's part of my vision. And let me put it, it is practitioners of color. They're not white. But more importantly, in terms of the long term, my vision is we need more judges. That's as simple as that. Our workload has increased tenfold since I became a judge in 2007. But our precinct is old and is very compact, if I can put it that. So we need more courts. A building has been in the past identified. That process has stopped due to lack of funds. So there was previously mentioned that we will be able to get 2 courts probably, civil courts. And that is a long-term plan in terms of funding. But in terms of the criminal division as well, our caseload has quadrupled in the past 5 to 6 years. We are sitting with people in prison awaiting trial for almost 2 to 3 years before they get a trial date. I've visited in the past 18 months various prisons. And I can tell this commission that if you walk into one of those awaiting trial facilities, they're overcrowded. You've got 40, 50, 60 people crowded in one facility with an open bathroom, sitting there for a year, 2, 3 years, waiting for a trial date. That cannot be. So what I have done is, there was this program before where we used courts at prisons, and one particular court, Paulsmoor, but there was some sort of objection from the practitioners and whoever, the facility was not up to standard. I took it upon myself. Took the stakeholders to Paulsmoor. We had the commissioner, he retired now, with us. I asked the legal profession, what is wrong with this? Why can't we not sit here and deal with matters? And they were telling me that this bench is too short and we're sitting on top of each other. And the commissioner said, stop. What do you want us to do? Do you want us to lengthen it? Yes. So how many counsel can sit here? From 4, we increase it to 7. And that's been done. Paulsmoor is running currently. In the past 12 months since I took over, 6 matters has been finalized in Paulsmoor. And these are not 6 ordinary matters. These are 6 highly complicated and high-risk matters. With regard to Goodwood Prison, that prison facility was not up yet. I've pressed the Department of Correctional Service, then under the previous commissioner retired, to get the facility up and going. It is now. But we have got a problem in terms of the IT infrastructure, because the cabling is too expensive and no one has got money for it. So we are using our own mobile system currently. 6 matters has been finalized in that court in the past 12 months. So these are the things that I would like to drive, and to see more of these facilities, because we need to finalize cases. The turnaround of cases needs to increase. This commission will probably know, and I've got a report here from the NPA, that essentially says that currently the Western Cape High Court has got 13 high-risk matters. The commission has probably read in the newspapers about it, but when you see the witnesses under witness protection, it's one thing. But when you see the investigating officer under protection, and you see the prosecutors under protection, it's something else. And whilst the cases are running, witnesses are being taken out. It's a worrying factor, and we need to deal with it. Because if we don't do it effectively and efficiently, the rule of law will be under attack. And that is my vision, that to get the division running smoothly, and currently I can say to this commission that from 197, I'll just get my figures right. About 2 years ago, we've now got about 110 matters on our roll. Of that 110, 34 are parted matters. So there are some judges that's got more than one parted matter. 14 of those matters are currently in sentencing stage. So we will be under the 100 mark of criminal cases on our roll. And how did we do it? I physically went to go count those cases, because in order to manage it, you must measure it. Because without that, you don't know what you're doing with and dealing with. I've also indicated to the judges, because what we found is the acting judges not completing their cases and their criminal matters. And then they postpone the cases to term. So when we arrive after recess period, we find that most of the courts are busy because this acting judge is doing criminal matter and that acting judge is doing a criminal matter. I stopped that. I stopped it. I said no. If you've got a parted matter as an acting judge, criminal matter, you do it in recess. And if those judges, permanent judges, can finalize a criminal matter, whether just to sentence, or whether there's a probation officer's report outstanding, do it in recess. And that is what I've done within the short space of time. And I think that I'm confident that I've got the backing of the judges with me. Not one of them has raised any issue with me yet to say that they disagree with this or they don't agree with that in terms of the case flow management of cases. In terms of being a judge president, obviously you must also have your pulse, or your finger on the pulse in terms of the rest of the division. What's happening in the lower courts? What's happening in the organized profession? And in that regard, my interaction with the magistracy, I understand the issues there. I've been a magistrate. The regional court president was the other day at our office, and we discussed the issue of the Southern Cape. Southern Cape has got a problem in the regional court. There are only 5 magistrates, but there are about 4,000 cases outstanding. We need more magistrates to work down that load. So that is work in progress as to how we're going to deal with that. In this past 18 months, I could not give sufficient attention to all what's happening in the lower courts because of what was required from me to work in our own division. But I've understand the difficulties that they're facing. Infrastructure problem, recording machines that's not working, and how that impact on the delay of cases. So from where I'm sitting, Chief Justice and Commissioners, is we need to build the Western Cape. We need strong leadership within the Western Cape. And we need leadership that can understand the issues of the Western Cape. And I firmly believe that we can, or I can turn it around with my experience and skill set. The last thing that I would like to mention in terms of the bar, because that always remains an issue. We see that young black junior counsel coming in, but after a few years they disappear. The Cape Bar has got what they term a program where from year 0 to 5 you will have senior counsel clubbing together in a pool and pay the expenses of the young juniors. But that's only from 0 to 5. The difficulty is after 5 or 7 years, what happened then? That is where the problem lies. And often, the briefing patterns of the state needs to be looked at. It cannot be that you still find today that the state brief, and I'm saying with all due respect, white males walking into your court without any juniors or black juniors. Why is it still happening? The state attorney might have his own briefing patterns, but we need to relook at that. And I think if that changes, that we have a system where senior counsel must have a young black counsel, female, male, then it will assist in the transformation of the judiciary. Because I firmly believe a strong and ethical bench and attorney's profession brings about a strong and ethical, let me just rephrase that. I just want to say a strong and ethical advocates bar and a strong and ethical attorney's profession brings about a strong and ethical bench. Thank you, Chief Justice.
Thank you, Judge Lecranse. You mentioned, as you were going through your plan, that it or aspects of it have the support of your colleagues.
Yes, Chief Justice.
Mm-hmm. Does that include the acting judge president?
Yes, because what has happened is we've discussed it, and we have an open discussion in terms of how we should do things. And she is aware that we have different views and opinions on certain issues.
All right. Just to round off on your CV, you've also acted in the competition courts?
Yes, but that didn't materialize as I would want it to be, because what happened is that there were no cases And then I got appointed as acting DGP. Then I phoned JP and said to him, I think I'd rather concentrate on the work that was given to me, and that was the end of it.
All right. And whilst the magistrate, you were the National Executive President of JOASA.
That's correct.
Which is an association of magistrates.
That's correct, Chief Justice.
For a term.
I was for 2 years. It's a non-renewable term of 2 years. And I can proudly say that I and the chair of the gender desk, or one of the magistrates, discussed the gender desk in the organization when I was president, to promote the interest of the female magistracy. Because at that time, in 2000, there was very few black female magistrates in leadership. In fact, I don't think there was. So we've worked on it, and I can say that the first chair of that gender desk is now a senior member at the Supreme Court of Appeal.
All right. That's something to be proud of. Okay. Judge Gamble, do you have any questions for the candidate?
Yes, thank you, Chief Justice. Judge Lagrange, sitting where I am in the, I suppose, the departure lounge of judicial officer, I'm very encouraged by your visions. It's good to hear that there's a plan in place. I've got just 3 issues that I'd like to raise with you. The first is the question of the criminal backlog. And the commissioners this morning had questions for Judge Goliath in that regard. The backlog is extensive, and you've spoken about bringing it down. One of the problems, as I understand it, is that effectively the judge president has no control over the amount of criminal matters coming in. That's the prerogative of the DPP. You get told that the following cases are on the roll for the following term, and please find us judges for it. How do you address that problem?
Well, we did address it in a practice directive. So what we said to the NPA is, whilst the matter is still down in the lower court, and before transferring it to the High Court, I want a practice note from the NPA to tell me exactly what's the nature of the case, how many accused are involved, what's the complexity in terms of the indictments that we're dealing with, and the time period that they think this matter will run. So we've changed our practice directives to deal with that issue. So before the NPA can transfer a matter, I first see what it is, because what has transpired in the past is the DPP just transfer matters to the High Court, to what we call a pre-trial court. And then you will see a host of matters sitting there, and we don't have the judges. So before a matter gets transferred, I know beforehand how long that matter is going to run, how many state witnesses they intend calling, and how many of the accused might call witnesses, etc., so we can plan properly. I mean, I can tell this commission there is now one case that's still in the district court, in the lower courts. Highly complicated organized crime matter, where it is alleged that the construction mafia is involved. And there's also an ex-high politician involved in that particular case. We track that matter, because when that matter comes to the High Court, that matter will be allocated to a person that can deal with it accordingly and have a quicker turnaround time.
My second question relates to serving the province. Our province is huge. It runs from Vredendal in the north, Cape Town, Beaufort West, Swellendam, and right up to Plettenberg Bay in the east. As you know, I'm a keen one for circuits, and I regularly do circuits because I believe that's the way that you take justice into the community. It does seem to me from the way things are going that there is an ever-increasing necessity for a local division to be established in perhaps George or Mossel Bay. Probably George, because George has a bigger commercial centre. That would enable the division to cover Oudtshoorn, Plet, Knysna, Mossel Bay, Riversdale, even down to Swellendam. And it would make it easier for civil litigants to get to court in a place like that rather than in having to come to Cape Town. Have you any thoughts in that regard?
I know that I think it was the Moseneki, I'm just trying to think of the name, that compiled the report with regard to the court structure. So there is the suggestion that George be a local division, a permanent local division, and I support that wholeheartedly. But once again, these are budgetary constraints. Let me explain to the Commission the following. Because I'm dealing with circuits, if you send a judge on a circuit, you must determine the length of that circuit in terms of time period. Because it's not only the judge that's going, it's the judge, the secretary, the stenographer, and the interpreter. Because OCJ functions separate from DOJ. So, and then you must take into account the prosecution and the legal aid. Because all of them are coming from Cape Town sometimes, and the cost involved. Because to put up all those people for a period of 4 months, 5 months, drains the budget. So when that has happened, for me, it is, what's the case that we're going to deal with, and will that case be finalized? So when a circuit is being declared by me, I know that this case will be capable of being finalized within that period of time. And I think that is an important factor when dealing with circuits. We've got a continuous civil circuit within George that's running for a term, 2 weeks the first portion of the term, and 3 weeks the last portion of the term. But once again, it is the cost implications, because our budget has been cut, and there is just a problem in that regard. But we go out as far as possible on circuits. I myself, as acting Deputy Judge President, has gone on circuits, because I know for the fact this case will take 2 weeks, and I finalize it within 2 weeks. Within my period as acting Deputy Judge President, I finalized about 6 cases in the last months from the start of this year. So I'm going to court and deal with it. I've also, in order to avoid this paper war that we're fighting, at one instance I assigned myself a matter, a review matter, and the paper was this high. And I phoned Justice Muslam and I said, look, it appears that these attorneys all are on your platform, on case lines. Can I jump on your platform? And his reply was, well, it's for all of us. Luckily, a day before the matter had to be heard, I was phoned that the matter has been settled by the parties. But that is the innovation that we need to do in order to get things going.
The third is a remark, perhaps on a lighter note, because I know you have great difficulty with control over the building. But if you do get the job, could you please fix the toilets on the 2nd floor that are used by judges? Thank you, CJ.
Thank you, Judge Campbell. Mr. Boshoff?
Thank you, CJ, and afternoon. ADG JP sounds a bit silly, but yes. Just two brief questions. I think the one is a follow-up on Judge Gamble's question regarding the circuits, but there was a comment from one of the submitting bodies, I think the National Bar Council, and I think I'll just repeat what they asked, but how you would or could potentially use technology in a similar way, or the innovation that you've shown with your criminal initiatives to potentially, we're talking about circuits now far away, but there's a need for access and easier access to justice on our doorstep in the very poor communities around Cape Town, Kailicha, Langa, Elsie's, so is that possible? And I know budget and everything, but being in government myself also, you have to make do with an ever constraining fiscal space, but that's no ointment to the wounds to people who are sitting there desperate for, if they have to decide between, well, the transport to court is going to be the difference between a meal tonight, then that's not justice. So I would just, and then there's a short question after, but I think I'll give you an opportunity first to answer that.
I think we have to embrace technology and use it to advantage. Whilst we were discussing with the regional court president some of the difficulties that she experienced, one of the options was to, instead of a magistrate that had a parted matter in Bellville, but she was appointed in Vredenburg. So they put up in front of a laptop there in Vredenburg, and then was hearing the matter, the rest of the evidence in Bellville, because he was working there in Bellville during an acting period and pick up it. Now that's the innovation. So it saves cost. And I fully agree that we must embrace it. But it is sometimes problematic because the speed of the Wi-Fi might be a problem. Then pictures get frozen and everybody becomes unnerved about it. So it is those infrastructural problems that we're facing. But I fully agree with Mr. Boshoff that we need to embrace technology. And insofar in terms even postponements in prisons. As far as I'm concerned, and I'm not too sure how many have ever experienced Cape Town M3 on the morning, with all these vans chasing down those things, is to have a postponement whilst those that we know we're not going to deal with. But what we do find now, there is objection to that from the accused because they want to come to court. They want to see some of the families. But there's also other reasons why they want to be there. So those are issues that we are dealing with, that we would like to engage the NPA with. And if I get recommended to Judge President, those are the innovations that I will drive to ensure that there are cost-saving measures in place, in particular in that regard.
Thank you, Judge. And then the second one is you would have seen there was an objection from a Miss Albush that was filed. Now, I mean, what I really just want to ask, it seems it was somebody who appeared in person. There was an earlier appearance before AJP Goliath, and the matter was, well, at that point it was DJP Goliath. I don't know. I don't know the details of it all. It involved an eviction and etc. Then this person appeared before you in court, and in your response you filed the transcript of the proceedings, and the person was unrepresented, and I think if I go by the transcript, the proceedings lasted all of a minute. And you had dismissed the matter for lack of urgency, and you advised that they rather approach the Maj Court to have it rescinded, the order that they took issue with. My question isn't so much about the matter, but more about the perception that an unrepresented litigant appears before you, and the transcript creates an impression of a bit of a potentially, I suppose, without being unfair, and please understand it's a question, I'm not accusing, but it comes across as quite dismissive, especially when somebody's unrepresented. So I would just like to hear your comments on that.
Thank you, Mr. Commissioner Boshoff. Firstly, I've got no independent recollection of this particular matter. I asked my secretary to see if they can draw a file that period, and when the file arrived, my response is accordingly that. Ordinarily, what would happen is that if there is a person or litigant that appear in person, and you're on urgent duty, you will get the file before and go through it. And then you go to court and deal with it accordingly. So I cannot, it might come across as sort of dismissive, but that's not my way of dealing with matters. If that was my way of dealing matters, Commissioner Boshoff, I can tell you now, Advocate for Transformation would not have recommended me or supported me. Neither the 3 female senior counsel would not have put their signatures to recommend me. That's not me.
Thank you, CJ.
Thank you, Mr. Boshoff. Commissioner Gotsa?
Thank you, CJ. I was covered by Mr. Boshoff in part about the remand detainees and the use of AVR. I was also recently at Polsmoor, and I've seen exactly what you've seen, and I'm just interested in, could you maybe just briefly expand on how you will work with the lower courts and the regional court to make use of those facilities in order to deal with the issue of remand detainees faster?
If recommended as Judge President, I will issue a directive in that regard in terms of the postponements, how we can deal with that. But before issuing a directive, I will sit down with all the stakeholders and see how we can deal with it in a more efficient and effective way without transporting all of those people all the time. But there's limitations to all of this, and it's progress. It will be over medium to long-term period to implement it. But it is there and we need to use it. That court was never optimally used. It was always there. But since I took over, it's now being optimally used. It's every term there's a matter down to be dealt with. And may I add is that one of the judges that's sitting there is one of the more experienced regional court magistrates, and she's a female that's dealing effectively in that particular case, in that particular court.
Thank you. And then just to confirm that in Cape Town, we have 2 types of blue light brigades. The one being the one from Polsmoor.
Yeah,
Commissioner Marumagay?
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Initially, I wanted to speak to you about your judgment, Musa versus Hennecker, that was confirmed by the Constitutional Court. But you said something in your vision that really required me to actually focus on those because I thought they were important. The first issue that I want to address you on, or to ask you on, it is the issue of, which is part of your vision, that you want to interact with stakeholders to see how black lawyers can be made part of the system so that they can survive. I think in most instances, the issue of briefing and all the issues that we always talk about in terms of how other people get access to work, it comes across as if we need to do black people a favor, that they need to be made part of. And we end up making the white person who's actually is being paired with a black person to look good. Like, I've done this for this person, I've done that for that person, and I have an issue with that. What are the more nuanced and strategic sort of suggestions do you have should you be successful, even if you don't become successful, that can actually assist within the context of the Western Cape to ensure that the people that you refer to as disenfranchised are actually being made part of the briefing patterns? Business changes its mind, government changes its mind, and when they are paired with wide senior account, they are actually relied on because it's about opportunity. It's not necessarily about people being paid for their fees and all that. It's about getting opportunities and proving yourself so that people can realize that you are good at what you're doing? What are the sort of realizable sort of goals do you have or objectives that you think can be achieved to change the mindset in terms of changing the briefing patterns?
Commissioner, it's a very difficult question, but one can do something about it. As Judge President, you have to have, as I indicated earlier, your finger on the pulse in terms of what's happening within the profession at large. And one of the things that I'm currently doing is to get involved with training at the bar. I do moot courts during recess periods, and particular for pupils that's at the bar. But there is it's an issue that we need to talk about networking as well. It's how do we, that has been previously disenfranchised, network ourselves in terms of showing that we are capable of doing it. Because you cannot just sit and think that somebody's going to knock on your door at your chambers and say, sorry man, are you doing X, Y, and Z? Come appear for me. We need that, and we need to tell our young practitioners that we need to get involved with the organizations. We need to get involved and be more active in that regard. So it's not a case of, yes, a white man, I must now be paired with him and then transfer skills. But it is, how do we also ourselves work the system in terms of showing up, in terms of going out there and tell the people that I can do this. I'm capable of doing it. Give me the opportunity. And I think that is where the involvement of BLA, NADEL, Advocates for Transformation, plays such a fundamental role in that process. I hope I've answered you.
Yeah, no, I appreciate the answer, but there is the issue of touting as well. That might complicate the situation.
Yes, that's what I'm saying.
Let me go to my second question. Should you be successful, you will be leading a division that will obviously and invariably hear political disputes that often have the character of legal something, and you have to deal with those. And there is a sense in the country that, yes, we talk about separation of powers, and we try to explain it, and we try to even teach it in universities. But it appears in reality that there is some level of judicial activism in South Africa, which potentially can turn the country into a judiocracy. What is your view with regards to that?
Commissioner, remember Parliament sits within our jurisdiction. So obviously if there are disputes of Parliament, it flows over to us in the Western Cape Division. With regard to that, it is, we don't ask for matters to come to the High Court. It is when there's a fallout and a dispute, then it ends up at the High Court. But the question in terms of the Western Cape itself, it is, this is the bench. And we have to allocate these matters.
I will leave it there, CJ, because I raised the issue of judicial activism and judiocracy, but I think I will leave it there.
Thank you, Prof. Commissioner Breitenbach.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
If you are successful, you're going to go back to a division that is, in my view, seriously fractured, with many divisions and many problems. Why do you think you can heal those fractures in that bench? And while you're answering that, could you tell me what you think the one most important attribute of a judge is?
Can I start with the last question first? Integrity. That's our currency. Without integrity, that's the core of what judgeship is all about. Honesty, openness, transparency. If a litigant walks into a court, despite that he or she would accept that the person knows and understands the law to resolve the dispute, is to know that this person with integrity will deal with my matter. That is, for me, it's non-negotiable. With regard to your first question, Commissioner, yes, there are fences to be mended. Yes, there are different views and opinion, but there's also an enormous amount of goodwill. I've been in that division, as you all know probably now, for more than 17 years. I've seen that division grow. When I started, it only had 27 judges. It's got now 33 judges. In fact, it needs more. But most of the judges, apart from 5, were appointed after me. If the judges that's going to leave soon, the next 18 months, I'll be in the top 3 in terms of years of experience. I understand the complexities, the dynamics. I understand the individual judges in terms of their personalities. So from that perspective, I will have a deep sense of what it is that might be the reason for whatever differences there might be. And that is why I feel that we need to heal ourselves from inside so that we can contextualize what has happened within that division and have an honest and open and frank talk, which we never had. We never had a session of sitting down and just talking to one another. I think when Justice Malamba was there at one Friday afternoon, it was the first time where a majority of judges were together because case lines are so important. And the laughter, the bantering, it was so good to see that within that division and environment. And it can happen. It needs leadership to do it. And that is what's the position. The reason why we haven't done the talk yet, because there was a view that in this transitional period, let's wait for the judge president to be appointed so we can deal with this in that fashion.
Commissioner JP Malamba.
Thank you very much, Chief Justice. Good afternoon, ADJP.
Good afternoon, JP.
One thing that makes a bench gel, when I say gel, it's like function optimally, is when it is collegiate. You understand what I'm trying to say? When you have a collegiate bench. I see you're not responding.
Oh, sorry, I'm watching you here, so on the TV, because you're so far away, so I'm watching here on the screen.
So I want to understand whether you understand what I mean by a collegiate bench.
My understanding of a collegiate bench is a bench that is collegial with one another, that is understanding the issues and understand what needs to be done, unless I've got it wrong.
And they can work with each other?
Yes, of course.
Am I understanding you to be saying that's not the case as we speak in the Western Cape?
Judge President, I tend to differ slightly. Colleagues are working together.
Yes.
Colleagues are dealing with matters as we sit here, and colleagues are sitting in full bench appeals, in applications, they are working together. There might be colleagues that has got different views and approaches to certain things, but as a division currently, we are working and we are doing what is required. On that score, let me just go a bit further than that. You must remember that the fallout between two leaders affected us tremendously. It didn't only affect us, it also affected the support staff. And we need to build on that. Whoever takes over as Judge President need to understand what really transpired within that division. I, for the first time, when it was Secretary's Day last year, said, the secretaries, we're going to have a function for them. There were some issues about there's no money, whatever. I said, I don't care. We're going to have a Secretary's Day. Because those are the people in the support staff that also got affected by it. We got a Secretary's Day. We had a finger lunch. We bought small little presents for them. Just to say thank you. Thank you for the support. Thank you for being there all the time. And they really appreciated that gesture coming from the judges. So, yes, we are working together, but, you know, there are always differences with judges. You know, some people support guys, and I don't want to make light of it, but we banter with each other in terms of who's winning and who's losing, etc. But the serious differences in terms of what's there need to be unpacked. Because remember, commissioners, names were mentioned within the complaints of judges. And some of them feel offended about it. Some of them feel that, you know, why I got dragged into this mess now? What did I do wrong? And we haven't talked about it yet. So those are the core issues that we need to deal with.
Okay, so what you're saying is that colleagues are working, but more needs to be done to bring it together to be a bench that functions optimally, that understands what it has to do. That's what you say.
I agree with that summary, JP.
Okay, thank you very much for that. Now, my second question is, you and AJP mentioned backlogs. You know, I get worried as head of court when I hear that there are judges who are carrying 3, sometimes more than that, in terms of part heads. You worked in the regional court. I don't know whether you've had occasion to chair a PEEC.
Yes, no,
Have you chaired a PEEC?
I know what you're talking about.
You know what I'm talking about.
Yes.
But the question is, the reason the regional court has a problem is they don't have a continuous roll system.
Right.
At any given point in time, you find magistrates at some stage carrying something like 25 part heads, one person.
Yes.
Now, looks like the Western Cape Division is going there.
No.
That's what we had.
No. Let me explain that, JP.
Yeah.
Before I arrived to deal with the criminal division, there was a project that the previous judge president was dealing with criminal matters. He got a few judges, 4 or 5 of them together, that only did criminal work. So what will happen is that the NPA will, you start with a matter, apparently, that is what I've been told, and I stopped that. You start with a matter. So when there's a delay or there's somebody got sick or they can't continue with one matter, they will bring another matter in, like in the regional court. Because these judges are now going to just do criminal work all the time. But the difficulty with that is the bulk of those 4 or 5 judges are acting judges. And when I arrived and I realized what was happening, you know, those matters were already there as parted matters. So those are the things that I stopped and said, it cannot continue like this. You start a case and you finish a matter. So that perception that we might go to the regional court, not under my watch. But we've got it now. We've got it now. It's old cases that's...
Yeah, am I understanding you to be saying you embrace the continuous role system?
Yes, no, of course. Absolutely.
I see. CJ, can I ask one last question?
Yes, JP.
We put some questions to the AJP, and I'll put it to you because you're part of the leadership as we speak. And this was raised in Judge Ali's memo of allocation of sometimes of complex matters to acting judges. I gave the example of one matter, very involved refugee immigration related matter. That was done by an acting judge. And I asked myself, how does that happen when there's a leadership that must check what's on the roll and check who must deal with it?
Judge President, I've got specific duties that was given to me by the acting Judge President. And one of it, I allocate 2 days of the week, on a Monday and a Friday. I go through the file before allocation. And in fact, it is not uncommon that I will phone the judge first. It happens, I mean, that certain, but not under my watch. And we're not saying, try to blame the AJP here. I mean, she might have had her own reasons. But you must understand that there are acting judges that's coming from the magistracy. There are acting judges that comes from the attorney's profession, and there are acting judges that comes from the bar.
Can I stop you there?
Yes.
I want to hear you tell me how you as a leadership, or if you get the job, how you will address that.
I will address it immediately in terms of, and you must screen the matters, and also in terms of going online, because you must be able to understand the strength of your bench. And the way I will change that is to do the allocations. And I will be able to understand exactly what case is going where once we have our system up and going. And it's a simple system. It's an Excel spreadsheet with all the judges' names on, with the dates. You can see there is case X going to Judge Y. When you pick it up, you can see, but hang on, you know, this is an acting judge. This is a rather weighty matter. So those are the things that I will immediately implement.
Thank you, CJ. No further questions.
President Mulemer.
Thank you very much. Good afternoon, my brother ADJP.
Good afternoon.
I think I must just preface my question by saying, please don't take it in a pejorative sense. I'm just trying to understand something because my understanding is that you have been ADJP for over a year.
Yes.
Am I correct?
Yes.
So you and AJP Goliath, I assume, have been working as a team.
Yes.
And if you were working as a team, you probably had a shared vision about where you want to take the division.
With regard to the shared vision, you must remember that when we discuss issues, there might be some different view and approach. And as AJP, she's got the final say. So if I propose a particular route perhaps, and there's a different view on it, well, her decision stands.
Yes, so are you suggesting that in relation to some of the things that you say were your initiative, like postponement of matters at correctional facilities and so forth, the ones that you managed to get right, she was amenable, and the ones that you say you are still going to do are in respect of matters where she was not amenable?
No, I'm not saying that.
Yes.
What I'm saying is that this is ongoing in terms of the role and the backlog. It is trying to deal with it in a more efficient and effective way. Because, see, left the criminal division in my hands. And I dealt with it in that way. I'm not saying that she didn't approve of it, no. Or that's not her vision at all. I hope I make myself clear.
I hear you. So the flaws or the weaknesses that are in the system are there despite your interventions in relation to the criminal matters, because you say she left them in your hand. So meaning what you are still to introduce is something that you could have introduced before because she left it in your hand.
President Mulder, the issue here is you must remember that we're working with a whole range of factors. It is not just a matter of implementation. It is a matter of getting the stakeholders together with a period of time. And we discussed the issue of, I think it's AVR, with the DPP. But it is a time factor and also a resource factor. There is, the problems that's there is a holistic problem. It's not a problem that's saying you can rectify it overnight or you can rectify it within a month or so. There are all sorts of role players that needs to be involved in that.
Yes. My last question, CJ, with your permission. I'm asking all of these questions in order to try and fairly assess or gauge whether you would be able to implement what you have set out in your vision. That's why I'm asking all these questions. One item that you said is what you can do in the short term is in relation to allocations, and I think when you elaborated on it, you said so that, I'm paraphrasing now, so that allocations must be seen to be done fairly such that no one feels to be overworked and someone is seen walking around the passages as if they don't have work. So my question is, why have you not been able to intervene in as far as that is concerned, as part of the leadership, as the person who has been part of the leadership for more than a year?
Well, that is where the different of approach and views comes in.
Excuse me, sorry. I didn't get that.
That is where the different views come in and approach.
I see. Oh. Thank you, CJ. Thank you, ADJP.
I'm sitting here listening to you, Judge Lecrance, and I just get a feeling, it's just a feeling that you are tiptoeing around issues. You're not coming out clearly, being fully candid about what's going on, and but I'll leave it at that. Commissioner Nkonyan?
Good afternoon, CJ and Commissioners. Good afternoon, Judge Hans. I'm here.
Sorry. Oh, sorry. I was just looking at.
I'm here. Thank you very much for your responses. There's one issue that I would like you to clarify us on. At the present moment, the AJP is the head of court, and DJP, you are the assistant. Assuming you succeed, becoming the head, and she naturally revert to her position. In view of what has been happening in that provision around the issue of unity and cohesion, how is that going to happen? Will that collegiality that we have been asked about before continue or to regress? I just want you to comment around that issue. That's the only question I have.
Thank you, Commissioner. It is not a secret that the AJP will always say, and she mentioned it in the tea room as well in front of other judges, that I've got calm demeanor and a way of dealing with issues on an even-handed manner. And she made it known that she will work with me. But over and above that, you start to learn to know a person if you start working with him. And I just want to address the point what the Chief Justice said, I'm trying to tiptoe around issues. I'm not trying to tiptoe. If that is the impression, then I would like to correct that. In terms of the allocation, it's an issue that has been raised. But it's an issue that, at that point in time, the AJP feels uncomfortable to implement. Why? She's the AJP and she made a decision on that. Because what's happened currently is this. The secretaries come with an allocation note. They write on a piece of paper, they say my judge is available on this and this date. These are the matters. They take the secretary's note up to a pigeonhole. Then somebody collects it from there, write it manually into allocation list. So then you will have a list where you have to allocate matters from. So you look at dates. We've got a matter, you sit with a matter here now, it's for 2 weeks from now. Now you're looking, whose judge is now available 2 weeks from now to allocate the matter. But we don't know what happened in the interim period with a judge that's from a day or two ago, the availability. So in order to avoid that, because now you allocate the matter, the file goes down to the judge phones up and says, but listen here, don't you know that I'm busy on such and such a date? I can't deal with this matter now. Now, how do you address that? It's simple. You put an Excel sheet, you put it on computer, there is the OneDrive system. So when you do all your allocations, within seconds, somebody else can open up their laptops. It's there. They can see it. So it will avoid all of this tension that might be there, or the issue of preferential treatment.
You're doing it again, tension that might be there. Is there tension or is there no tension? Which is it? I can actually feel your pain as you're trying to count your words, and it's so painful to listen to.
CJ, what I'm just saying is that, obviously, if I get a file and it appears that I'm busy, then there is a sense that, don't these people know what they're doing?
Okay.
That's the point I was trying to say. It's that you are allocating matters, but don't you know that I'm busy with another matter? That is essentially what I'm trying to get across.
Yes, Commissioner.
I became confused. In the course of the Honorable Justice answering me, he then come to explain the tiptoeing. And in my mind, he was really tiptoeing around my question. Can it be clear to what I was asking?
Go ahead and put your answer, your question again if need be. I'm sorry for
okay. Thank you, Chief Justice. Judge Lechrans, I was asking you that assuming you are successful and your boss become your immediate subordinate, that is acting judge president, becoming revert to her position as the DJP of that province. In view of what is publicly known, and in view of the stance that I have no doubt you and her have taken to improve the unity and cohesion within that division, I was asking you, will that not affect that if you now change the roles, you become her boss and she becomes your junior, as it were?
Commissioner, the answer to that is no, because she indicated on more than one occasion that she is willing and prepared to work with me as DJP.
Thank you, Mr. Chair.
Commissioner Ngaiton.
Thank you, Chief Justice. Good afternoon, Judge Lekranse.
Good afternoon,
Yes.
Katobi.
Look, just to place it on the record that I've appeared before you several times, and I've never got any sense that you don't know what you are doing. It's always been a pleasure. But I've got a problem with the way you've answered the question around Mrs. Albers, who was not represented. I know that you say advocates have praised you in your manner in court. I could join that list as well. I think your manner in court is very good, but I always, when you read something like Albers, well, is it because I'm an advocate? How does he engage with the unrepresented? Now, I've looked at the transcript of that hearing day. It starts at 9:53, it's over by 9:54. And it starts by you saying, are you the one who was evicted? And then she says, yes. And then you say, well, I'm not going to deal with this matter. I'm going to remove it. She says, well, no, but the magistrate didn't do a proper job. You say, well, let's go back to the magistrate's court and do a rescission. And then she tries to speak again, and then you interject and you say, matter is removed. Now, given the context of that case, that it is an eviction case, Cape Town is notorious for evicting of poor people from housing. Section 26 is a constitutionally enshrined right. It seems that the way you dealt with that case showed a level of impatience. Because she's not an advocate, she's an unrepresented person, and she's being roughed up by the judicial system. So I do want to get a better answer from you, because I don't think you get the gist of the concern.
Commissioner Katobi, I fully understand the question that you raised. And if one look coldly, that impression might be created. But as I indicated to the Chief Justice and the Commissioners before, I've got no independent recollection of this particular case. But that is not my style of working with unrepresented litigants. And if that is the way I operate, I can tell you now that there would have been a complaint about it. If one, and the reason why I refer to the advocates is if you have regard to the comments from the General Counsel of the Bar,
No, I don't have a problem with the GCB. I accept fully. I've got a particular problem with the way you appear to have roughed up an unrepresented litigant on an eviction case about a home.
But as I said, on the cold facts, might have looked like that, but that is not the way I deal with matters. And I will accept your criticism on that.
Then can we move on to another aspect, which also I've got a problem with, and I do need to get some explanation on. The issue about your involvement in leadership, about a year having been an acting deputy judge president, I understand all of that. You've presented a vision that places you as an outsider, but in reality you are an insider. There are 4 issues, well, there are many issues, but let's pick 4 from Judge Ali that she is protesting about. Number 1 is the issue of the abandonment of the continuous role. We asked the candidate before you, the acting judge president. She explained why she's not using the continuous role. Your answer is you want the continuous role to be used. You support it. Number 2, Judge Ali complains about arbitrary allocations, where there is lack of transparency about why allocations are given to certain judges and not to other judges, and which has also caused resentment because permanent judges are being overlooked for very serious and important cases in favor of acting judges. Number 3, minutes are not being kept, so you end up not knowing what was decided. The acting judge president has defended herself on that, about why minutes were not being kept, the matter coming all the way from 2010. And then number 4, it's the lack of consultation and lack of joint decision-making. Now, we put all of those to the acting judge president, but I think that we should also put them to you, because you are also the acting deputy judge president. You're not an outsider, you're an insider. If these are true for Judge Goliath, they must be true for you. So could you just explain, firstly, whether you think the criticism by Judge Ali is correct or fair? And if you think it is fair, why you have done nothing about it for more than a year?
With regard to question 1, in terms of the abandonment of the continuous role, there are judges that's doing criminal matters that has been ongoing for some years. In fact, there's one matter that's going on for 4 years, and the state has not even closed its case. That judge was an acting judge when he started with the matter. He's now a permanent judge. And he, on more than one occasion, came to me. I'm not too sure if he went to the AJP, but he came to me and said, Judge, please, I need some civil work. So what I have done is, when I allocate on a Friday, and there's a civil matter, because we allowed him to deal with that matter, because it's a matter that's going on for some time, for the entire period, because ordinary Fridays are appeal days. If he can do on a Friday a civil matter. So from that perspective, there is then an interruption, because the judge's been sitting for so long just doing criminal work. And he wants to get exposure with civil matters. And he's a relatively young judge in terms of years of appointment. So with regard to the abandonment of the, or let me put it, the criticism from Judge Ali. If one have regard to that, that was discussed in a meeting. And I said to the meeting there, because of judges that are in civil pool, because this is one of the judges that came to me and talked to me about it. He says, listen, I've been sitting in so long in a criminal matter, I want to do a civil case. That because of that, we will allocate civil matters to the judges. And it's not as if you break the entire continuous role. It's an application, a one-day matter. It's not like the person is now have to do a civil trial for 4 or 5 days and then the matter stands over. And it does happen within criminal matters sometimes, that the matter doesn't run for a variety of reasons. Somebody got sick, witness doesn't pitch, etc. And it's in that periods then that these matters can be heard. So that is how I see it from that perspective in terms of the continuous role. But we cannot function without a continuous role. I don't know what the AJP has told this commission, but we need a continuous role as far as possible. Because you can ask any senior judge or judge president, it will cause chaos.
Yes, Judge Lekranj, you know, the real issue I'm trying to get to, it's very unusual for this body to receive an objection from a sitting judge against another judge. It's the attorneys, it's the advocates, it's the clients. But to get something from a judge that says this person is not fit to become a JP is a big thing. So that's why I'm saying we've been debating with the person accused of all of these things. But it occurs to me that we should not let you off the hook because you are an insider. And the reality is, I'm trying to get to whether you think, so it must have taken something very seriously for Judge Ali to come to the point where she's sounding an alarm to the whole country about the state of the division. You are a leader in the division. These things should have been raised internally or maybe were raised internally. The real issue is why have you, as the acting deputy judge president, forget about Judge Goliath, her interview is over. Why have you not done anything to address the problems of one of your colleagues?
Let me answer it this way. This complaint, I haven't seen it. And I haven't seen what exactly Judge Ali was raising with the AJP. But I know for a fact that the issue of the continuous role was discussed in a meeting, and that's how we dealt with it. In fact, it's during that same meeting that Judge Ali was indicated that she's prepared to do a judgment writing seminar for an hour or two for the acting judges. And she did it. I was present when she did that judgment writing workshop with the acting judges.
And minutes not being kept?
The minutes that has been kept, it's a long issue that's coming on for some time. And the AJP has decided that minutes are not going to be kept, and that she made a ruling on it.
And the arbitrary system of allocation where there is no transparent system?
As I indicated to the Commission at large, if we introduce a computerized system, that will fall away.
I understand that, but I'm asking you to account why you've done nothing for a year because you've been in the leadership.
Commissioner Katobi, that is where the different approaches arises. Where you say, fine, look, we need to change this. We cannot continue using the system. It's an old system.
No, I get that. And then the last of the 4 complaints, which is the lack of cohesion, consultation, collegiality, working together in the division. You say that's, well, let me not speak for you, but give you a chance to explain yourself.
I want to say the following, and that is, that's a process that we need to deal with. Colleagues go about their work. We are dealing with our work, and there are interaction. The cohesion that there is, or the differences, we must have more often meetings. Currently, we only have one meeting a term. That is...
No, sorry to interrupt. It's really about why you've done nothing about that issue since you were DJP.
In terms of cohesion of getting the colleagues together?
Yes, the plans you're outlining, which I must confess I agree with. But if you are an insider, you must also account about the time you were there and you did nothing about the things you're promising.
What I can say is that you have to understand that within the division, we've had the occasion of having a farewell for one of our colleagues that retired. All of the judges attended that, his retirement. We had an occasion where we thanked the acting judges that came at the end of the term. The judges were there. And we have our functions now and then, and the judges attend to. That is part of the process.
Thank you, Chief Justice. Thank you, Judge Lagrange.
There's a follow-up question, Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Judge Lagrange.
Good afternoon, Commissioner.
Judge, there's been a common theme throughout your interview, and I'm a bit concerned that you seem to be dodging the issue rather than deal with it head-on. So I want to give you a further opportunity, probably your last opportunity, just to deal with the elephant in the room. I think what we're trying to probe, Judge, is the extent to which, in your capacity as a DJP, you were able to exert influence in order to address all of the challenges that we've heard about throughout the course of the morning.
In terms of me addressing these issues, I have, as I said previously, the fallout didn't only affect us as judges, it also affected the staff. And I was firm about it. Let's get the secretaries together on Secretary's Day. With regard to getting judges together, we've got a functional tea room. And we are having that, and we're trying to arrange, or not try, we did arrange some get-togethers. Now, it's very difficult if judges say, well, I'm not going to come to this function, because you don't know what's the reason for that. It might be, he or she might be busy. There are all sorts of other reasons with it. But as Judge President, and I think this is where the Commission must understand, is that we did not have a talk and a discussion together.
Sorry, please just clarify, when you say we didn't have a talk together, you're saying you and who?
No, as a collective. As judges sitting down and say, look, we need to move on and we need to address, as you put it, the elephant in the room. What causes, what is it that you might feel offended that I did or I say as Judge Lagrange, or what is it that someone else might feel offended about? And the Commission might think I'm tiptoeing around it, but it's not. It is a fact of, and I think that, the Commission must understand, it's not just a matter of walking to a person's chamber and say, listen, why didn't you, what's happening here? Why are you doing ABC or whatever the case may be? I haven't seen you for a while. Why are you so quiet? I chat to judges, and I walk sometimes to their chambers, but it is not the way to deal with it. I think
what is the way to deal with it?
The way to deal with it is to get together in a room like this and to talk about it. Because as I said, CJ, before, the fallout has caused and affected people differently. And we need to debate and talk about it. We cannot just assume these things.
And Judge, why hasn't that happened yet? You're the ADJP, you're saying this is such a necessary event to take place. Why hasn't it happened?
Because of the interim process, because the reason why it's not being happened is there was a decision taken that wait for the JP to be appointed to deal with this. You must remember also there was also the case pending from the previous JP still in terms of challenging a lot of things in higher courts.
Okay. Commissioner Moimang?
You
are covered.
Thank you.
Are you covered? Okay, no, you'll get your turn. Commissioner Moimang?
Thank you, CJ. Greetings to yourself, Acting Judge, Deputy President, the site.
Oh, yeah.
On your right.
Thank you. Just two questions from my side. The first question is whether are judges allowed to protest?
No.
Because of your protest against sitting on an appeal matter, which to me put into question the issues around the commitment, around judicial temperament, commitment to public service. I think the first question that comes to my mind, what was the impact of that protest action on the affected parties, and the extent to which that protest action delayed justice to be discharged. The second one relates to the point that you raised to say, and repeatedly you have said so, that because of different views with the judge, or the acting judge president, this did not happen. So the only question that I want to ask is, upon your assumption of an acting position, because I believe that you are the most fortunate one to have acted for that period. Like now you are still acting, meaning that there was confidence in you displayed by the acting judge president. Now, in terms of key programmatic areas, obviously around strategic level in terms of moving the Western Cape Division forward, emanating from the quagmire that it was facing. Do you want to tell me that we never had a strategic session with the acting judge president to isolate these issues and agree on a common approach to say this is what we are taking to your fellow judges? Thank you, Chief Justice.
Thank you, Commissioner. In terms of the first question, the protest action, I don't see it as a protest action in that sense. I see it in a way of protecting litigants that appears before a court of law that expect judges to behave in a certain manner. Open, transparent, and integrity. And if one have regard to some of the case law, although not on point, it's quite clear that judges can decide not to sit with other judges. But those circumstances are rare, and this one is one of those rare circumstances. The second issue in terms of strategy and of the way forward. The first thing that I said is that we must have a judges' meeting. And I don't know if the AGP indicated that for the first period she acted on her own. But she wanted to show that she can run the division. And that's her decision, because ultimately she is the acting judge president. Now, the strategy of how are we going to deal with the issues at hand? As I indicated previously, I'm not trying to tiptoe about it. The decision was taken in terms of the interim phase of the leaders to postpone that until a permanent JP has been appointed. And that is it, Commissioner.
Sorry,
Follow-up,
whose decision was it to suspend fixing things until a permanent JP is appointed? When there are two people acting and being paid the same amount a permanent JP and a permanent DJP, well, there is one, would be paid to execute these duties for which you are appointed. Who took that decision to suspend the well-being of the division?
Well, Chief Justice, we had a discussion about it.
Who? The entire body of
No, just the two of us.
Oh.
Just the two of us. And that was the decision taken.
To leave the court in limbo while you were being paid to be JP and DJP?
Sorry to interrupt, Chief Justice.
Yes.
My humble apologies.
Please interrupt, because I want to understand.
It is not about leaving the court in limbo. It's about dealing with hardcore issues where the ADJP is also involved. It is about having someone to take charge and ultimately take charge of the division so that this can be discussed openly. And I think the motivation behind that was because obviously the JP had ambition to become the JP.
All right.
Follow-up, CJ.
Sorry,
Follow-up,
Justice, if I can make a follow-up.
Okay.
Look, this is
I've noted you.
I mean, on this quickly, this is what troubles me throughout. I mean, I share the same view by the President of the SA, the Chief Justice, and other constitutions. You were, yourself, you were handpicked by AGP Collegiality. That is, she looked out of the 30 judges or 31. She recommends you to the minister to be appointed as an acting. Is that not so?
Yes, he came to me and asked me if I would work with her. That's correct, Commissioner Tesi.
Yes. Now, having picked, meaning that you are a person, according to her, who fits into her own vision, into her own plan. You sat with her, where she presented to you, she tells you what she wants from you, how you should support. That is, you are engaging. First, you are handpicked. Secondly, she presents to you what is it that you are waiting for in respect of this judge president who was going to be appointed. What is it that you are waiting for? No. Because we are a team that has a mutual understanding. She picked you and we are comfortable to work. What was the problem?
I think Commissioner Tesi must understand that there was certain duties assigned to me by her. Firstly. Secondly, I acted on those duties.
Yeah.
Thirdly, in terms of strategic discussions, we didn't go and strategic discuss in terms of things that we sit in a dark corner and chit-chat. No. It is about how can we stabilize the division? How can we bring and work together? And more importantly is the idea of getting together and talk about issues that is deep-seated issues.
Yeah.
That caused, as a result of the fallout between the two leaders.
Yeah. No, it's fine. I mean, I think I will leave because of just a follow-up. But I just want to leave this comment. First, there is something that you are not telling us. It is something that you are not comfortable to tell us. Because in respect of positive things, well, we are prepared to say, that's fine, and then tell us. But insofar as there are other matters that we don't want to say, well, we are not a decision maker. And the third answer is that, no, you have postponed until a judge president is appointed.
Deputy Judge President, I just want to take you back to the question that was raised by Commissioner Muima, and I think that is where I got a feeling of unease. If I understand this, and correct me if I'm wrong, you were supposed to sit with a judge on a particular matter, and because of a moral call, based on what had transpired with the former judge president, and he said that, the other one said that, you took a moral call to say, look, but I cannot sit on this matter with this judge. Do I understand that correctly? Is that?
I think I might just help you. I didn't say don't want to sit on the matter. I don't want to sit with the judge. The matter, because the litigants have got nothing to do with this. The file was immediately assigned to someone else, without even getting or giving me an opportunity. Let me just place this in context for the commissioners, is that when I went to the judge involved, I said to him my dilemma. It's obvious that the judge then went to the previous JP. And then this file was just recalled from my chamber because I was the sitting judge, without giving me an opportunity to explain.
At the time, you had already taken a decision that you're not going to sit on the matter. In other words, now you are willing to explain why you are not going to sit on the matter. Like, do I understand correctly?
Well, I've expressed my view to the judge as to what I'm going to do. And I was also prepared to write a judgment on that.
All right, no, thank you very much, CJ.
Commissioner Lekhanyan?
Chief Justice, thank you so much. Good afternoon, Acting Judge President Lekhanyan.
Good afternoon.
Acting Deputy Judge President. I just want to take it from where Commissioner J.P. Mlambo has left it. He asked you a question about a collegiate bench, and you responded to it very succinctly. I see here there is a disclosure that you made to participate in an appeal matter with one of your former colleagues or one of your colleagues. and I don't want to go into the merits and demerits. Just to check with you if you think that your refusal to participate in that matter, with the reasons that you advanced, did it enhance collegiality within your division? And I think that in response to that question, you will also do it within the context that it was at the height of tensions and palpable divisions that were there in the Western Cape division of the High Court. Thank you so much.
Thank you, Commissioner. Commissioner, not one of my colleagues came to me afterwards and said that they had a problem with what I've done. In fact, I had the support of 10 other colleagues in this regard, from senior colleagues. Some of them retired, that were judge presidents in other divisions. Some colleague is now in the Apex Court.
Do you have another question, Commissioner?
No. I just want to check with you the manner in which you handled the matter, your decision to refuse to participate. Do you think that was the best option under the circumstances at the time?
Commissioner, let me say this in front of this body. Before taking that decision, it caused me sleepless nights because it was not an easy decision. But I stand by my decision. The integrity of the bench can never be compromised.
Well, he's given his answer, Commissioner. Commissioner Baloi?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes, to go back to a question that was asked by Commissioner Marumakhai, and it was about a discussion about briefing patterns. And I understood you to say that in order to assist with changing the patterns of briefing, your training, and it's about networking and people putting themselves out there. Now, I want to raise the issue with you from a different perspective. It seems to me that the bench should have a different interest to change briefing patterns different from to what my interests are. And different in this way, that the bench is supposed to have a vested interest in training for the future bench. And I was hoping that when Commissioner Marumakhai raised the issue with you, you would answer it from that perspective. What it is, if you were appointed as Judge President, you would do to enhance or to assist with changing the briefing patterns so that the bench of the future benefits from that. We've heard from the AJP that she's had to import people from outside the province because, in her words, I think, there aren't, because she couldn't find enough or at all capable black women, African women, to act, and she's had to get them from outside. Now, I would like to hear your thoughts about what it is you, if you have thought about it, you would look at doing in order to correct that, of course, in the long term, in order to have options at choosing people for your bench.
Thank you, Commissioner. Ongoing training is vital and important. But more particular, the ongoing training must be to that extent that it also fill in the gaps. And as, if recommended as Judge President, that is one of the things that I would look at. As the Commission will probably know, there are various training programs by SAJE for aspirant women judges, ongoing. And that is to be supported in that regard. The role that I'm currently playing, in the meantime, for being on the bench as a leader, is to actively get involved with the moot courts, whether it's from the bar, whether it's from students, whether in fact, we were at a meeting with UNISA some time ago, where this particular same issue was raised. And we said to the body there that they must come and tell us what it is and how we can help them in that regard, in terms of continuous training. Because, as we all know, that UNISA is part-time studies, and we engage with these bodies on a regular basis. So that is definitely where I'm sitting currently, an issue that I will deal with. And not only in terms of the advocates, etc., but also the magistracy. I go out with regard to training for the magistrates as well. So there's an ongoing process that we have to deal with.
Thank you, Suja.
Commissioner Mangen?
Chief Justice, adequately covered by Commissioner Baloyi and Commissioner Mwima.
Sorry?
My questions were adequately
Also, you've been
raised,
covered.
yes.
Thank you, Commissioner. Commissioner Nokes, you asked a follow-up
Chief
question.
Justice, I've been covered.
You covered, okay.
Yeah.
Commissioner Steinberg?
Sorry, I'm taking you back, Chief Justice, because it was a follow-up from much earlier. I want to ask you what your position is on the taking of minutes at judges' meetings. What do you think is proper?
Sorry, can you just repeat that, Commissioner?
What is your position on the taking of minutes at judges' meetings? Judges' meetings? What do you think the proper procedure should be?
I've got no difficulty with that. I mean, if we can have a recordal of what transpired and the important decisions we take, it can only benefit the division. We can always go back and say, but listen here, 3 months ago we decided this, why have you changed this? It's accountability. It keeps us accountable as leaders. So, and it should be. I mean, as a leader, you want to be accountable. Somebody must say, but listen here, you decided that 2 weeks ago and you just now decide something else. How can you do this? On what basis can you do this?
So in your position as acting DJP, did you raise that issue squarely?
I was not in that meeting when it occurred. I was on circuit, Commissioner.
But
I mean, that is...
Why did you need a meeting to raise the issue?
No, I raised it. I raised it.
You raised it with the acting JP?
Yeah.
And what was her response?
Because he don't want minutes to be taken.
Excuse me?
No minutes to be taken because that has been... apparently, according to her memory, and I'm speaking under correction here, when she was appointed as a judge, she took minutes. And then there was some story about someone else must take over the minutes, and then there was a decision that the minutes shouldn't be taken.
So you're saying this is one of those issues where there wasn't anything postponed, you had one view, the acting JP had another view, you squarely raised your view that this is important for accountability, but she declined to implement it. Is that what you're saying?
Yeah.
Thank you.
Did you say yeah?
Yes, sir. Sorry.
Okay. I'm hard of hearing, sorry. Commissioner Hassan?
Thank you very much, CJ. Potential follow-on, but maybe a little bit different. Just to clarify, to preface my question, acting DJP, how long have you been acting in the position?
Since April of last year.
April 2023?
Yes.
Perfect. I'm interested, and it's an interesting point because it would appear that you've been the only candidate that's acted in the position of DJP. And I'm interested to know about your thoughts around leveling the playing field and giving exposure and opportunities to others, whether you have ever raised with the acting JP that others should also be given an opportunity to act in your current position. Let's start there. Have you ever raised that?
I raised it squarely.
So you have raised it
I
with...
raised it with a...
All right, and what was the response from the AJP and your subsequent, I would think, response to that?
Subsequent response was she found it difficult to work with any of the other senior judges for reasons that she advanced. And she's of the view that with regard to my temperament, the manner I deal with issues, she feels more comfortable to work with me.
Okay. Thank you, CJ.
All right. Thank you very much, Judge Lekranse. We've come to the end of your interview. You're excused.
Thank you, Chief Justice.
All right. We take a quick lunch. It's 10 to 3. Come back at 3:30. Well, come back at 3:20 so that the candidate can be called and we ready ourselves, and at 3:30 we interview her or him, her. All right.
see you. Thank you.
Good afternoon, Justice Pokoane. Mabindla Pokoane, sorry.
Good afternoon, Chief Justice, and good afternoon to the commissioners.
We are sorry to have kept you waiting all day, but it's just one of those days. You don't have luck, it seems.
Not a problem, Chief Justice.
How are you?
Very well, thank you, and how are you?
Fine, fine, thanks. All right, are you comfortable over there? Is that
I
a
am,
nod?
Chief Justice, thank you.
Okay. Justice Pokoane, just forgive me. Well, you've always said you don't mind being called one or both. Both are your names, so
Yes.
I'm saving time. Your name is too long.
No problem, Chief Justice.
You obtained 2 degrees from the University of Wits.
That's correct, Chief
In
Justice.
1996 and 1998.
Yes.
What did you do thereafter? Just briefly, in your own words.
After that, I completed articles at Denise Rates Attorneys, and thereafter I went to join Sampson Oaks Higgins Attorneys as an associate. While I was there, I was headhunted or asked by Anglo Gold Ashanti to join them as a labor lawyer or as labor law counsel for the also were part of the negotiation team that negotiated and involved in collective bargaining with the trade unions. At the time, the Mine Workers Union, National Union of Mine Workers, Solidarity, I think, and UWASA, those were the main trade unions at the time. And so we had to do a lot of labor relations between the unions and the company and advising the company as such. And we also represented the company. When I say we, it was myself and the colleagues that were in the department. We represented the company at the Chamber of Mines, which is an association where the mines were, and they would devise national policy for the mines and also negotiate at that level with the trade unions on wages and all those things. I was also in charge of giving opinions, legal opinions on employment matters, and also interacting with lawyers outside because I was in-house counsel. I would also appear at the CCMA in the labor court because that was allowed, being an employee of the company, representing the company, to do so. So that generally was my role. And I also was in charge of devising, if I can recall, the disciplinary code and procedure of the company, as well as the anti-sexual harassment policy of the company at the time, and went
we did road shows and workshops in different regions and mines. So in a nutshell, that's what I can say. Oh yeah, while I was there, I think it's important to mention this, I was asked to be a trustee in the board of the Mine Workers Provident Fund, which I chaired a few years or a year later, if I recall. So being a chair of the fund, I would collaborate with administrators, with asset managers, and a whole host of stakeholders that had a relationship with the fund. And I also got to be involved in the Institute of Retirement Funds when I was there as well. That is, as a board member. The Institute of Retirement Funds is an institute where retirement funds, administrators in the country collaborate, and I was part of a number of committees in those structures.
Either as a member or in the executive?
Yes, either as a member. And also, I forgot to mention SASLO, that I was in the National Executive Committee of SASLO. I was elected there when I was still at Sampson Oaks Higgins Attorneys to be in the National Executive Committee of SASLO, and I was there for a number of years, and I became the vice chairperson of the Gauteng chapter at some point.
Yeah, I count 11 years of your involvement with it.
Yes, it was a long time.
All right. Then you decided to strike it off on your own.
Yes, then I ventured on my own. I think like many young people do. You go and venture and try things and see how it goes. And when I went to Port Elizabeth, I started a company called Lwazi Consulting. In fact, its full name was Nolwazi Investment Holdings, trading as Lwazi Consulting, because as a startup, I would do something that I was trained to do, which is to consult on employment matters and do training for companies. And also at the same time, I was in the panel of Dogiso. I'm sure a lot of people know Dogiso dispute settlement. So we would get drawn from the panel to go and arbitrate matters, to mediate, to facilitate whatever that would be needed at the time by the clients.
That didn't last very long. You started another enterprise, Hluma Business.
Yes, I had a collaboration between myself and another partner. We started Hluma Business and Labor Services. We did similar work, but my partner was more human resource inclined. And so he devised policies for clients on that line. And mine was the labor side of things. But because of his illness, we couldn't continue with the firm. Then I had an appetite of wanting to go back to practice and focus on pension law and no longer labor law this time, because that's the area that I was now involved in.
Mm-hmm. So you joined TIPA Incorporated Attorneys as director and senior attorney?
Yes, director and senior attorney, and specifically formed a company, a branch of the company in Port Elizabeth, which I led and focused on, but I was in charge of the litigation for the entire firm, because we had 3 branches. We had the main office in Johannesburg, because this is where most of the pension funds and administrators are located, and also in Cape Town, because that's where others are. And so we had Johannesburg, Cape Town, and the little branch in Port Elizabeth.
All right. Then you were lured to the bench.
Yes, one day.
When?
One day in 2011, Judge President Mlambo gave me a call and asked me to come and act at the Labor Court in 2011. I think it must have been September or so. I can't recall.
And the rest is history.
The rest is history. Yeah. And then I went to the High Court.
You acted at the Labor Court?
Yes, acted at the Labor Court. I think the last quarter of the last term of 2011. Then I was called again to act in 2012 from the second term, if I'm not mistaken. And then directly from there, I was called to act in the High Court. So I acted in the High Court right through from January 2013 until I was appointed on the 2nd of December 2013.
And at some stage, you became involved in the competition appeal court.
Yes, I became involved in the competition appeal court. In 2015, I was asked by Judge President at the time, Dennis Davis, to go and act in the competition appeal court, and I was appointed by this body, recommended by this body in 2016 and appointed in 2017.
And I recall that the vision was for you to take over that court as its judge president when Judge President Davis retired.
Yes, I was
until the
told.
SCA poached you.
Yes, I was informed of that.
So how long have you been at the Supreme Court of Appeal?
When you called me, when you were still the Chief Justice as president, that was from the 1st of April 2020. Then I continued to act until my appointment on the 1st of July 2021. So I've been there for 4 years.
And apparently you've done so well there that right at the moment you were busy filling in your JSC questionnaire for this position, the former Chief Justice was contemplating inviting you to go and act at the Constitutional Court, but we'll get back to that. You've written a number of judgments as a judge in all these courts in which you've sat.
Yes, Chief Justice.
About how many would you say on estimate?
You mean all judgments?
All your judgments.
The ones that I could locate, because I traditionally would send my judgments to sub-plea, although that was not something that was done as a matter of course in the High Court. Judges choose whether or not to send the judgments there. But so I was able to locate about 163, I think. I can't remember, but I put an annexure in my questionnaire, Annexure C and Annexure D. Annexure C deals with the reported judgments in all the courts, and then Annexure D deals with all judgments that I could locate.
How many of those reported? Doesn't have to be an exact number.
40 something.
Right.
43 or, yeah, I think.
Okay.
And I saw 2 more after I had handed in my application that they were also reported from the SCA.
How long were you a judge at the Western Cape Division of the High Court?
I was a judge there for 7 years, Chief Justice.
Okay. Your career trajectory has been it's a strange one. You were offered a leadership position at the competition courts, and you chose to go to the appellate division, the Supreme Court of Appeal. Now you had an opportunity to go to the Apex Court, well, albeit in an acting stint, and you decided to go back to the High Court. That just makes sense to me. Why would a Supreme Court of Appeal justice, one doing well for herself, want to go back to the High Court, to a seemingly, well, not seemingly, to a troubled division at that?
I know.
Why are you applying for this job? Is what I'm trying to get from you.
Thank you, Chief Justice. I will give an honest answer. I was actually nominated for the job, and the approach came to me as a surprise, and because I was still minding my own business, doing my work, being comfortable at the Supreme Court of Appeal. But I took to heart the confidence that was shown to me by those that nominated me, and I reflected on it, that they saw something in me that at this moment in time, you have something that we think can be valuable for you to contribute in the Western Cape Division of the High Court. And since I come from that court and are very much close to it, it is the court from where I come, I decided that I'm going to accept this because I believe that being a judge is an act of service. And so you serve as a judge. In isiXhosa ndiya apho ndithunywe khona. Loosely translated, I go to where I'm sent.
All right. That's a nifty answer. Okay. Now, Are you not worried that if you go back there, although you spent all those 7 years in your previous life there, you would practically be coming in from the cold? And how do we know that your appointment would not cause resentment and perhaps meet with resistance?
I'm not new in the court, Chief Justice. I know all the colleagues in the court. In fact, even the ones that were appointed after me, I had an occasion of interacting with them at the personal level. And I can safely say that a number of colleagues have actually called me and they've said to me, we are behind you and we are supporting you. So I know that there would be no resentment whatsoever when I go back to the court. And I kept in touch with the colleagues. I'm not new, and I don't think they see me as an outsider per se, because the time that I've spent away from the court is not too long. It was only 4 years. And I think that, Chief Justice, while we're there, I think as a person who has been outside of the court and now coming in, I would be bringing a fresh perspective and the manner and the way of seeing things in a new way, because I'm not too close to things that are happening there. And sometimes when you're not too close, you have a broader view of things.
All right. I don't know if you have a vision for the court if you were lucky enough to get appointed. What do you know about its current condition, and what plans, if any, do you have for it?
Thank you, Chief Justice. I have put my vision down, and if you would allow me, I'm going to read my vision.
Okay.
Thank you. My vision for the Western Cape Division of the High Court is first to ensure that we serve litigants and the public as our constitutional mandate requires of us. This means working to cut backlogs, making court processes easier, continuing to make the court accessible, and improving the court experience for its users. Secondly, it is about us who work in the building, the judges and the court staff. I want to cultivate or enhance a culture of collaboration, collegiality, openness, accessibility, and efficiency. It is to contribute to making that court a united and a transformed one, which would provide quality justice to the people of the Western Cape. Thirdly, is about collaboration with the stakeholders who are the users of the services of the court. Fourthly, working with the magistracy. Section 8(4)(c) of the Superior Courts Act provides that the judge president of the division is also responsible for the coordination of the judicial functions of all magistrates' courts falling within the jurisdiction of that division. So my presentation touches on these aspects. Why I accepted this nomination? This is the first time in 23 years that a new leader for the Western Cape Division of the High Court is being considered. When as I've said, Chief Justice, when calls came for me to make myself available for nomination for the position of Judge President, I heeded yes after some long and hard deliberation. This I did because I took to heart the confidence that those who approach me have in my abilities. I was humbled by that. I believe that I'm suitably positioned to lead the division and to set a vision for its future. I want to be part of building on the gains that have been made and facilitate any changes necessary for the well-being and development of the division. That court is where I learned most of what I know as a judge today. It is very close to my heart. I literally grew up there. I do not come as one with all the answers, but as one who would like to be part of the collective that will find solutions and cultivate a new culture. Before I went to the division in January 2013, I was warned about how difficult the place was and how I would be unsettled by the environment as an outsider who had not even practiced in that division. When I got there, I was warmly welcomed by all the colleagues in the division. This is partly due to my personality, I think. I have always enjoyed healthy relationships with colleagues. Like other workplaces, there were challenges, but at the heart of it all, no matter their differences, colleagues in the main worked hard. They were respectful and committed to the delivery of justice. They would not let their differences affect their public duty, which was to hear matters and deliver judgments. As someone who has been in the division, who had been in the division for 7 years and outside of it 4 years. I believe I have a unique set of both experience and skills to lead the division into its immediate future because I have an objective perspective about its present circumstances. I'm not new to leadership. Currently, I'm one of the 2 judges serving in the Rules Board as its vice chairperson, who together with the chairperson are responsible for leading the board. The Rules Board is a body that is charged with making rules for almost all the courts of this country. I'm also one of the 6 judges who are currently members of the Judicial Conduct Committee, a structure that oversees discipline amongst the judges of the highest courts in the country. Apart from the Chief Justice and the Acting Deputy Chief Justice, I'm the only other judge currently in service in that committee. I would like to think that I was appointed to these positions because I have leadership qualities. I'm a presider currently at the Supreme Court of Appeal. A presider is a senior judge who manages several matters allocated to them and other judges in a term. Members of a panel usually include acting judges. The presider not only directs the proceedings in court, but provides guidance on the approach to be taken in matters and assists junior and acting colleagues when consulted on substantive issues. Before I became a judge, I served in various leadership positions in the legal profession and in the society at large, as I've mentioned to the Chief Justice, including the South African Society for Labor Law, the Institute of Retirement Funds, Mine Workers Provident Fund, Vision for Women, which is very close to my heart, an organization in Port Elizabeth that inspires, mentors, and empowers young girls and women to know that they can be something better in life, and other bodies. I also manage a company that I was part of, and as well as a branch of a law firm of which I was a director. I also did management and leadership courses early on in my career. All that is in my CV. One of my other unique skills and experience that I would bring to the court is an emphasis on thought leadership, which would help strengthen the jurisprudence of the court. I've had the unique privilege of having sat in 4 different courts, including the appellate courts, the CAC, and presently the SCA. The advantage of sitting at the appellate court is interaction with colleagues who come from different divisions around the country. With this experience, I will bring a broader and a richer perspective. At the SCA, we sit in panels in every matter, where one learns to respect and accommodate other views, and where we cannot find each other to disagree without being disagreeable. As a judge of almost 11 years and 13, including my acting stints, I have been a hard worker, and I believe I have a strong work ethic. I've led from the front in leadership positions I've held. I've never shied away from challenges. I've written judgments in complex matters, even as a junior member of a panel, in the High Court and in the appellate courts. I've also shown my independent-mindedness in that where I differed with colleagues, I would write separately, no matter how complex the matter was and how much time the research it would involve. At the SCA, I've had exposure and engaged in complex legal issues across the spectrum. Since 2020, I would have participated in approximately 10 to 12, sometimes 15 matters in a term, on average, translating to about 160 or more appeals up to date. The division is uniquely placed. It is in the province where the national legislature seat is. This presents it with an opportunity of nurturing the talent and cultivating strong jurisprudence in areas of administrative law and constitutional law. I would encourage continuous learning in the court by promoting the culture which I found when I first went there of senior colleagues assisting junior members. I would advocate for a structured induction and mentorship program to assist acting and new judges. In reviews, the division has always had a practice of having 2 judges sitting together. This can be a platform to pair a senior colleague with a junior one, for transference of skills so that the inexperienced judge is not thrown into the deep end. I'm aware that there are two senior judges at the moment who had held workshops with acting judges. We will build on that. The division could have a judicial education committee like the one in the Gauteng division, which develops a program per term by promoting peer learning workshops every Thursday lunchtime on topical issues. I know that the division has colleagues. I know that the division has colleagues who have vast experience in specific areas of the law. I would identify their strengths and weaknesses. with a view to utilizing their expertise in the areas of strength, but also to balance the allocation of matters so as to expose all colleagues to a wide range of cases in order to build capacity for the court to the advantage of the litigants. My focus will also be on enriching our judgment.
Where is this document? Do we have it? No. Oh.
No. Should I continue?
I thought. Huh?
Sorry.
I thought do we not need it?
Well, I've been listening very intently, so we can ask.
Yes, I can share the document afterwards.
Yeah,
I was
please.
not asked to make it available.
Yeah, Mayor Kulpa, well, we didn't know you were going to read the document, so.
Okay.
Yeah, no, but you can make it available to us as
Yes,
soon
I
as
will
you
do
can.
so. Can I continue, Chief
Yes,
Justice?
please.
Okay. My focus was on this part, that my focus would be on enriching our judgment writing skills with an understanding that while judgments are primarily written for the litigants, they may also be precedent setting and they are also used as teaching tools. The division has been for years circulating a list of reserved judgments, which works successfully to get judgments done. This is useful in keeping a watchful eye on bottlenecks and delays to ensure that judgments are delivered timeously. I would identify reasons for late delivery of judgments and find ways of assisting colleagues who have challenges as part of ensuring our accountability to the public. I would encourage colleagues, as I've said earlier, to upload judgments to SAFLI, as that is not consistently happening, and prepare media summaries for all important judgments. Transformation remains a key discussion issue for the judiciary. Western Cape has unique challenges on this aspect in both the legal profession and on the bench. Many Black African judges who became judges in the Western Cape did not practice in that province. The majority came from the other places. Now I'm including those that also have retired. Currently, there are few Black and women senior advocates at the bar, only 2 Black African men and no African woman who is a silk when I last checked the website. The tennis profession suffers from the same lack. Commendably, very good Black African judges have been drawn from the magistracy. This is a good balance and shows that one need not only look at the practitioners. I would do my homework to also draw acting judges from the academia in the province and from elsewhere in the country. Transformation and excellence are not mutually exclusive concepts. They must go together, given our unequal past. While we transform, we must mentor and develop skills in a structured way to get us all to the level that benefits the litigant. The immediate challenge in the division is working towards change in how colleagues relate to one another. We have to work towards creating a culture of openness, transparency, and cohesion, where we would build an environment of trust. I hope to provide leadership that is attentive, felt, visible, accessible, and collaborative. My role as a leader is to help others to do their work to the best of their ability. How will I facilitate this? I will visit each colleague in their chambers. I know this sounds simple. I will visit each colleague in their chambers to find out what the issues are, to open communication channels between the head of the court and the colleagues. We are human beings before we are judges. I would then encourage holding a boss parade, maybe with a facilitator, to talk about issues faced by the division. My hope is that in those conversations, we'd be able to carve out a vision for the future of the division, short term, medium, and long term. We would hold regular judges' meetings to ensure feedback, transparency, and accountability. I would like us to work as a team where colleagues are part of the decision-making process and the administration of the court. Involvement in committees is one way of achieving that. I'm aware that there are committees in the court currently, some more active than others. We would review their effectiveness with a view to enhancing them and creating more participation. I would suggest the creation of an elders type of committee, which can be made up of senior colleagues, including the judge president and the deputy judge president, or the chairs of committees, or any other formulation that colleagues may find suitable. This committee would discuss matters that require attention between the plenary judges' meetings. It may also advise on acting appointments, for example. I would also meet regularly with the court staff, as they are the backbone of administration. Collaboration with the chief registrar, court manager, and the provincial head is important. Courts are facing various challenges at the moment, central to which are shrinking resources, which affect the turnaround times for service delivery. The court does not have enough personnel in the registrar's office. It has lost a lot of personnel, and they are not being replaced. Interpreters resigned in numbers after lockdown. This leads to postponement in criminal trials. Backlogs in criminal trials remain a big challenge facing all the courts. As we heard when the former Chief Justice gave statistics in the Judiciary Annual Report for the period of 2022 to 2023, targets in all divisions were very low at 30%. Although many divisions outperformed their targets, the Western Cape sitting at 58% of finalized cases for that period, backlogs remain unrelenting. Case management in criminal matters has been in place in the division for many years. There is, however, an increase in criminal trials. Even when certified trial ready, they cannot speedily be heard or resolved. So collaboration between the leadership of the court and the DPP's office to manage this is key. There must be discussion as to which matters should be coming to the High Court and when for proper planning. In turn, the operational consultations between court administrators, their operational counterparts at the DPP's office, as well as the police regarding operational matters in preparation for criminal trials should be installed. Collaboration is also required with the legal aid to streamline their decision-making processes when considering applications. As regards civil matters, judges are involved in case management and pre-trials are held every second week. I was part of that when I was there. There is a significant increase in CRASA matters, and we know the big elephant in the room are RAF matters and the creeping increase in medical negligence cases. And in my view, heads of court should engage with the RAF to find ways on how it can improve in bringing matters to court. The earliest dates available for allocation in civil trials, I was told, is in August 2025. The earliest date available for semi-urgent is in January 2025, but there are those set down for March 2025 as well. For opposed motions, matters are being allocated for February 2025. Case flow management remains the most effective way of weeding out matters that should not go to trial early on. But this must go hand in hand with mediation. Mediation, as you would have seen in my CV, mediation is very close to my heart. I'm one of the 7 judges who were sent to Utah to be trained as a mediator and as a trainer. We came back and conducted various workshops for judges, magistrates, and traditional leaders via SAJE, which was well received and well attended. Colleagues were given some practical tools of how they would conduct mediation. The idea was not to have judicial officers mediating all matters per se, but to sell mediation as an effective tool of resolving disputes, to equip judges with skills they could use in case flow management, and to encourage litigants, where appropriate, to opt for mediation. Mediation offers a lot of benefits. It is cost-effective, it may lead to speedy resolution of matters, and the solution comes from the parties themselves. Modernization and digitization will go a long way in helping with court efficiencies. Judges and court staff have been trained on case lines, and I was trained on case lines twice at the SCA, and I'm made to believe that the division is ready for the rollout. And that there will be a self-help facility that will be put in place in the court for those that cannot upload in their homes or in their offices. The rollout of case lines means traveling to court from faraway places to file documents will be a thing of the past. Judges and practitioners will have access to documents online wherever they are and in court. The system will also help with the archiving space, which the court is currently struggling with. Litigation is expensive. As part of enhancing access to justice, I would move for the creation of a pro bono desk manned by lawyers on a weekly basis, particularly for unrepresented litigants in motion court. I will collaborate with the legal profession on how this can be formalized and even recognized as pro bono hours for the benefit of participating practitioners. I will collaborate with the legal profession to listen to their concerns as recipients of our services and on ways of improving our systems. Circuit courts are key in bringing justice to the people. Ways in which we can make them more effective and accessible will be looked at. I would also look into the proposal by the Rationalization Committee, which I saw in the document, to make Thembaletu Circuit Court a local seat. I would interact with the magistracy to address issues beyond reporting at the PEC. There are several challenges that need attention. For instance, the method of how posts are created in the Regional Magistrates Court is outdated. It was last reviewed in 2008. Regional courts are centered around the city and bigger towns. So regional court magistrates in those areas are expected to service other areas which are not as small as they were in 2008. For instance, a magistrate from Cape Town would go for only 5 to 10 days in a month to Hermanus, which has about 200 criminal cases. Why can't a post be created in Hermanus, for instance? Hermanus is not the only place, there are other places as well. The attainment of a single judiciary is imperative. The magistracy needs to be supported by the judiciary beyond case flow management and coordination of statistics. I would add my voice to the calls for full institutional independence for the judiciary and the better resource judiciary. Thank you, Chief Justice and Commissioners, for listening to me.
Thank you, Justice Mabintla Pokoana. That's a lofty and all-encompassing vision, I must say. But have you been, well, you've given us a lot of intimate detail that seems to suggest that you've been in touch with the court.
Yes, I have.
To get an accurate sense of its state.
Correct, Chief Justice. I was in touch with the court administration to get correct information as to what is the state of affairs with regards to court administration. I also was in touch with colleagues in the division just to put me up to speed because it was necessary for me to have those details for the purposes of understanding what the current circumstances in the division are.
Okay. You do many things, and some of those holding the position of Vice Chairperson of the Rules Board for Courts of Law.
Yes.
And you're also one of the 6 members of the Judicial Conduct Committee of this body.
Yes, Chief Justice.
Okay, well, you mentioned mediation as one of your passions. You did not mention that you also train judges.
Yes.
You have trained and trained judges in cybercrime and competition law as well.
Yes, when, I think that was a few years ago, before there was still a cybercrime bill at the time, and there was a European team that came, I just can't remember their name, that they came via Sajay, and they trained judges as trainers, and then we had to train other judges, or at least sensitize them, maybe not train, but sensitize them about cybercrime and what it is all about.
Right. Well, it's impressive that all the professional bodies support your candidature, and they speak very highly of you. The GCB saying you have a reputation for integrity and ethical behavior, and you are a well-respected judge in the Cape Division, especially among practitioners, so that's quite a compliment.
I'm humbled by that, Chief Justice.
Yeah. All right. I will leave it here for now, Justice Mabintla Pokoana. Judge Gamble, do you have questions for this candidate?
Thank you, CJ, and good afternoon.
Good afternoon.
Former colleague, if I may say, Judge Pokoana.
Good afternoon, Judge Gamble.
Your list of judgments is impressive, to say the least.
Thank you.
You've covered all areas of the law. My eye falls on matter number 28, called the Polaris. Do you remember that matter?
I remember it.
We had an interesting discussion about it at
Yes,
the time
I
because
remember.
it was a shipping case that crossed over into business rescue.
That's right, yes.
And I see that you say that that's been internationally acknowledged now.
Yes, I actually stumbled on it sometime on a publication that was done, and I was interested and I read it, and I found that in fact it was a subject of the publication because it talked about the intersection between company law and
shipping law.
Yes.
And for those who don't know, Cape Town has a very busy shipping practice. The
That's
Cape
right.
and Durban courts do a lot of the shipping matters.
Yes.
I dare say this is one of the first judgments written by an African black woman on shipping law, and that was quite a ceiling to break through.
Oh, I didn't know that.
Judge Bukwana, the question that I and many of your colleagues are asking is why are you moving south rather than north?
I think there's a pool.
And I ask it with respect
Yes.
for the following reason. Your acumen lies in research and strong judgment writing. You occupy, I think, a fairly senior position in the SCA now, and you've led panels there. That court is going to be depleted. But many see your future in the Constitutional Court. Do you have any long-term goals in that regard?
You know, Commissioner, it's very difficult to actually answer that question at this point in time because 3 years ago, was it 3 or 4? 3 years ago, when I sat on this chair, I did not know that I would be sitting on this chair again today. But one thing I can say is that I'm committed, were I to be appointed in the High Court as a judge president, to stick around and stay in the High Court because one thing I can commit to is that I will not abandon the court because I'm committed to making sure that what I envisage myself doing and contributing at the court is brought to pass, and I can see it being successful.
If I look at your personal details in paragraph 4.1, you just 51 years and some months, and you will have completed with your appointment, if you're successful, just over almost 11 years. You would then be entitled to exit at 65, would you not?
Yes.
Because you will have done 20 years. So the minimum period that you would be in the court would be 13 years?
Well, for me, I don't look at 65 for now because I'm not about to retire, so that's not even something that I'm thinking about. So when I think of retirement, I think 70 somewhere down the line.
Let me assure you that when you get to 64 and a half, you'll be thinking very seriously about the 20-year option. But jokes aside, you could exit after 13 years.
Yes.
Failing that, you would have been in the position for approximately 18 years. That's
Yes.
if you went at 70,
Yes.
which is the maximum
That's right.
period that you could. During that time, you are going to be involved, as we've heard this morning from the other colleagues, in a considerable amount of administration work.
Yes.
And my concern is that we will lose your contribution to the jurisprudence because you're going to have a lot more on your plate. Obviously, you will go in and sit in the big cases.
That's right.
That's what judges president should do.
Yes, and that's
They
what I
haven't
would
always
like
done
to
it,
do.
but they should do it. They should go in
Yes.
and lead the judiciary on the jurisprudential side.
That's right.
And that would be my concern, and I'll give you a chance to think about it. That you're going to lose we're going to lose your contribution to the jurisprudence at the cost of administration and fixing broken toilets and things like that.
If you've seen my path, Commissioner, as we were discussing with the Chief Justice, I consider myself an all-rounder because I didn't just go and practice law. I did a lot of things, and that makes me a person who's actually well exposed into many things. I don't see being a judge president as administration in the sense of doing, small things and tasks like that, and maybe allocating matters and all that. I see it as a broader thing because it is a leadership position where you set the tone, not just for the court, in how the culture, yes, the jurisprudence, also the province because you take along the magistracy with you. So it is a position that is broader than just administration.
And then, excuse me, lastly, you will inherit, and if you get the position, you will inherit an incumbent deputy.
Yes.
Who has been in a leadership position as a deputy for 8 years, I think, 7 or 8 years.
Yes.
And in a leadership position for 2 years. Do you foresee any problems between cooperating with Deputy Judge President Goliath if you get the position?
Not at all, from my side, definitely not, Commissioner. I've known Deputy Judge President Goliath for a long time, since I was in the division for 7 years. And I've had a number of interactions with her, and I respect her. I think that the position of the Deputy Judge President is an important position because it is not only a supporting role to that of the Judge President. The Deputy Judge President has tasks that are generally allocated to them by the Judge President. But besides that, when the Judge President is not available for whatever reason, the Deputy Judge President does the job. And so it's important that we work together effectively and in a matured way. And that is something that I commit to do.
And there are no issues between them?
There are no issues between us.
Thank you. Thank you, Judge Bukwana.
Thank you.
Thank you, CJ.
Thank you, Judge Campbell. Mr. Boshoff?
Thank you, CJ. Good afternoon, Judge Bukwana. Right here.
Oh.
At the risk of I don't want to repeat Judge Campbell's questions to you, but so a friend of mine once said to me when I was bemoaning my career path, etc., he said, you know, sometimes choice is a curse as well. And I just want to inquire a bit about your career path and your decisions in your career, and please see it as a compliment because clearly your membership of the judiciary is something we should all be very grateful for. The world is your oyster, so to speak. Now, you mentioned that there was a potential, possibility for a leadership role at the Competition Appeal Court, but that was then overtaken by your current, the opportunity that you then pursued at the SCA. May I ask why, and is my suspicion correct that the SCA was seen as academically a bit, more challenging and satisfying potentially? Or what informed your decision to, instead of pursuing a leadership role at that position, at that point, to pursue the opportunity at the SCA? And then with regards to now, the potential for, within the near future, opportunities at the Apex Court arising, what then informs your decision to rather pursue here? Because, and this brings me back to choice being a curse, whatever you were to pursue, I'm sure you would succeed at. And with a potential career span of 18 years still ahead of you, what assurance do we have that 5 years from now, you won't be sitting here again, or in 3 years from now, for an opportunity at the Apex Court?
Okay.
And that's just within the context of a division that really urgently requires long-term stability and long-term commitment. Thank you.
Yes, thanks. Let's start with the first question about the Competition Appeal Court. There were no firm discussions at that time between myself and the Judge President, Dennis Davis. It was just a futuristic thing that this is something that he would like me to do in the future. So it was not something that was colliding per se at the time. And so, and the other reason is that the Competition Appeal Court is a specialist court and doesn't open you up. So you would be dealing with just one area of the law. Yes, you'll be in the High Court as well, But at that point, I thought being at the SCA, where you would learn a lot more, would be something that I would like to do, and that is why I opted for the SCA. I didn't think about it in that sense at the time. And I mean, I want to repeat my commitment when it comes to me now being approached and having accepted to be considered for the Judge President position of the Western Cape High Court, that my, what I'd like to do is to have that division coming to the stability that will make everybody happy about where it would be at the time. And I would not abandon the division and just simply fly away and say, well, because this is not about a personal ambition, because even moving from the Supreme Court of Appeal and coming here, it is not a personal ambition issue. It's about people thinking, we need you more here, and me saying, okay, I'm going to accept that call.
Thank you. CJ, just with your indulgence, I mean, I know it wasn't one question, but if that could be my first question.
Ask away.
Then just the second question.
Chief Justice, I wanted to make a follow-up on what he said.
All right,
okay.
You can interpose.
On the first one, yeah. Mine is very quick. President Molemela was interviewed like you for a position of JP in Free State.
Yes.
And in a short space of time, she went to become the president of the SCA. Did that court of Free State collapse after that?
No, it didn't.
Thank you.
It was left stable. Thank you, Commissioner.
Carry on, Mr. Bosho.
So Judge, you would be aware of the objections filed during this process, and you filed a response, quite a comprehensive response.
Yes, I
so
did.
I don't want to go into the detail of it.
Yes.
I think my question is just that the complaints centered around your relationship, professional engagement with court staff and support staff and administrative staff at the division. Were you to be successful in this process, you would obviously have to work with some of the people at the center of this objection and your response on a daily basis. How do you propose to mend those fences or build those bridges again? Because it was quite an unpleasant to and fro, and I don't want to breathe life into it. I just want to...
You are actually not allowed to breathe life into it, because the objections committee of this body, it deliberates on all the complaints that come against candidates. It carefully adjudicated that matter and found that it had no merit, and made a decision that is binding on all of us not to put questions about it to the candidate. And this is not just unique to this candidate. It serves for other candidates who've come and are still coming.
CJ, my understanding is that the committee dismissed part of it that had the double hearsay attached to it, but that the remaining, there was the other half of it that they were comfortable with us, but I will defer to the committee to confirm or correct me there.
If that is the case, then you are most welcome to ask on the uncontroversial part.
CJ, the point is, that's why I say I don't want to go into the detail of it, but clearly whether it's whatever might belie it, the candidate will be, if successful, be going into a division where there is this, for lack of a better term, thing in the air. And I would just like to, from a leadership point of view, find out how she would address it.
There wouldn't be, actually, because those people are not in the court. The people who wrote in are not in that court.
Well, one is.
No, he's not.
No, both of them are not in the... Well, the one was never employed, the other was an ex-employee. We dismissed the first one about the widower completely. The second one is relevant insofar as a general point about not the complaint, but whether or not Judge Bukwana has a good relationship with staff. That's open to us.
Perhaps given that there isn't really a delicate way of then asking the question, I'll rather abandon that line of
No,
questioning.
I would not want to deprive you of an opportunity of putting a question you think is worth asking, Mr. Boshoff. As I said before, you may ask on the part that the Objections Committee has said we may ask.
I think maybe then I'm just not comfortable going down that line and perhaps overstepping, CJ.
Yeah,
so I'm
tricky.
not comfortable doing that.
Okay.
I don't think it would be fair to this process.
Okay. Thank you then.
Then I have no further questions.
Okay. Thank you. Commissioner Malema, I don't know if you had
No,
a
it
substantive question.
was a follow-up.
Okay.
Yeah.
Commissioner Marumachai?
Thank you very much, CJ. Good afternoon, Judge Gwana.
Good afternoon, Commissioner.
Since these interviews have started, a lot of people have been asked in terms of their trajectory and their history of assisting people from disadvantaged backgrounds and their role as they progressed, taking the village with you kind of a situation. And even some of the candidates who are actually trying to get this post, they've been asked if they are successful, what is it that they are going to do to make sure that all that we are complaining about, briefing patterns and all these kind of things, at some level they are addressed. I want to ask on that sense that in your own journey of success, which is quite remarkable, what have you done to ensure that as you progress, those who were at the bottom, you actually carried them with you going forward? And when you get the post, what is it that you are going to do to contribute to the debate that people from disenfranchised sort of communities, they deserve to be given opportunities to showcase what they can do? I mean, you in your vision, you referred that at the Cape Bar, for instance, there are 2 males who are senior counsels, and there is no. So those are the challenges that we are faced with. When you assume this leadership role, what will then be your role? But I'm interested first in your journey before you answer the second part of the question.
Chief Justice, could I just intervene here? Could I ask the Commissioner to rephrase 2 questions, which is when you get the post to if you get the post?
Oh, thank you very much, Commissioner.
I missed
if
that.
you get a post. Thank you very much, Commissioner.
Thank you so much, Commissioner. I take keen interest in actually mentoring. I take keen interest in mentoring, particularly women, because I believe that I'm where I am because other people took me along with them and mentored me. And so I don't only talk and give speeches in conferences and workshops and seminars. I have one-on-one mentorship. I have people even currently that I mentor. And actually someone that I bumped into also here said to me, Judge, I think she's applying for a position. I don't know if it's tomorrow. She bumped me and said, Judge, I remember you held my hand and you said, you know, that's fine. We want to hear your voice in the judgment. And you showed me the ropes when I first came to act in the court. And so that is what I do. And when it comes to the Western Cape, the Western Cape has a difficult or a different kind of scenario as compared to other places. Other places, you will be able to find a professional African person everywhere you go. But in the Western Cape, you don't necessarily get them readily there, or you don't see that they probably are there. So one of the first things that I would do is to actually interact with the legal profession, that we may go and find the people, because I believe that there are people in the corners. I was also found in some corner in Port Elizabeth. So we need to collaborate with the legal profession to try and find people, one, but also not to do that, but to mentor people, because you have to understand that We come from an unequal past, and therefore we need to pick each other up, and so make sure that we are exposed in these kinds of areas. But the third thing is that I think this discussion also involves businesses, clients, and so it's a legal profession, and people that give instruction and brief people that must be involved in this debate. I'm talking about big business, and I'm talking about big firms to be involved in these discussions so that they can influence their clients to brief and give instructions to black people and give them a chance.
Thank you, CJ.
President Mulemer.
Yes, thank you very much, CJ. Good afternoon, my sister, Justice Boqwana, Mabindla Boqwana.
Good afternoon, President.
Just to record that you and I met for the first time in 2012 when you were still acting at the Labor Court. Is
You're
that
right.
correct?
You're correct. You borrowed me your bib.
Yes. And we have had a cordial relationship ever since.
Definitely.
I'm just saying this just to clear the air that you are not running away from the SCA.
No, not at all. Not at all, President.
Yes. You'll confirm that you and I have had several conversations regarding what I thought would be your career path.
Yes, that's correct, President.
In your mission, reference was made to your strong work ethic, and I can attest to that, and it was precisely because of that we had several conversations along the lines of your career path.
That's correct, President.
Also that after being nominated for this position, you called me and we had a long conversation, and you indicated that you wanted my views before finally accepting the nomination.
That's correct, President.
Yes, thank you. My last question. You alluded to the fact that you were attached to Tukiso Dispute Resolution Center at some point as a mediator, and that you attended a seminar in Utah on mediation and so forth, and mentioned that only in relation to the importance of mediation as an alternative to adjudication or ADR.
Yes.
Yes, but if appointed, do you think that your experience as a mediator would come in handy in terms of healing the rifts among colleagues that currently exist in that division?
Definitely, President, because mediation is about pulling people together who are in conflict, and you have the skills of being able to ask the right questions and to assist parties to finding a solution. So I believe that those skills would definitely come in handy.
Thank you, Justice Mabindla Boqwana. Thank you, CJ.
Thank you, President.
Thank you, President.
Commissioner Gotzel.
Thank you, CJ. I do have a question, but before I ask it, I just want to go back to Mr. Russell Daniels, and I will try my best not to overstep. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, do you know Mr. Russell Daniels?
I know him as an usher who used to be at the court, so I know him like all the ushers in the court.
Yes. Now, is there any reason why Mr. Daniels would fabricate such a story?
I don't know. I'm also shocked. I was actually taken so much aback. So I don't know what...
Commissioner Gotzel, the decision was that the candidate would not be asked about that objection because it was adjudicated and found meritless. So we can't put questions by our own resolution. We can't put questions to this candidate about that objection. That's how this works. You do have the policy, the objections policy of the Judicial Service Commission.
Yes.
Yeah. You can't put those questions.
All right. Well, I'll move on then. So, Judge, you've been in the Western Cape High Court for 7 years.
Yes, I was.
And how much criminal experience did you gain in that time?
A lot. In fact, in my first year of acting, I was involved in a criminal case, and it involved rape and murder, and a case where I had to impose life. That was my first criminal trial, and I've done criminal trials a lot in that court, criminal appeals from the Magistrates Court, and also currently do criminal appeals at the SCA. So in my 11 years, I've done a lot of criminal work.
Okay, so The Western Cape is plagued by gang-related matters, quite a lot of them.
Yes.
Some of them will probably take multiple years to conclude.
Yeah.
And that attributes to the backlog of the criminal role.
Yes.
At the same time, the Department of Correctional Services also has a massive problem with remand detainees.
Yes.
So in your vision, you explained that you would liaise with the DPP, the legal aid, and other stakeholders to address the backlog in the criminal role, but I was just wondering if you could maybe just explain how you would also work with the magistracy and the Justice Department and perhaps Correctional Services to encourage AVR technology, electronic hearings, in order to address the issue regarding remand detainees.
Yes, I think that's important. I would work with them to make sure that when it is not necessary for a matter to be physically in court, then we can deal with those matters in that way. So I would collaborate with them.
Thank you.
Commissioner Matolo,
Chief Justice, just to follow up, not on the crime issue, but on that first issue.
Okay.
Just to, for those commissioners who were not with us when we began, we reported on the matter that the 2 objections were considered and dismissed. We then said it is still open to ask the candidate whether or not they've got good relationships with staff, because it's an important aspect of leadership. But the objections were both dismissed. And that is why the Chief Justice keeps reminding commissioners of our own decision in accordance with our own objections policy.
Exactly.
Commissioner Matolo, thank you for the intervention, Commissioner Nungaito.
No, thank you, Chief Justice. Good afternoon, Judge Bakona.
Good afternoon, Commissioner.
No, just to put on record, the question by Justice Mulemela was the same question I wanted to ask.
So you covered?
Yeah.
All right. Thank you, Commissioner. Commissioner Hassan?
Thank you very much, CJ. Judge Bakona, let me start by first addressing some of the important cases you've presided over, and I think it is just relevant to mention it. Also as a Muslim woman, as someone who does represent that community quite often, and just to say how important and how groundbreaking it's been. I mean, even my own grandmothers and many members of my community have for a very long time been fighting for recognition. So I think it's just important to acknowledge the activist role and nature of some of those cases. But to my question, CJ, through you, I'm very interested in, and I picked up pieces of it when you were relaying your vision, but maybe it's just a little bit easier to speak to it now. There are 7 senior judges in the Western Cape Division who will retire in the next 2 years.
Yes.
And I think it's cumulatively almost 100 years of experience. And another candidate also mentioned this. So I'm interested in your views around how to build a strong pool of succession, but also what you will do beyond the regular run-of-the-mill acting stints and sort of going on courses. I'm very interested in that, and perhaps related somewhat, if you could also bring in the rationalization project, which is quite a big thing ongoing in the judiciary. Thank you.
Thank you. Thank you so much, Commissioner. The first one, I think it's important to use the skills of the retired judges by making sure that we bring them back to assist with workshops on important topics, and also to call the judges back for important matters where they can sit and transfer skills to junior colleagues. One of the things that I think might be important relates to criminal trials, where we have a backlog. One of the things we could do is to recall or maybe ask retired judges and perhaps regional court magistrates that have retired to assist with the backlogs, perhaps during recess periods, because of the shortage of courts that we might have during term. And so we need to utilize those skills and not simply let the skills go without being tapped into. When it comes to the acting stints, I think it's important not to develop people only by acting, but educating. So there should be education, not only of acting judges, but of judges themselves, because we have to continue to learn, because things keep changing and adapting and developing. So I would encourage, as I've said, continuous learning, and it must be structured. Induction programs must also be structured. The last question was about, can you just repeat the last question?
The rationalization. Let me actually phrase it properly, because I do have it here, about what you can do to enhance access, more particularly to the poor and marginalized, taking into account the rationalization interventions and projects that's ongoing in the judiciary. Thank you.
Thank you very much, Commissioner. I think one of the things that's mentioned in the rationalization report is whether or not the Western Cape should have a local seat, because currently we have a main seat in Cape Town, and that is the only one. And then we have circuit courts around, and we have Temperament in George, which sits 5 weeks a term, that also services places around it. And so I think having a local seat will bring access to justice to the people who don't have to come to Cape Town, and saving on transportation and all that. I think it's important also, there was something else that was mentioned in the report that had to do with concurrent jurisdiction that needs to be addressed. I haven't thought through it as to exactly how. The issue of concurrent jurisdiction between the magistrates' courts and the high courts, that you find a situation where a plaintiff picks a court, they would normally pick a high court because they think that the high court is more efficient and they'll get speedy justice. Now, the defendant has to travel all the way to the high court, and in a matter that could have been dealt with at the magistrates' courts level. And that's the first thing. And the second thing is the defendant will have to get lawyers and pay them at the rate that is higher than that which they give. I know that the courts normally give the scale when they give costs, the magistrates' court scale, but that doesn't address the issue. So those are the things that we need to think about as we rationalize.
Judge President Mlambo.
Thank you very much, Chief Justice. Good afternoon, Judge Mabindla Botwana.
Good afternoon, Judge President.
I think, Kashu, you've already mentioned that the first time we met, you had already accepted an acting invitation to the Labour Court.
Yes.
On that last issue, the Concord and the SCA have already said the High Court has no choice. Whether the matter is a match court matter, it must hear it if it comes to the High Court.
Yes, I understand. I've read that judgment.
Unless you will pull some magic and help us.
Yes, no, I think for me it's more about perhaps education, Judge President, and for people to understand the benefits of having the matters being heard at the place that's closest to the people than getting people to travel all the way to the High Court.
I heard your vision. I listened very attentively. Do you actually know what is the problem in the Western Cape Division?
Judge President, I was part of the court, and then there are historical issues in the court.
Yes.
That happened when I was still in the court. Dynamics, whether overt or covert, but intentions and all that. So there are issues that I know, and some of the issues that came to the public domain happened at least the first 2 months that I was still in that court. And so I do know what the problems are in the court, and I also know it because the colleagues have kept me informed about the court, because I'm interested in knowing what the problems are.
Okay, thank you very much for that. Now, it appears on a case flow front, there's a problem in terms of a skewed capacitation reality, in that more judges seem to be required to do criminal trials than civil work in particular. I'm not sure if you are aware of that dynamic, and
Yes.
if so, what will you do if you are appointed to address that problem?
Thanks, Judge President. I'm aware of the problem. I think maybe before I answer the question of what would I do, maybe I should say the consequences of that problem are that the permanent judges that should be developing the jurisprudence of the court are taken away from civil matters that are important because of the problem. And you get acting judges coming on an ad hoc basis, and there's no continuity, therefore, and development in that regard. And so that is for me, an issue that we would need, were I to be appointed there, that is an issue we would need to focus on, because we have to get continuity and empowering also, so that even judges within the division get a fair spread, a wide spread of matters. And then when it comes to my ideas on how we can deal with the criminal backlog, the first thing is an obvious one, which is the strong relationship with the DPP's office, because it's important for that discussion to take place, that some of these matters are not supposed to be in the High Court. There are simple matters that are supposed to be at the regional court, because I think the regional court, in my own view, is the court that is supposed to be the trier of facts, basically on criminal matters. And what it robs of, what happens when when a simple matter comes to the High Court, that accused is robbed of an automatic right of appeal, because when the matter is set in the High Court, they have to apply for leave to appeal, as opposed to when the matter comes from the regional court. And so that relationship between the DPP's office and the leadership of the courts is very important, and it must be tightened up. The second issue I was told that there was a pilot project in the court where the court identified one accused, the matter where there was just one accused, matters that could just be removed from the roll swiftly. Those matters, as I think I've already mentioned, that we perhaps can have a project where we have retired judges and retired regional court judges and perhaps practitioners that could do that, but during recess, maybe deal with those simple matters that we can get off the table quite quickly. Those are just maybe the short-term things that we can do.
Thank you. CJ, I don't know, I still have a question unrelated, but I have a follow-up to this one.
Okay, ask the questions you have, JP. I'm sure they will be asked.
Thank you.
You are a head of court, so you hold a special status.
Thank you very much. The follow-up question relates to the overall responsibility of a JP in a division.
Yes.
You also have some oversight responsibilities over the lower courts.
Yes.
The regional courts, I'm sure you heard from Commissioner Gottsel, I don't know whether he asked that question or maybe he didn't, that awaiting trial detainee periods are a big problem in the regional courts. They spend years on trial before their matters are finalized. It will be something that will be your responsibility as head of the division to try and assist. Do you have any ideas how you could do that if you are appointed?
I think, Judge President, we could look at the causes, maybe first whether we have enough people, enough complement of the regional court magistrates. As I've indicated, I think that with the establishment, what is currently being used in that regard is outdated. So we need to review that, look into reviewing that. And also, secondly, to look at the bottlenecks, what are the causes of inefficiencies in the system that make matters, that create the backlogs. And so that is how I would, for now, that's what I can think of, Judge President.
Thank you. Thank you very much. My last question. The high courts have a problem with reserve judgments. I'm sure you've read about that in the judicial reports and in the reserve judgment reports that come out periodically.
Yes.
I think the problem in the Western Cape is not as pronounced as some courts like mine.
Yes.
But do you have any ideas what you would do if you got the job to ensure that judges deliver their judgments at least within reasonable times, taking account of the fact that we don't have judgment writing time, unless you look at recesses?
Thank you. Thank you, Judge President. I would identify what is the problem, why the particular colleague, maybe I'd look at the pattern as to how many colleagues and who are these colleagues who tend to have judgments reserved, and go to the colleagues and try and look at ways in which I can assist them. If it is a matter of capacity, maybe alleviate some of the pressure to them so that they can be able to do the judgment. I know what used to be done sometimes is to give a judge a trial, a criminal trial, because when a person does a criminal trial, they've got some flexibility in playing around with their time that they can use to also write the judgments.
Thank you very much for that. Thank you, CJ.
Thank you, JP. Commissioner Notice?
Thank you. Good afternoon, Judge Bakwana.
Good afternoon, Commissioner.
There's just one question. I think you have touched on this in your plan, but it keeps on going around. What is your view about the importance of a good relationship with the staff? That is, I think we have touched on that, but if you can speak to it just again.
It's very, very important. I mean, the staff, they are the core support of the judges. So they are the backbone of the administration, and they help the judges to do their work well. And so it's important for judges to have a good relationship and take keen interest in the people that they work with. Not just being interested in the work they do, but being interested in them as a person.
Thank you, Judge. No question.
Commissioner Baroi?
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes. Judge, you spoke about mediation.
Yes.
And that you've trained, you provided training to judges after you attended the mediation course. Now, could you share with us in how does it get practicalized? It's obviously a well-intended dispute resolution mechanism, alternative dispute resolution mechanism. We have it in Rule 41A. But when one looks at Rule 41A, at least the first parts of it, it's more a mechanical process where people indicate whether they want to engage in mediation. My experience is that generally litigants seem to prefer to choose not to go to mediation. What do you see yourself doing if you're appointed to this position to practicalize this alternative dispute resolution mechanism whose purpose is to move or at least to ease the backlog in the courts?
Thank you, Commissioner. As I understand, there is thinking to move towards court-annexed mediation at the moment, and we are currently awaiting legislation to indicate what kind of model would we have in our country. Would it be a hybrid model of having, for instance, I almost said commissioners, mediators coming from the outside privately, or would we have a CCMA type of thing where you have people employed within the system and assisting? The training that we did was not to make judges necessarily mediators, but it was to assist them with the tools, one, to get them to know what mediation is all about so that they can sell it to the litigants in front of them. So the judge would not just say, well, this is a matter that needs to go to mediation, but the judge will be able to say why mediation is important in circumstances like this. I had an example, but maybe I should leave that one. Rule 41A, I know that it is seen by a lot of people as just a tick box exercise because someone fills in a form, no mediation, yes or no. But it is really something that is meant to nudge people to think about mediation deeper, and perhaps a judge can assist in educating people there about mediation at case management level at least, because I think those two should work together. So I would encourage mediation in that way, that at case management level, in matters that are deserving, family disputes and other matters, please let's engage meaningfully with the parties as to whether or not mediation is not appropriate, and tell them what the benefits of mediation are.
Thank you, CJ.
Follow up, CJ.
Sorry?
Follow up.
Who's that? Oh, Commissioner Marumakai. Yeah, go ahead.
Thank you very much again, Judge. On the issue of mediation, obviously, even in the rules of court now, you have to show some interest in mediation before, at the High Court, before you institute the matter. And obviously, the magistrate court, there is court annexed and all those kind of things. But isn't it that mediation is now going the route of arbitration, where we see the mushrooming of private organizations that are doing, especially in family law, that are doing mediation, and the costs associated with mediation are contrary to how mediation has been advertised? Are we not experiencing that challenge now?
That's true. I mean, I think that's an impediment for many people who think that, well, at this point, I have to pay for the mediator. I have to pay for the cost of mediation. And I think that's one of the things we still need to think about creatively, is how to do. And if I recall the land court at the moment, there is a provision for costs, and it's not the parties that pay for the mediator. We still have to devise rules as the rules board as how the mediators will be paid. If I recall, I might be wrong. So I think you're correct. It is actually an impediment for many people, and we have to find ways of how we can be able to make it less cost, to be cost effective rather.
Thank you very much, CJ.
Thank you, Commissioner. Just one last question from me, Justice Mabinja Pokwan. One of the judgments you list as your reported judgments is the case of Lungisa versus S, which is bilingual. You wrote it in English and is the Xhosa.
Yes.
Is this, and by this I mean the practice of writing court judgments in our indigenous languages, is this something that we should encourage, and is it a practice that you would enforce at the Western Cape Division of the High Court if you get this job?
Definitely, Chief Justice. I think there should be recognition that all 11 languages are constitutionally recognized and entrenched, and promotion of language is important. So I would definitely inculcate that and encourage us as much as possible to make sure that we write judgments in the language that people understand. And maybe not just judgment writing. Proceedings in court could happen in the language of the people that are there if all speak the same language. But I understand the issue of cost because of the translations that have to be done for purposes of an appeal and all that kind of thing. But we should work around those things in order for us not to lose sight of the promotion of language.
Thank you, Justice. You're excused.
Thank you, Chief Justice and the Commissioners. I appreciate the opportunity.
Thank you. Why should I look at you? Good afternoon, Chief Justice, and good afternoon, Commissioners.
How are you?
I'm well, Chief Justice, and you?
I'm fine, thanks. You are from my neck of the woods. You come from the Eastern Cape.
Of course, Chief Justice.
And you studied at my alma mater, the University of Transkei.
Of course, I am from UNITRA.
Where you obtained 2 degrees, a B.Juris and LLB.
Yes.
Did you proceed to work there? Your CV says you worked as a legal assistant at the Lawyers for Human Rights. Where was that?
If I may start by saying, when I first went to University of Transkei, there was an Office of Lawyers for Human Rights that was at, I can't remember the street name.
In Mthatha?
In Mthatha. It was headed by Ms. Dennis Rudolph at that time. So Ms. Dennis Rudolph used to go to the University of Transkei to educate or train students about what human rights are for. So I then cultivated a relationship with that office, and I still remember in my very first year, I asked Ms. Rudolph whether I could come to the office and do voluntary work during school holidays because I was interested in the human rights law.
Then you were a regional distribution coordinator with the Independent Forum for Electoral Education.
Yes.
What did you do there?
It was during the time when we were preparing for the first democratic election in South Africa. So Lawyers for Human Rights had so many projects at that time. So we were busy with voter education as students. We were busy with so many things under the umbrella of Lawyers for Human Rights. So I was busy with voter education for almost every magisterial district of Transkei. I traveled Transkei throughout. That is building up to the general election in 1994.
All right. Then you were a legal advisor at Madikizela and Associates, but yes, for a very brief spell.
I liked doing vocational work. Even then also, I wanted to gain some experience in litigation. I would ask the directors that, can I come to your office and do some voluntary work? Mostly I got into those offices by doing voluntary work, but by the time the time comes for me to leave and go back to university, I would get some stipend or something. Yeah.
Then you returned to Lawyers for Human Rights for
I built a very solid relationship with the Lawyers for Human Rights because that's where I started. That's where I cut my teeth as a lawyer. That's where I was told that a lawyer never writes with a blue pen. A lawyer uses a black pen to write.
And you just decided that you were going to join the sidebar, and you went and did your articles and started practicing.
Yes, definitely. At GLIACO Incorporated at Owen Street.
You worked for a number of firms, including the Women's Legal Center. Where was that?
In Cape Town.
In Cape Town.
Yes.
And joined the State Attorney's Office.
Yes.
As a senior assistant state attorney.
I started as an assistant, then I was promoted.
You were there for 9 years. Well, you say between 2002 and March 2011. I counted.
Yes, yes,
Right.
that's correct.
And you decided to start your own practice.
Yes, I started my own practice where I dealt with some commercial work. I still remember I used to do contracts for companies that had businesses in some African countries like Zambia and Lusaka. So I was busy with commercial contracts during that time.
And where did you open this office? In Cape Town?
In Cape Town. I practiced from home at that
Right.
time, yeah.
You're very brave, I must say. When I was offered an opportunity to work there, I couldn't wait to run away and go back home.
Not everybody can withstand what is happening in the Western Cape.
Yeah. All right. Your life as a solo practitioner was short-lived because you started acting.
Yes. I thought I was going to practice for quite some time, but the former JP said I must stay on until I was appointed. I thought I was breaking away from government now to start my legal practice, but it never ended like that.
Yeah. I see that you started acting as a judge in April 2011 and you never went back.
Yes. I only went back during recess.
All right.
My practice.
And you were permanently appointed in 2013?
In February.
You've acted at the SCA as well?
Yes.
So when?
Between June
The third
and
term?
September this year.
All right. It was just for that one term?
Yeah.
How did you find that experience?
No, the experience was fulfilling. Things are done much different from the High Court. And I must say I've learned a lot to take back to the High Court.
Yeah.
And also things that we thought were correct, that we should correct at the High Court level.
I see that you've done a lot of things. You've served in various committees and,
Yes.
and boards, in addition to running your own practice. So
Yes.
administration work you're familiar with
I've
it.
done a lot of administration work. It's only at the High Court that I was never given an opportunity to do that.
Yeah, I was going to ask about that. I take it you are one of the most senior judges in your division.
There are senior judges before me.
Yeah, no, I understand that, but you are not low level. You are
No, I'm
somewhere
not
up
low
there.
level. No, I'm not low level.
Have you been given an opportunity to act in the leadership position
No.
pertinently as an acting deputy judge president?
I thought that was something that I was going to address later on.
Okay.
When I'm dealing with my vision, perhaps.
Okay, no, that's fine.
Yeah.
That's fine. All right. The professional bodies generally speak well. Your reviews are fair. The GCB says an assessment of your judgment shows that you understand legal concepts, including constitutional law.
Yes.
But then they mention a judgment of yours, they and the Law Society of South Africa, which you served at some stage.
Yes, I served at the LSSA.
Yes. They mention a judgment, is it Labuskachne against Commissioner
Bernard
Sars?
Labuskachne, yes.
Yeah,
I
which
think I sent a response in as far as that is concerned.
Yeah. No, I just wanted to raise something with you about, I'm not concerned that you were overturned by the Constitutional Court. I mean, if any judge will claim that they have not been overturned on appeal at some stage. What I wanted to raise with you is a concern raised by the Law Society that you omitted to mention that judgment in your questionnaire.
I omitted to include it in my questionnaire because I was not aware of it.
You were
at the
not
time
aware of it.
I completed my questionnaire. Otherwise, I had nothing to hide.
Yes. All right. You mentioned the vision. I'm salivating. Let's hear this vision for your court.
Okay. Let me start by advising this commission that I was nominated to this position
at the time when I was preparing to take my acting stint at the Supreme Court of Appeal. It came as a surprise to me, but I had to agree to serve because I'm already serving as a judge in any event. So I'm going to start by telling this commission why do I think I'm the right person for this position. I've prepared something in writing. I don't know whether...
You want to read it?
Yes, I would like to.
You may do that. I find that saves time.
Yeah. After I had an opportunity to observe different leadership styles from different leaders that I served under, I'm convinced that mine is slightly different from others. Besides being a visionary and a strategic leader, I think transparency, holistic approach on matters, welcoming spirit, and inclusivity is key to successful leadership. I would classify myself as a born leader because I chased opportunities to lead throughout my young days up until now. From my teenage years at the University of Transkei, I saw myself with some few students establishing a student body that was called Students for Human Rights. During those years, this body did so well in conscientizing the broader community of the former Transkei region, in educating them about their basic human rights and their right to vote closer to the first democratic election in 1994. As young students, we undertook this task diligently, although we did not have any Bill of Rights at the time. Our source document that we used was the Universal Declaration of Human Rights that was adopted by the United Nations General Assembly on 10 December 1948. The establishment of that student body was a success, which prepared the less privileged adequately for our democracy. This initiative would not have been possible without the support of the Lawyers for Human Rights, and later on, funding came from the University of Transkei. Despite being the youngest in the group then, my thought leadership and transformational commitment was well embraced by all involved. Shortly after I obtained my degrees, I joined the Black Lawyers Association, which at the time did not have a student body in the former Transkei. I and my former colleagues, who were candidate attorneys at the time, were tasked with the formation of the BLA student chapter, as we were fresh from university and still had contacts on campus. This initiative was well received by students who aligned themselves with the BLA objectives. Regrettably, I had to leave Mthatha before its launch, as I received a work opportunity as a director at Prela Oosthuizen Incorporated in Cape Town. Once more, when I arrived in Cape Town, the culture was different to what I was used to in Mthatha. There was close to no organizational structure that I could identify or associate with. For instance, there were 2 or 3 people who identified themselves as members of the Black Lawyers Association, but there was no organizational structure in place. I remember after having a meeting with Advocate Dumisa Ntsebeza SC, who shared the same sentiments that we need to form a body, a structure of the PLA in the Western Cape. We decided that I will mobilize people who are interested to join the organization and put formal structures in place. In our first meeting, I still remember Advocate Ntsebeza was elected as a branch chairperson, and I was elected as a Secretary General. The organization grew slowly throughout the years, and when Advocate Ntsebeza relocated to Johannesburg, I led the organization as the branch chairperson. I grew in this organization and served the BLA at the NEC level on more than one term. To this day, I owe it to this organization for nurturing my leadership prowess. This is the organization that deployed me to various structures where I led at different leadership roles, like being a counselor at the Cape Law Society and the Law Society of South Africa. In addition, I served as a board member at the South African Board for Sheriffs, and which at that time we found it in disarray. However, by the end of our term as the board, all systems were in place, and I assisted in setting up its disciplinary department, and I chaired the disciplinary committee of the sheriffs. I must say I gained much leadership I gained much experience in leadership when I was at the state attorneys for those years, and also when I ran my practice as a solo practitioner, although I had somebody who was assisting me at the time. For these reasons, I would find no difficulty in giving a strategic and jurisprudential direction to the division. I must say that I've mentored many acting judges in my division in judgment writing and in case management. Some of them did exceptionally well under my guidance and have now been appointed permanently. I interact with my colleagues and staff in general pretty well. I'm forthright in my approach, and I'm also time conscious, and I'm not scared in getting my hands dirty. I can safely say that I classify myself as a diligent and hard worker who's not afraid to lead from the front. My interest in imparting skills to others is not only limited to the bench. I do talks on relevant topics to students, disadvantaged communities, government institutions, mostly during recess. Also, I still do the BLA, I still offer training at the BLA trial advocacy training during recess. I do this training to law students and to the legal practitioners. At this point, I must pause and say that I am a human being, and at times I would make mistakes. So this means that I'm not averse to criticisms if I make mistakes. I take kindly to constructive criticism and take it as an opportunity to correct my mistakes and appreciate and understand issues differently. Also, in times of disagreement and with my calm and strong demeanor, I'm able to diffuse tension or conflict quickly before it escalates to something uncontrollably. I always think that communication is key to any kind of relationship. Transparency in communication and collegiality is something that should always be fostered at all times, I believe. With all that said, I am available for this task as I possess relevant leadership qualities. The fact that I have not acted in this position should not be put at my doorstep, as the acting criteria in these positions is not clear. From where the Western Cape High Court is currently, it requires strategic and visionary leadership. And I'm mindful of the fact that this is a view I formed from being a judge in that division for a considerable number of years. Despite that being the case, I've stated that I have not acted in the management capacity in that court, as the criteria remains unclear. However, I must point out from the outset that The situation is not easy as one would see or as it appears. There are serious dynamics at play in the Western Cape High Court. One might say, for instance, I would ensure that all the colleagues attend tea room, they go to judges' lunches, they attend judges' meetings, but I don't think that would be a solution for starters. So with that being said, I would like to share my 10-point plan. If appointed as JP, I would like to implement. First, number one, I would start with addressing relations. 2, visibility of the leader in the division, that is the judge president herself. Number 3, skewed patterns of allocation of work. 4, transparency in the allocation of circuit courts. 5, modernization of court and virtual hearings. 6, access to courts. 7, shortage of judges and tools of trade. 8, transparency in the appointment of acting judges. 9, efficiency in utilizing court time. And 10, maintenance of stakeholder relations, more especially in the lower courts. With regard to the relations, in an environment where trust relations between colleagues have broken down for years, in my view, it would assist to get an opinion from a specialized individual on workplace relations to first conduct an assessment and give us a report on what remedial measures need to be implemented. That's for starters, because as I'm sitting here, I don't know what is the problem in the Western Cape. Coupled with that is the perception that some colleagues, due to their backgrounds, perhaps not originating from the Western Cape, are not supposed to be judges in that court. I consider these first 2 critical issues as delicate and of utmost importance and cannot be simply ignored or be resolved by a relationship coach or a diversity training workshop in a one-day session. Perhaps those might be relevant at a later stage, but not now. We need to identify, we need to zoom into the problem right now. However, on the other hand, I must point out that the situation is not that ominous. The Western Cape High Court prides itself with judges who are committed to their oath of office and are always hard at work. Whatever relationship issues that might be there, they have not affected the work output. In fact, this is the compliment that we always receive from colleagues from higher courts, that is from colleagues from the Supreme Court of Appeal and colleagues from the Constitutional Court. Number 2, I'm going to deal with the visibility of the judge president. As I've stated earlier, in a division that has trust issues, it is my opinion that there should be visible leadership. What makes relations to be strained is that judges are reluctant to open up. For that trust to be regained, for starters, the lines of communication with the management should be open and clear. Having identified these areas of concern, once communication lines are open, it is my strong view that judges would have confidence in their leader. For instance, judges sometimes do experience work and personal challenges while executing their duties. For instance, if a judge approaches a judge president for whatever reason that might be there or concern, such conversation should remain between the two. Confidence is of utmost importance and should be key. One other example, if an email is sent to the Judge President, that email should be responded to promptly. It is the role of the Judge President to administer the day-to-day affairs of the division efficiently, and that invariably includes issues that are delicate enough and should not be responded to by the Judge President's registrar or secretary. I'm acutely aware that secretaries are there, or a secretary is there to support the office of the Judge President. But there are issues that are sensitive, personal, and operational in nature that are not supposed to be addressed to the judge by a secretary. It is therefore my plan to recognize, acknowledge, and give consideration to my colleagues, stakeholders, litigants in general, should I get the nod. In order to gain and maintain confidence on my colleagues and the staff in general, I will implement an open door policy. More interaction in forging healthy relations in the form of discussing and sharing sessions, perhaps a sharing session that would be planned on a certain Friday afternoon, sharing sessions on new judgments at least once per month, a reinstatement of judges' lunches. I don't know whether judges can afford judges' lunches given the fact that, given the state of their salaries currently. Also, judges' meeting and end-of-year functions would at least help to mend the relations in the division, because there would be that ongoing type of an interaction. I will also ensure that the information from other structures like the PEEC, heads of court meetings, the OCJ, that affects the division is reported back to the judges for discussion and resolutions to be taken as a collective. I'm now going to go to the third point, equitable allocation of work. For quite some time now, there has been a discontentment in how the work is allocated in our division. By way of an example, most permanent judges are working between unopposed motion court and criminal court currently. Matters of substance, especially civil matters and high-profile matters, are allocated only to selected few permanent judges, and on ad hoc or pro bono acting judges, or acting judges who are appointed from the ranks of the advocates profession. For instance, certain judges have been privileged to be allocated cases that enhances and develop the jurisprudence, whereas others receive none of that sort. I'm fully aware that perhaps that might be a strategy on the part of the management to address the issue of the backlog. But it is my strong view that expertise and experience of permanent judges, in my view, is not something that is normally taken into consideration when work allocation in both criminal and civil matters is done. Coincidentally, this does nothing to recognize the divergent skills that are possessed by the members of the court, I mean permanent judges. So permanent judges remain in criminal court for years. This by no means should be taken as downplaying the criminal court work or trivializing the work of some judges over the others. However, the truth is that the jurisprudential strong points of permanent judges should be recognized and nurtured throughout their careers at the bench. In future, this would create a pool from which the Supreme Court of Appeal and the Constitutional Court draw acting judges from. I'm mindful of the fact that we still have backlogs, and backlogs are still going to remain with us for quite some time. At the same time, the reduction of case backlog cannot be addressed by removing permanent judges for about 3 years from the civil pool. Some sort of balance, in my view, should always be maintained. This is not only detrimental to the judges who lose touch completely with that area of law, also it causes difficulty to advocates who deal with these voluminous and complex matters. For instance, when they revert back to their practices at the end of their stints, it causes delays with the handing down of the judgments, as they have to juggle between successfully operating their practices and or working on their reserve judgments. In my view, to ensure that permanent judges are upskilled and an expertise is created amongst its rank, if appointed, I'll ensure that an equitable distribution of work amongst colleagues is maintained. The uneven allocation of work should not be a weapon to settle scores and or to stifle the growth of others on the bench. In addition, when a motion court is allocated to certain duty judges, it should be finalized by the said duty judges and not be reallocated to judges who are not part of that duty. By so doing, a perception would be created that other judges are favored and or are shielded from heavy lifting. I'm now going to deal with my fourth point, transparency in allocation of circuit courts. Previously, when I joined the bench, the allocation of circuit court was done by order of seniority. However, lately there seems to be no criteria at all on how they are allocated. Some senior judges monopolize certain circuit courts, and in some instances, junior judges are given preference over senior judges. I think also a clear criterion should be put in place to the fact that, for instance, a duty roster of judges due to go on circuit should be kept and updated at all times. No judge should go on circuit court on 2 consecutive terms, or for the whole year, for that matter, as it's currently done. A judge should spend at least 1 term at circuit court and thereafter revert to the division. Should a matter or matters not be finalized on an allocated time, it should be transferred back to the court or be heard virtually and be finalized as soon as possible. Also, I found that there's a problem in as far as the current demarcation of circuit courts are concerned. Something needs to be done, or the circuit court demarcation needs to be relooked at. As in my view, some existing courts are not located where the people are, or where the people are concentrated. Judging from the way the amount of work is increasing, circuit courts should be designated for both civil and criminal work, and not only be criminal work orientated. By so doing, this would assist in bringing justice to the people. I'll deal now with modernization of courts and virtual hearings. This project was first touted even before COVID-19 hit the world. However, its rollout has happened at a snail pace. And I understand that training by Mlambo JP happened for the first time in our division a month ago. And even then, I don't think that was enough to upskill the full complement in the division. Some ongoing training on case lines and virtual courts needs to be done. As a proponent of an online court, and one of the first judges that received training on virtual platforms when COVID-19 hit. I think virtual hearings are the most efficient way in finalizing cases expeditiously. I know Mlambo JP has always offered his services insofar as the JP has already offered his services insofar as training is concerned. But this new innovation has not, in my view, received the embrace it deserves. In my observation, the older judges are not keen in learning new ways of doing things. Should I be offered this opportunity to lead the division, I'll ensure that filing online and reverting back to virtual hearings is introduced gradually or incrementally so as not to overwhelm those who are not keen on trying new things. In fact, it should be introduced in such a way that all would buy to it. For instance, virtual hearings have proved to be quicker and efficient in urgent matters, more especially in after-hours duties and unopposed motions. This is by no means evidence that open court should be done away with. However, this innovation will need support from the Office of the Chief Justice. I must stress that if judges do not have functional laptops and they do not have access to a stable network, or for instance, OCJ pays limited amount of time when making subscriptions or buying licenses from service providers to access the network, this strategy would be a futile exercise. I'll now deal with the access to court. Section 34 of the Constitution guarantees access to courts to all. There is a perception out there that courts are only accessed by those with deep pockets. This is evident on the caliber or types of litigants that we encounter in our courts on a daily basis. Even though the Legal Aid Board had previously broadened their scope in terms of matters it covers, it also faces some challenges in the sense that their budget has been cut. That will also curtail a number of underprivileged litigants from accessing, more especially the High Court. Coupled with this is the geographical location of the High Court. For instance, the Western Cape High Court is not easily accessible from the people who are coming from the most disadvantaged locations or backgrounds. And in my view, this remains a huge challenge. The lack of means is evident when one deals with the unopposed motions or a criminal trial. It is either that the litigants or witnesses come late to court because of challenges with the transport and find out that their matters have already been dealt with, or do not come to court at all because of the reasons related to shortages of funds. In my view, this problem could be partly addressed if, for instance, a criminal matter originates from Khayelitsha and the accused and witnesses are all from that area. An ad hoc circuit court could be created in Khayelitsha Magistrates Court to deal with such matters so as to eliminate the strain of traveling on those persons. This would only be a temporal measure until the location of circuit court in our jurisdiction is revised, as I've pointed out earlier on. I recently understood that, for instance, for legal practitioners licensed to be renewed with the LPC, that is Legal Practice Council, they are compelled to have done a stipulated number of pro bono work at a certain period of time. If the Legal Practice Council, as a stakeholder, could share a list of practitioners who have not done the number of hours, a judge on duty, for instance, could refer unrepresented litigants to these or to those attorneys. The Cape Bar also used to have a pro bono advocate readily available in court. I'm not sure whether that is still the case. It is my strong view that legal services and access to courts should be open and accessible to all citizens of this country. I'll now deal with the shortage of judges and tools of trade. The reason why we have this constant backlog is that currently there is a shortage of judges. That has been underscored by various judges from various divisions. I've heard this time and time again. This problem has been there even before I joined the bench as a judge. It is not clear whether this situation will remain or change would happen at some point. It is not even clear whether judges should get used to working under these pressurized conditions, as the situation cannot be changed. As a result, most judges end up getting sick due to stress they encounter on a daily basis. Let's take, for example, if the Western Cape High Court is allocated 6 to 10 judges tomorrow. Do we have space to accommodate them in the form of chambers, court, and staff? Not at all. The courts around the country in general seems to be carrying more challenges than solutions. This at that. Judges do not have updated law reports in their chambers. They even find login challenges to their online platforms that OCJ has subscribed on, that is LexisNexis and Twitter. This poses even greater challenges with the limited staff complement of legal researchers. Most daunting, I'm now speaking for myself. I have been standing on the queue for the past 3 years for a new laptop that has forever been promised that is on its way. I would at this point implore the Office of the Chief Justice to ensure that at least judges are provided with the basic tools of trade to ensure that they function optimally. The strain is even more if judges have to be burdened with the lack of resources to do their work. Even if there are austerity measures in place, judges deserve to be provided with tools of trade to deliver on their obligations as mandated by the norms and standards. Next point, transparency in the appointment of acting judges. It has always been said that the current process of appointing acting judges is shrouded, susceptible to abuse and patronage. I'm not sure whether that is correct. However, I'm acutely aware that the former Minister of Justice, that is Justice Ronald Lamula, introduced a policy to ensure transparency and fairness in the appointment of acting judges. Despite this be the case, it is my view that all the members of the legal profession should be given a fair opportunity to put their skills into test. It cannot be that the same faces show up all the time when calls are made for acting judges. In fact, should I be appointed, I think a committee should be put in place that is chaired by the Judge President to screen and identify potential candidates in the broader legal profession in line with transformation initiatives to act as judges. On the one hand, I would ensure that senior judges who are eager to train and mentor acting judges are identified for the success of the division in retaining skills, as more judges who are experienced have now retired. The next point is strategy to utilize court time efficiently. In light of our backlog currently and shortage of judges, I intend to devise a strategy to use the court time efficiently. For example, counsel and legal practitioners should stick to the allocated time either by the court itself or the time that they have reflected in their practice notes. In so doing, allocations of 2 to 3 short matters per judge per day would be possible, should counsel stick to this allocated time. For instance, arguments should only be limited in issues of dispute. Counsel should not be allowed to read the whole heads of arguments, as the other parties would inadvertently have read the record timelessly. Also, in order not to put strain on the long list of reserve judgments and also to start the new term on a clean slate, I envisage the last week of term to be used to utilize by the judges to catch up with their reserve judgment and any other previously allocated work that remained unfinished to be finalized in that last week, so that when the new term starts, the court starts on a clean slate. My last point is the maintenance of relations with the stakeholders and magistrates' courts. I do understand that there is an ongoing relationship between the judge president and the stakeholders, and the stakeholder relations should be maintained at PEC level on an ongoing basis. We all understand that the coordination of all judicial functions of Magistrates' Court fall within the jurisdiction of the High Court, and it is the responsibility of the judge president to coordinate those relations. Also, I'm mindful of the fact that Magistrates' Court, they operate under enormous pressure to dispense justice at an entry level of the judiciary. In my preparation for this interview, I stumbled across a report that was prepared by the Public Protector, dated 4th June 2024. So in the interest of time, I won't really go through what the Public Protector identified as problems. It seems that the problems are all the same, in that the Public Protector identified that there is a shortage of resources at the Magistrates' Court, and it seems also issues with regard to domestic violence are not taken care of by the magistrates, and also magistrates themselves have reported that they've been victims of sexual harassment by their colleagues. And this is about 16% of women magistrates who voiced that opinion. So if magistrates have been victims of gender violence, victims of GBV, gender-based violence themselves, how are they going to make sure? Let me start by saying, if the women magistrates have been victims of gender-based violence, without any intervention in the form of counseling being done to them? Are they going to be able to do justice to the cases that come before them? Also, if the male magistrates are found to be the perpetrators of this gender-based violence, that is sexual harassment, are they going to do justice to the matters that come before them involving sexual harassment? That is my question. Another problem that was identified by the public protector was the issue of bribery and corruption, but that one, she didn't have any mandate or capacity to investigate because it's beyond her scope, it's criminal in nature. And also there's lack of security in the magistrates' court. So if I'm appointed as a judge president, I would make sure that I do interact with the lower court in order to see to it that I support them in as far as their challenges are concerned. The public protector in her report concluded that court infrastructure, resources and staff conditions are deteriorating and there needs to be some improvement. It is without a doubt that also the lower courts experience huge backlogs due to COVID-19. So what should be done in such matters? So it would assist to interact with the magistrates more to get a feel as to what is it that needs to be attended to as of priority. I would also make sure that I identify all these courts within my jurisdiction who suffer from these hardships and support them and see as to how we can better mitigate these challenges depending on the nature thereof. In conclusion, I must say that judging from the support and messages received from my colleagues and from the support staff of the Western Cape High Court, from last week up until this morning, I do enjoy support of the majority of them. And I would have no problem in working with any one of them. That's my presentation.
Thank you, Judge Mantame. Judge Gamble.
Thank you, CJ. Judge Mantame, amongst your litany of complaints was the question of the allocation of work. And did I understand you to say that there's an inequitable allocation of work, that some people are getting interesting cases and others not? Was that your complaint?
It's not only my complaint, it's the complaint that I've heard from many of my colleagues as well.
Well, I want to just have a look at Barnard Labuskachny again. That was a very complicated tax matter that was allocated to you.
Mm-hmm.
Am I correct? It was a problematic tax matter.
Perhaps it was problematic.
It went to the Constitutional Court and judgment was delivered there in 2022, volume 5, which means towards the end of 2022. But you say you never knew that the case went to the Constitutional Court.
I didn't pick it up.
Have you since read the judgment?
I did.
Are you aware of the strident criticism of your approach in the judgment of Judge Rogers?
Yes, I did see the criticism. But
Are you
also, I
aware?
don't know whether you've read my judgment.
Beg your pardon?
I'm not aware whether you've read my judgment.
No, I'm asking about whether you read the judgment of the Constitutional Court, which criticized you for your failure to apply one of the basic rules of our law, that's stare decisis.
Yes.
And that you ignored precedent.
Yes, I've seen that criticism.
And do you understand the criticism?
Yep.
Then there's further criticism. I'm simply looking at what the GCB had to say. There's further criticism that you dismissed a constitutional challenge which was made in the alternative without even considering it. Are you aware of that?
Yes, I'm aware of it. That's why I was asking if, did you at least have a look at my judgment before?
No, I didn't. I'm asking you about the criticism of the Constitution.
In my judgment, I said that matter was capable of being determined without reaching a constitutional point.
On the issue of circuit courts, you suggest that there's an inequitable distribution of circuit courts. But
Not
you know that...
inequitable as such. It needs a revision because
Judgment done. Maybe I just ask you to be patient with Judge Gamble as we have been patient with you.
Okay.
Let him finish his questions,
Thank
please.
you, Chief Justice.
Circuit courts in our division are advertised at the beginning or the end of every term. Sorry, at the beginning of the term, the circuit courts for the next term are advertised. And colleagues are invited to apply.
Sorry?
Circuit courts are advertised. So, for instance, now at the beginning of this term, the circuit courts for the beginning of next year, the first term in January, first term in 2025, they will be advertised and colleagues apply.
I've applied, but I've never been given a chance to go to circuit court.
But they are advertised. It's not a question of them just being dished out.
But if you put your name down, you would be told that someone has taken it. Much more junior than you.
You speak about promotion of collegiality, and you speak about promoting that culture in the tea room. When last did you attend the tea room in the High Court?
I can't remember.
You at one stage were working from home quite a lot. Do you spend all of your time at the Cape High Court, or do you still work from home?
When was that?
Beg your pardon?
When was that I was working from home?
No, I'm asking. A number of colleagues during COVID and after COVID worked from home. I'm simply asking, do you spend all of your time at the Cape High Court, or do you still work from home?
I don't know how to respond to that question because I'm not sure which period are you asking for. I can't just respond without knowing which period I'm referring to. Whether it was during COVID or after everybody went back to the building.
No, post-COVID.
I went to the building when everybody went back to the building.
And then lastly, you appreciate, Judge Mantami, that if you get the job, you inherit a deputy judge president who's already there and who is going to be there on her reckoning for at least another 5 years. You will inherit a judge president in the person of Judge Goliath. You appreciate that?
I do.
Will you be able to work with her?
I think so. I don't have any problems with the
acting
judge president currently.
The reason I'm asking is because I recall a judges' meeting not too long ago when you accused her of dishonesty in the face of other judges in an open meeting. You know the meeting I'm talking about.
I didn't accuse her of dishonesty. I still remember you intervened and you asked her to investigate the matter. And the matter, I don't think it was really investigated to start with.
Well, maybe our recollections are different, but I do recall that there was...
It was investigated, but the outcome was the same as what happened at the meeting, if you want me to put it like that. That's why I'm saying I don't think it was investigated, because we filed statements as to how the issues turned out, but I don't think those issues were even taken into consideration by the AJP.
But you say notwithstanding that interaction, you would have no difficulty in working with her?
Not at all. I do go to her chambers every now and then when I've got a problem.
Thank you, Chief Justice.
Thank you, Judge Gamble. I allowed you to continue with your questioning, but the thing is we don't know what you're talking about. And practice in this body is that if you are going to raise an issue of concern with a candidate, you forewarn them and this body so that they have a chance to respond, and we have this body has a chance to determine if that objection has any legs, it should be allowed. But then you wouldn't know. That's why I gave you leeway.
Yes, my apologies, Chief Justice. I was responding to the statement of the intent that the judge put forward. I was responding to the issues that she raised in her statement of intent.
Yes. All right.
But my apologies for overstepping the mark.
No, that's fine. Mr. Boshoff?
Thank you, Chief Justice. Afternoon, Judge Montoni.
Good afternoon, Commissioner.
Just on the Labuskaghni judgment, I note your reply that you said, look, you weren't aware of it at the time of your application. But that judgment was handed down more than 2 years ago. So would you agree that given your position as a judge and the expectation, I suppose, from people who appear before you and the general public that judges know the law, that there's an expectation that you keep yourself abreast of developments in the legal landscape, and especially when it comes to judgments of the higher courts?
Yes, I do agree.
And especially given their binding nature on the lower courts.
Yes.
So does your explanation not admit to a shortcoming in that regard?
Not at all, because sometimes you get to know about your own judgment when you're researching a certain point, when you're preparing a judgment. You don't always follow up on each and every matter that you've granted leave to appeal on. Once the matter leaves your desk, there are so many things, or there are so many matters that a judge should attend to at the High Court. The work is moving very fast.
No, sure. I take the point. I think my point is rather that regardless of whether you actively follow up on your own judgments, there are services in which the various courts circulate judgments on a daily basis to those who subscribe to them. So it's very accessible, especially with SAFLI being open source facility. What I'm saying is that in the normal course of familiarizing yourself with the latest judgments of the higher courts, you should have come across this judgment and said, hey, wait, but that looks familiar. I remember that case. And what I'm saying is your explanation perhaps reveals a shortcoming in that regard in the general continuous updating of yourself with the developments in the law.
Yes, I do update myself in the development of the law. I check all the cases that are delivered, for instance, by the Supreme Court of Appeal and by the Concord. Only if those matters are reported. I don't know whether this matter was a reported judgment, but I didn't pick up that it was a reported judgment. Hence, it skipped my mind, or it skipped my day-to-day looking at the recent decisions that have been delivered by higher courts.
Okay. Thank you, Judge. Thank you, CJ.
Commissioner Malem.
Thank you very much, CJ. I just want to ask you 2 questions quickly, and then I will tell you why I'm asking those questions. What is your understanding of a judicial temperament?
Judicial temperament. It requires that a judge should be able to listen and take into consideration other people's views and be collegial to others, and not act outside of what is required of a judge.
What is your understanding of collegiality?
Is that colleagues should be should have relations, good relations, and should be able to work well with others.
So when I walked in here, the CJ was still conducting the interview, and the way you were responding to her, at the beginning I thought maybe the CJ explained your relations before I came in, and maybe you know each other from somewhere else, because you kept on interjecting her and not allowing her to finish her points, and I was like, does she have a problem with her or what? But you do that to your colleague again, this side. And this time you don't do to her. You're doing to your colleague. She says to you, no, wait until he has finished his point. But that's what you've been doing to her. Do you define that? You are the one who just said to me now, judicial temperament means that you must listen to others. But here you have to be stopped for you to listen to others. Interject the most highest office when it interviews you. Is that a true reflection of judicial temperament and collegiality at this level in public?
Commissioner Malema, I didn't see that as an interjection. I thought the Chief Justice had finished her questions, and I thought Commissioner Gamble had finished his questions. If I have interjected, I do apologize. It was not my intention to interject.
Thank you, CJ.
Thank you, Commissioner Malem. Commissioner Maimang?
Thank you, CJ. Good afternoon, Judge Mandame.
Good afternoon, Commissioner.
It's just one from my side. You did mention that it's easy for you to interact with the acting judge president upon there is the question that was posed by Judge Campbell. So now the question that I want to pose is, given the key areas that you have raised as part of your vision, and with the relationship that you have painted around the dire situation of permanent judges in terms of circuit courts, the question that I want to pose is, I get an impression that, it will tell me if I'm not correct, I get an impression that there is no platform by judges to raise these key areas that you have highlighted as problematic areas that has to be fixed, that are captured as part of your vision going forward. Is my impression correct?
You might be correct, Commissioner, because I raised them with the AJP and I raised them with the ADJP.
And I guess you are not the only one that have raised them. And in the meetings that are not minuted, but notes are taken, I guess that all these issues were raised in those meetings.
Not in a meeting. I raised them via email or verbally sometimes.
Thank you, Judge Mandaba. Thank you, CJ.
Commissioner Mangena?
Good afternoon. Good evening, Judge Mandame.
Good evening, Commissioner.
Yes. Earlier on, we were told that the fallout between the then JP and the current AJP had actually led to serious problems in the division. And those would be some of the things that you would then need to deal with should you be appointed to this position. But then the question that I would want to ask you in relation to skewed allocation and second allocation, do you think that there are judges that are being favored as a result of the positions that they've taken in relation to the fallout between the then JP and the current AJP?
The short answer would be yes, I think so.
So there are divisions in the division?
I'm not sure about the divisions in the division, but there are critical issues in the division.
Thank you, Chief Justice.
May follow up just on this question. You say there are critical issues in the division. The first one that was highlighted, it would seem to me, is favoritism. Can you tell us what are these critical items? Because when you say there are critical issues, we don't know. What are they? What, according to you?
Commissioner Nokesi, I don't know whether I should talk about individuals in this commission that are being favored, or there's a perception that they are being favored. But there is that perception, without calling names.
Yeah, please don't mention names.
We may pass on from the question. In fact, no, we may pass on from question because my understanding was there is favoritism that one can't pass. And then I understand you to be saying there are critical issues, not necessarily that. I didn't understand that to be names. I was maybe thinking, what is this critical point issue? But now, if we are not comfortable, we can pass on with that question.
Commissioner Steinberg.
Good evening, Judge Mantame.
Good evening, Commissioner.
I'm going back to the Labuschagne judgment. When Judge Gamble asked you about the Constitutional Court judgment, you responded by saying, "Have you read my judgment?" And I have two questions in that regard. Are you implying that the Constitutional Court got it wrong and your judgment was right?
Not at all, Commissioner. What I wanted to clarify is that perhaps the case that was put at the Constitutional Court is not the case that I was confronted with. That's all.
Well, I'd like to probe that. The Constitutional Court said on the issue of the rescindability of tax judgments. It says that all the authorities, which has said those are final judgments and are rescindable, were brought to your attention, but you ignored them and didn't follow precedent. Now, that seems to be correct from a reading of your judgment and the Constitutional Court's judgment. So, what about that was not before you?
You would remember that Metcash dealt with the VAT, with the VAT Tax Act. The matter that was before me dealt with the Tax Administration Act. The Metcash was decided in 2000. The judgments that I relied on were provincial divisions that were recent, and some of them spoke on what was happening in that matter, that they referred to the Tax Act, to the TAA. So the Tax Act TAA, in my view, was addressed more better in the recent judgments of the provincial division, in the judgments of the provincial divisions, than what was at play in the Metcash. Remember, Metcash didn't deal with the rescindability of civil judgments. The Concord in that matter dealt with the declaration of sections of the VAT Act unconstitutional.
Well, the court here also comments that you didn't explain that. You didn't actually distinguish. You didn't take into account a whole lot of authority, and you didn't explain what you've just explained now, which I think is correct.
Yeah. That's why I said I do accept that criticism. Because sorry.
No, carry on.
Because my judgment was not thumbsucked. It came from precedents from the provincial division.
My second question also relates to your answer to Judge Gamble. And following on from Commissioner Malema, when he asked you about the Constitutional Court judgment and you said, well, have you read mine? Do you think that displays collegiality and an appropriate judicial temperament?
I thought by asking that question, it was going to have a balance on what was before me and what was dealt with by the Constitutional Court. I didn't in any manner try to disrespect Judge Gamble.
Thank you.
Follow up, CJ. Good afternoon, Judge. I'm here.
Good afternoon, Commissioner.
Yes. I just want to follow up on the Labuschagne judgment. My understanding of that judgment, first and foremost, Rogers J was not conclusive in his statement. He said you appear to have not relied on precedent. That's the first point. He was not conclusive about the issue. But that's not the point. He actually referred to a judgment of the Supreme Court of Appeal or the Appellate Division, the 1973 Appellate Division case, the Kruger case. And in his reasoning, he says that, in fact, in that particular case, the Appellate Division stated it categorically that tax judgments were rescindable. And that is the basis upon which the criticism is based. I'm not sure, do you have any comment on that?
I've seen the judgment that it started analyzing judgments from 1965. Those judgments were not before me when the matter was argued. It was only Met Cash that was put before me.
But was the issue whether a tax judgment can be rescinded an issue before you?
Yes.
But surely that is an issue that can be researched. It might be that the parties themselves or none of them actually argued the case before you. But I think if there is authority from a higher court, then one would expect that at least that authority is located, unless perhaps there's a challenge with resources in terms of research and so forth. And I think that's where Rogers J was coming from.
Commissioner, the reason, perhaps maybe I might have appeared hostile in asking whether Judge Gamble read my judgment. The case that was before me was not clear to start with from the applicants. The applicants didn't know which instrument to rely on. Firstly, it was said the application is brought in terms of Uniform Rule 32 to capital B. There's no uniform rule dealing with the rescindability of judgments in as far as that rule is concerned. Secondly, they said they brought the application in terms of Rule 42. Thirdly, they said they brought the application in terms of common law. I was confronted with those three legal instruments, and I had to analyze them all as to which one would be relevant in their case. It seems as if their case was all clear before the Constitutional Court. That's why I'm saying I don't know which case was put before the Constitutional Court, because the papers were in shambles when they came before me. But I do take that today the criticism is on me. It was not a good drafted application that I dealt with.
No, I can accept that. A case evolves with time, and sometimes when it gets to the Constitutional Court, it becomes better explained. I can accept that.
Sorry.
Thank you very much, CJ.
And even wrong legal instruments were quoted, and I had to probe during the hearing. Which Rule 32 are you referring to? Are you referring to 31(2) small b that deals with the...
No, thanks, Judge. I think you have made a point, and I think I agree with you. Thank you very much.
It was a bad case that I had to deal with, Mr. Commissioner.
Commissioner Ngugaitwa?
Yes, thank you, Chief Justice. Judge Mandama, I just want to come back to this point that you were discussing with Commissioner Steinberg on the Labuschagne judgment. because I'm very worried about the way you've characterized the criticism of the Constitutional Court. Because it seems there's one issue that they take with your judgment, which is whether or not you are correct that a tax judgment is not final and therefore not rescindable. Do you accept that?
Yes, because that was my finding.
Yes. Now, on that issue, it doesn't matter whether they characterize it as a Rule 32 or any other rule, because it's a question of law. Now, what they say about what you did is that you failed to have regard to at least 3 judgments that were binding on the issue, despite the fact that those judgments had been brought to your attention. In fact, it's only in the leave to appeal where you referred to Metcash. And the way you did so, at paragraph 29 of the Constitutional Court judgment, you said that the Constitutional Court did not make a finding of law. It just made an observation. This is why they use very strong language to say that your judgment was unacceptable. It's because you poo-pooed, you dismissed, you waved away a binding authority that says a tax judgment is final. That's the criticism against you. In other words, you treated authority of the Constitutional Court as if it didn't exist. So you can find that in the judgment itself at paragraph 29. They come back to that at paragraph 30. They say the reasoning in Metcash, now they're responding to you, on rescindability was not merely an observation. It was an integral part of this court's reasoning. And Metcash, in turn, endorsed the 2 judgments in Kruger. So that gives us 3 that were brought to you. You don't apply them, despite the fact that the Concord has spoken authoritatively on the subject. Now, my concern is not so much whether you get the job of being JP. It is what you will do when you return as a judge, bearing in mind the posture you've adopted today about the authority of the Constitutional Court. Can you comment on that?
Commissioner Ngwaito, I'm not sure what attitude I've adopted about the Constitutional Court.
You've said it was a different case before the Concord to the case that was before you, whereas I've just pointed out to you it was exactly the same issue, which is finality of tax judgments. Now, once you don't accept that it was the same issue, my fear is that you will repeat the same error of treating with dismissiveness judgments of the Constitutional Court. If I can just finish this point, maybe then, paragraph 30 says, observance of the rules of precedent is not a display of politeness to a court of higher authority. It is a component of the rule of law, which is a founding value of the Constitution. My fear is that you will not follow precedent.
As I said earlier on, Commissioner Ngwaitobi, that I do accept the judgment of the Concord. I do accept that I'm bound by the judgment of the Constitutional Court. However, there was a lot that I had to unscramble in the court of first instance to reach the decision that I've reached. Maybe it didn't come out clear that I had to unscramble a lot of issues before I came to that conclusion. I did not at all, not in 1 minute, say that I'm not bound by the President of the Constitutional Court.
No, I don't think you said you were not bound, but the approach we've taken before us is that it's because the applicants failed to identify the issue, and therefore the issues were different. So in other words, you still don't see that there was an error in your judgment because you got the law on finality of tax judgments wrong, and that's the point I was putting to you.
Commissioner Ngwaitobi, it's not that I didn't see what was in front of me. I was just giving a background as to what is it that I was confronted with. I thought that was going to clarify the issue as to why I came to the conclusion I came to. Not that I want to disrespect or disregard the judgment of the higher court, apex court for that matter.
Yes,
I
but
wanted to give a background.
No, I understand that, but the issue is still the same. It's whether or not tax judgments are final. That's the issue before you, that's the issue before the Constitutional Court. So I'm struggling to understand why this background is relevant to that issue. And that's why I fear that you will just repeat the same error.
Commissioner Ngwaitwe, I want to repeat that error. I'm committed to that.
Commissioner Shabangumdawi.
CJ, I'll let it pass. Thank you.
President Muleme.
Good afternoon, my Sister Justice Mantame.
Good afternoon, President.
Yes, you confirmed that you acted at the Supreme Court of Appeal during the third term, so more or less for 3 months. Correct?
I do confirm.
Yes,
President.
and I think you also stated that you learned a few positive things from that acting stint, correct?
Yes, that is correct.
Yes, I confirm that I think you were in my panel in 1 or 2 matters, if I'm not mistaken. Just to give you credit to say that I was satisfied with your level of participation in the conferences. You'll recall that we had a session with all the acting justices just before your term came to an end, and the parting shot was that request that all of you should go and plow back to the courts where you come from. Do you remember this?
I still remember that day.
Yes. Now, from your own personal experience, what is it that you will be able to plow back based on the experience that you got during your acting stint at the SCA?
On 2 occasions that I sat with another senior judge, there were problems in matters coming from my court where a full bench would sit as a court of first instance. So it caused some problems when it comes to leave to appeal. Parties, they don't know whether to ask for leave to appeal from the High Court or to ask for leave to appeal from the Supreme Court of Appeal. Mostly they approach the Supreme Court of Appeal, of which the Supreme Court of Appeal said it's wrong, they should go to the court of first instance. And that's one of the things that I would take back.
So if I understand you correctly, you are going to offer assistance to your colleagues?
Certainly, that perhaps those full benches are unwarranted in a situation where the court is going to be the court of first instance.
Thank you, Justice Mantame. Thanks, CJ.
Judge President Mlambo.
Thank you, CJ. Good afternoon, Judge Mandame. I'm here.
Good afternoon, Judge President.
Just 2 things from myself. One, I checked the last available reserve judgment reports. There were 2 judges in your court who were owing judgments. The period recorded was 22 months. And then there are others in varying time periods, up to 6 months, from 22 months, 18 months, 17 months, 16, up to about 6 months. If you are appointed as JP, how do you propose to help curb this problem?
Can I answer, Judge President?
Yes, please.
Firstly, I would identify as to what is the reason for the judgment to be reserved for such a long time. And if there are problems, I would see where could I assist. And also implore to the judge concerned that he or she should finish the judgment as soon as possible, because of the norms and standards that we should stick to.
You know, the CJ, the outgone CJ Zondo, threatened JPs for not reporting judges who owe judgment. I don't hear you mention that.
I don't know whether they are not reported by the current management, or I should have put in my plan that I would report them. I'm not certain about your question.
Well, I think my question, this is a follow-up question. You said, I asked you what would you do to assist in terms of addressing these reserve judgment problems.
Mm-hmm.
So if you are appointed as JP and you have a judge, say your tracking system fails you and you discover after 12 months, you discover that there's a judge who owes a judgment for 12 months, what would you do?
Firstly, I wouldn't understand why the judge president has to leave the judgment up until it's 12 months old as a reserve judgment. Because I start panicking with my own judgments when 1 month passes. That time is ticking. Even on the second month, I think the judge president is supposed to impress upon the reserve judgments that they should be finalized. 12 months is way out of line. It's a matter that should have been reported to the Chief Justice at 6 months for that matter, as far as I'm concerned.
Yes. My last question to you is, it appears that it is a problem in the Western Cape Division in terms of the capacitation of the different roles. It looks like judges are more allocated towards criminal trials, especially when we hear there's mention of backlogs, than to the civil part of the role. If you are appointed as JP, what strategy would you adopt to ensure that there's equitable distribution of judicial resources to ensure that no work area suffers because of lack of capacitation?
It is a fact that a continuous role at least should be maintained at all times. Judges who are in the civil pool should rotate and go to the criminal pool. It's inexcusable that there could be judges who stay longer in the criminal pool and don't have a feel of what it's like to be in the civil pool for years. Currently, judges carry about 2 to 3 matters, criminal matters at a go. So I don't think that is healthy, because I don't know whether it wants to imitate the way things are done at the magistrates' court. Magistrates' courts, they don't have continuous roles, for instance. You'll find that magistrates do 15 cases per day in the criminal courts. I don't want the High Court to be turned to be like magistrates in the future.
Thank you very much, Judge Mantame. Thanks, CJ.
Thank you very much, Judge Mantame. Sorry, it's been a long day. You're excused.
Thank you, Chief Justice, and thank you, Commissioners.
Chief Justice, can I ask you to find your glasses?
I did.
Oh, okay.
I'm wearing them.
Okay.
On a lighter note, I want to move that the JSC buys us all Red Bulls before the end of the evening. CJ didn't hear that, but maybe, Minister, you need to take up this mandate. of getting us energy drinks for all JSC commissioners and those in the room.
You need nothing except to hard work. You know? You need some vavavoom.
This way. Thank you.
Oh my gosh. Did it break?
Give you a holiday, just taking my bags and go.
Are you fine, Commissioner? Okay. All right. Good evening, Judge Potgieter.
Evening, Chief Justice.
I'm so sorry we kept you waiting all day. We're not having a particularly good day.
No, that is perfectly in order.
Yeah. How are you?
Surviving, CJ.
Well, aren't we all?
Yeah.
You have a number of degrees, a BA, LLB, BA honors, an LLM, and a certificate in international trade law.
That's true.
Which ones were obtained at the University of Western Cape?
It's the BA, LLB, BA honors.
All right, and the LLM from UNISA?
From UNISA.
And the certificate
from the
University of California?
UCLA, yes.
Which one, UCLA?
Davis.
Okay. You're an attorney, proper attorney.
Yes, I started off practice as an attorney, yes.
Having done your articles in 1980 already.
Yes.
But you joined the Cape Bar as counsel in 1985 and practiced in that capacity for 10 years.
That is correct.
Until 1995.
Yes.
Then you became a commissioner of the Truth and Reconciliation Commission.
In 1996.
1995? Well, your form says 1995 until 2001.
Yes.
6 years. Okay. Then you returned to the bar.
Yes.
And took silk. When did you take silk?
In 1996.
Okay. And you were appointed as a judge on a permanent basis in 2022.
That's correct, in Quebec.
Had you acted as a judge previously?
Yes, many times. CJ on aggregate, about 5 years, if you add it all together.
So you have been a judge in reality for about 7 years?
About 7.5, 7 years.
Yeah. And where did you act in the Eastern Cape Division of the High Court still?
I acted initially on a few occasions in the Western Cape, where I've always been based. I've acted in the Labour Court, and I've acted, the last few stints were in the Eastern Cape.
Okay. You sell yourself short in your questionnaire because these don't come out clearly. I would have missed this important 5 years you mentioned, because the professional bodies are complaining that you are inexperienced and could benefit from more time.
I've noticed it.
Although I don't know, I mean, you turn 68 in just under 3 months, so I'm not entirely sure how much more experience one can gain once you become our age.
Yes.
But in any event.
Yeah, I think one must do a bit of a calculation. Unfortunately, I didn't spell it out, but the years are there for the acting stints. So, yeah.
It is important. All right. So how many judgments would you say you've produced throughout this period on the bench?
CJ, I would say approaching 100. I've just done, my office has just done a sort of a sample test on the last about 50 reserve judgments to just see which ones were reportable and of interest and which ones were not, to get sort of a percentage. But as I've said, it should be approaching 100.
How many, do you know how, if any, were reported? We usually rely on the GCB for this exercise, and they say they did not complete the review.
Yeah. No, I'm not a big one on that. That's why I've asked my office to do that sample. From that sample of 50 reserve judgments, there were about, say, 35% were reportable and of interest.
All right.
And that's where I part with them. I don't really follow them up after that. I mean, I'm too busy. There's no time for that.
Indeed.
Yeah.
And I imagine that they would have been on a wide spectrum of the law.
Oh, yes.
Okay.
Yeah. No. That is correct.
All right. As I've already alluded to the complaint by some of the professional bodies, the GCB and the Law Society of South Africa,
yes,
who say you don't have sufficient experience for this position you're applying for. What would you say to that criticism?
I have, as I've said, I've performed the judicial functions for that period that I've referred to. I know what the job is about. I know what to do. I enjoy doing it. So I don't think that there's an issue around that, that I am a novice who don't know where to start. CJ, I've spent my entire professional career in attending to high court litigation, which is the lifeblood of the courts. So, apart from the period that I've been performing judicial functions, I've been doing litigation, high court litigation, for a few decades.
Do you have any leadership experience within the institution, the judiciary, that is?
Yeah, no, not directly in the judiciary, but I have.
Any leadership experience?
No. I haven't occupied a position as a leadership position in the judiciary. No.
Okay. All right. You've mentioned that you've been on the job long enough to know what this particular job requires. On that note, what challenges, if any, have you identified in that division that would require an incoming deputy judge president to take action,
yes,
devise measures to address those challenges? Just concisely.
Yes. Concisely, In my assessment, Chief Justice, the real issue of the division is the fallout of the failure of leadership. In fact, that is the elephant in the room. That there's been this protracted discord involving the leadership and everything else that went with that. Most of us know about the public face of that. It's quite obvious that the difficulty in the division is the divisions that resulted from that situation. It persists. It's there. That is part of the reason that persuaded me when I was approached to make myself available. I've been steeped in that division. I know all of the senior judges. I've worked with many of them, if not most. And I know all the other judges. So I'm well aware of what the actual cause of the problems are. As I've said, it's a failure of leadership, and what you require is not an administrator or technocrat. What you require is an effective leader. So you require effective leadership. And that is, effective leadership is really not what you do. It's what you are. It is part of your nature. The traits of effective leadership are inherent, really. The fundamental hallmark is service. They use the term servant leader. That's really what the essence of it is. You must respect in order to earn respect. And to earn buy-in. And that is, it's obviously what had lacked and which resulted in the situation that obtained there.
Have you worked in that division?
In
the Western Cape?
Yes. Oh, yes.
When?
Are you referring to judicial?
Yes.
Yes. No, as I've said, I've spent 4+ years acting in that division.
Oh, you acted as a judge there?
Yeah,
All right.
Most of the acting time was spent in that court.
Okay.
Started off way in 1998 already.
Okay. I'm sorry, I may have cut you short. You were still addressing us on your vision. Had you finished?
So really, Chief Justice, what is required singularly is to return the division to normality and cohesion, and to restore its stature and esteem through resolving the issue that I've referred to, the one of discord, strife, lack of collegiality, polarization, and the like. It's not, in my assessment, an issue around the systems or technical issues. The systems are fine. They've been there for a long time, and they're functional. It's not the systems, it's relationships. That's where it lies. Of course, there are other things that one can look at, but that fundamentally is what it's all about.
You'll tell me when you have finished.
Yes, yes.
You have?
Perhaps I can just share some other thoughts while I'm at this. Drawing on the situation where I am currently based, I think what one could do quite profitably is to look at the issue of decentralization in that division. I'm in a court which also serves a large, significant geographical area, and where there are 5 seats of the court. And you can see, although that's also historical, but you can see the difference that it makes with regard to accessibility. It's important when one looks at the Western Cape to think along the lines of what has started off slowly. There is, the Commissioner referred, that there is a court established in Temperament, which is in the Southern Cape. The previous Judge President has taken initiatives around sittings in prisons, designating prisons as special courts with all of the cost savings and the rest of it that go with that. So those are initiatives that could be pursued further to bring the courts closer to the people, which is the ultimate objective. So I believe that there's something that could be done around that issue, which, as I've said, I've seen in action where I am. There are questions around the turnover of judges through retirement, mostly. Obviously, senior judges. The Commission has heard, I accept that there are a number of judges who would be retiring, senior judges would be retiring shortly, in the next year or so, 2. And the challenge around that is that there is often not proactive steps to deal with that process of natural attrition. So that is something that needs to be looked at. One can consider ways of transferring skills from those to newer judges. There is a sort of an informal situation where there are some of the senior judges who are engaged in training empowering newer judges. I understand, for example, that two of those senior judges have been conducting these sessions over lunchtime in their free time, where there is obviously skills transfer in that process. There is, of course, a need for continuing education. The present sort of limited processes need to be expanded. I have myself benefited from primary judicial training as a practitioner. We have undergone training by the Canadians, who are very good at this. And I've seen that there is benefit to have that sort of facility, as it were, available, which can simultaneously increase your pool of potential candidates and to upskill your existing serving judges. So that is something that that needs to be looked at. There is, I understand, some sensitivity around that to make sure that when hearings panels are constituted, that you try to pay the members on the panel so that you have skills transfer, so you can put a newer judge with a senior judge, which of course is a very effective way of learning. The judicial function is a practical one. You gather experience and skills as you go along. So that is an important process that can possibly be expanded, as it were. So those are the kinds of things that one could look at.
Mm. All right. I've already mentioned your age. Should it be an impediment to your appointment that you'll be turning 68 soon?
No, I don't believe, Chief Justice. I would have, all things being equal, a further 8 years.
Until you work until 75?
Yes, I can do that. I am in a state to do that.
Mm. So how is your health, if I may ask?
It is, I don't want to use the word excellent, you know what health is like, but it's good.
Yeah, we don't want to jinx things.
No. We know.
All right.
But there's no issues. There's no physical issues there. Perhaps health. I'm sorry. Age. Should not really be such a big concern. See, because this job requires skill and experience. You only acquire those through practical exposure. This is it's a practical field. So the conventional wisdom has always been that you are ready for judicial appointment towards your later years, and that those are the types of candidates that are able to just move seamlessly into the job and to perform. So one should not scoff at age. In fact, that is perhaps one of our difficulties when one thinks of the turnover of judges, is that you have a challenge to attract sufficiently experienced candidates, because that's what you require for various reasons. You must obviously make the position attractive to those kinds of candidates, but it's difficult. It's difficult to do that. So if those kinds of candidates look at the workload of judges, which is not always appreciated or understood, issues around adequate remuneration, then there are few incentives for those kinds of candidates to be persuaded to avail themselves.
Okay. Judge Campbell?
Thank you, CJ. I'll be brief. Evening, Judge Potgieter.
Evening, Judge Campbell.
From your CV, it's clear that you were born in what was then known as Uitenhage, it's now Kariga.
Kariga, you're quite right.
Yeah. And then you moved to the Western Cape for education, for your university education.
That's right. I think you know the situation in those years.
Yeah.
Yeah. So I had to come to Western Cape.
I beg your pardon.
I had to come up to Western Cape.
Yes.
Although there was a university in Port Elizabeth, UPE in those years, and a university in Grahamstown.
Yeah, you had no choice.
I had no choice, yes.
But since then, Judge Potgieter, since then you practiced in Cape Town the whole time.
That is true.
And record will reflect that we were members of the bar together in the 80s and thereafter.
That is quite so.
When was the last time that you acted in the, I always call it the CPD, the Western Cape High Court? I think you probably still call it the CPD as well.
Yes.
When was the last time that you acted there? I couldn't pick that up from your...
I'll have to look in the narrative, if you'll just bear with me.
Certainly.
Yeah. The last...
I think it's 2009.
2009. Yes.
Yeah. And then thereafter in the Eastern Cape in 2019 and 2021.
That's true.
You never applied for appointment in the Western Cape High Court, did you?
Judge Campbell, I think perhaps you will remember.
Pardon?
I think perhaps you'll remember when I was appointed in the Truth Commission. It was well, I did the initial process, and then I was on the commission as well, which was supposed to have a lifespan initially of 18 months. I made myself available for appointment in Cape Town in 1997. At that stage, I had 11 years of practice, and I would probably have stood a reasonable chance at that stage. However, I was prevailed upon from up high not to abandon the TRC process, which we then had to continue beyond the 18 months because it was obviously too short. So I acceded to that, and I never took that appointment, and then just and carried on with those duties until I completed them. So there I was. I had seriously applied to be appointed. I was ready also to be appointed, but then this intervened. And then, of course, once I was done with that, you know, the realities of raising children, growing children, going to high school, going to varsity. I think most of us know what the implications are there. It was just not feasible to then pursue appointment. So I had carried on back in my practice. And then, of course, we had the unfortunate situation there in the court. At that stage, I wasn't really approached again to act, for example. It was, as we all know, it was a bit unwholesome at that stage. And then, of course, the situation arose in the Eastern Cape. And I acted after I was asked by one of my friends who is on the bench.
Sorry, Chief Justice, I'm concerned. Yeah. I mean, for instance, on this question, the question was simply one. Did the candidate ever apply for appointment in the Western Cape? But for that answer now, we have a very fresh start presentation. And I'm not sure how far we are. I mean, if we don't control this at the end of the day, we will be here until very late.
Yeah, we do still have two more candidates who've been waiting out there, like you, Judge Potgieter. So let's just try to keep the answers as concise as possible.
I appreciate that. I thought I'll just give the context, but yes, you're right, Judge Campbell.
Sorry, I'll try and get to the point. When you applied in the Eastern Cape, you came before the Commission on the 6th of April 2022, and the proceedings are in the pack. I think you've seen them.
Yes, yes.
And you used a rather quaint phrase when the Chief Justice then was, Chief Justice Zondo was welcoming you and introducing you, and he said to you, I understand that in the past certain people had made attempts to persuade you to make yourself available, but did not succeed. It looks like somebody has succeeded this time, and you replied to him by saying the following: JP is a very persuasive man, CJ. He told me the first time when I went down there that the understanding is that cattle always graze towards their home state. And I understood that to mean that you had decided to go back to your roots in the Eastern Cape.
Well, partly, but that was part of the consideration, yes.
So why are you back here in the Western Cape?
Well.
Sorry, why do you want to be back here in the Western Cape?
Yes.
But he's a South African. He's free to go anywhere he wants to, Judge Gamble. I'm from the Eastern Cape, but here I am working in Johannesburg.
No, I would genuinely like to try and contribute to things up there, Judge Campbell. That division has been good to me.
Is your family still
for
here?
many years. Well, we're straddling. My wife prefers to be in Cape Town. I am in Kobega.
Thank you.
Mr. Boshoff?
I have no questions, Chief Justice.
No questions, Commissioners? Commissioner Nkonyan?
Chief Justice, good evening, Judge Potgieter.
Evening, Commissioner.
Thanks. I'm one of the junior counsel that appeared before you in Umtata. I think I can vouch that you're one of the best judges. But on this one, you said to be a senior of senior judges in the Western Cape Division. That's what you said. And I did ask some of the contestants before, but I think I must also ask you the same. I take it that you are aware of the challenges being experienced by that division. And if recommended then, how can you be expected to be accepted by those senior judges we have talked about as their head? How are you going to be able to manage those dynamics in that division? That's the only question I have.
Yes. No, thank you. Now, as I've, Commissioner, as I've indicated, all of those senior judges, including Judge Gamble, as he has indicated, we've been colleagues at the bar way back already. So I know all of them. I have a good relationship with all of them. I've got no issues with any of them. I'm sure, and taking the encouragement that I've gotten and to make myself available, that I wouldn't have any difficulty to rely on their support in addressing the issues of the division.
Thank you, Chief Justice.
Thank you, Commissioner. Well, it's been a long day, so we'll let you go at this stage, Judge Potgieter.
Thank you,
You're excused.
Chief Justice. I'm indebted to you and the commissioners. Thank you.
Are you comfortable, Judge Slingers?
As comfortable as I can be. Thank you, Chief Justice. Good evening. Good
All
evening,
right.
Commissioners.
I apologize, we kept you waiting.
Not a problem.
You have 3 law degrees from UCT, BA, LLB, and a Master of Laws in Criminal Justice, and another Master of Laws in Public, Constitutional, and International Law from UNISA.
That's correct, Chief Justice.
Yeah. You started out as an attorney in 1995 and remained there, working your way up to director by May 1999, but left the cyber in December 2001. And there was a spell when you were not working. We don't want to know what you were doing or not doing with yourself during that period. You joined the NPA in 2002, and as a state advocate, and worked your way up to senior state advocate, and then deputy director by March 2008.
That's correct, Chief Justice.
But then you left in 2010 to do pupillage and joined the bar in 2010 still.
That's correct.
And you practice as an advocate until your appointment as a judge?
That's
in
correct, Chief
2019.
Justice.
Okay. Did you act as a judge before December 2019, the date of your permanent appointment?
I did. My first acting stint was in the last term of 2017, if I'm not mistaken, and then intermittently between then till my date of appointment, I acted as well.
In that court?
In that court.
All right. And you wrote judgments?
I have written judgments, Chief Justice.
Many?
Many.
Any reported?
Quite a few reported. If I have to estimate, I've written, I think, over 100 judgments in my complete stint as acting and as permanent judge, and I think about 15 are reported to my knowledge, maybe a bit more, maybe a bit less.
All right. You listed reserved, is it reserved judgments or part-head matters? Those 3 matters?
The 3 were reserved judgments.
All right. Have they been delivered?
They have been delivered, and if you give me an opportunity, I can tell you exactly when they have been delivered. On page 15, in respect of paragraph 16.5.1, the matter of State versus Franke, that was indeed handed down on the 1st of August 2024. The next one, the matter of State versus Vasanti, that was handed down on the 30th of June. And the third one, FHK Electric, was handed down on the 18th of June 2024.
All right. Do you have any leadership experience in the judiciary?
I had no leadership role or position in the judiciary, but I have had leadership roles.
Yes, you've done courses in management, and as a deputy director at the NPA, you had managerial tasks, not so?
That's correct, Chief Justice.
All right. You are aware that a number of the professional bodies think you are not ready for this position. They all speak of your relative inexperience as a judge, not just as a leader now. What would you say to those judges?
I've seen the comments, Chief Justice, Commissioners, and I have responded to it in writing. But I'd also like to say that if one looks at my total legal experience, I have 29 years. And as I said, a judge president is first and foremost a judge. And I think if this body evaluates my vision, the steps that I want to take for the division, the issues I've identified, how I can improve and how I can grow the division, then they will see that my years on the bench is but one aspect of my legal experience and exposure. And I do believe that it's this body itself, when it set out the requirements for the appointment to a leadership position didn't make acting in that position a prerequisite.
Of course.
And I would not be the first to be appointed to a leadership position having only been appointed for a short time period. In fact, my appointment would not be the shortest serving period as a judge before being elevated, if recommended, to a leadership position in the judiciary.
Yes. Okay, let's hear this vision you mentioned, but as you take us through the paces, just bear in mind that we have a whole day full of visions under our belt. By now, we have a fair idea what's going on in that division, so just try to be as crisp as possible.
I will do my best, Chief Justice. Let me start by saying that my vision is for an effective, efficient division that dispenses transformative justice, where judges not only do their best, but where they are able to be their best. This vision is informed by my legal personality and character, which are the products of my experience and exposure. I was born and raised and educated in Cape Town. In fact, my first court appearance was in Court 6, the Children's Court in Wynberg, as an attorney. From there, I have appeared both in the regional and district courts, both as a prosecutor and as a defense attorney in civil matters and in criminal matters. I've acted as a small claims commissioner. I have appeared in courts from Vredendal to Somerset West to Khayelitsha to Delft to Cape Town. I've acted in this division. I've been appointed in this division. What this does, it has given me a unique insight into the courts, the presiding officers, and the people that use that courts, and to know what obstacles they face and to know what is required. In other words, Chief Justice, Commissioners, I'm invested in the people of the Western Cape. I can empathize with them, I can understand them, I can identify with them. And this insight would allow me to grow, empower, and upskill not only the judges of the High Court, but all the presiding officers of all tiers of the court that fall within the division. Because at the end of the day, I would not be Judge President of the High Court, I'd be Judge President of the division. So I need to have a vision that incorporates all the courts, all the presiding officers. I can tell this commission that I know what it's like to feel the frustration of getting a document filed at court. I know the discomfort and indignity of having to sit in a court that's held in a prefabricated building. And I know the frustration of a broken court equipment that results in delays. And all of these detract from a professional, efficient, user-friendly court system that provides dignified access to justice. I will liaise and canvass with other stakeholders to improve the existing systems in order that there are competent and adequate responses to social-economic problems faced by society, such as increasing poverty, homelessness, and increased organizational crime, including human trafficking. It is common cause that South Africa is the most unequal country in terms of wealth distribution. This is more pronounced in the Western Cape. Therefore, it is important for the Western Cape judiciary to understand and respond appropriately to this glaring disparity. It can be accepted that the biggest obstacle to attaining a truly transformative constitutionalism is the continuing disparities of wealth and power that exist in South Africa and the Western Cape. I should add that I am aware that widespread transformation of economic and social conditions is beyond the power of the courts alone. But it is only when the judicial commitment is coupled with legislative reform and appropriate executive action that the wealth disparity can be eradicated and properly addressed. I believe that as the Judge President is first amongst equals, she should not be seen as a boss micromanaging the presiding officers under her supervision. To this end, I will embrace a leadership of justification and not a leadership of authority. A leadership of justification requires a Judge President to be accessible, transparent, accountable, and responsible. It requires a Judge President to talk with people, not at people. It requires a Judge President to earn respect and to give respect and not to demand it. And it requires a Judge President to earn the trust of the people. While I have earned the trust of my colleagues and the support staff, it's stakeholders in my role as a judge, I believe that I can earn their respect in my role as a leader of the judiciary. I know this takes time, and I know building trust takes time. But I have time on my side, and I am committed to spending this time to growing the Western Cape High Court and the Western Cape Division as a whole. This court, the Western Cape Division, requires consistency and consolidation. I am prepared to be the anchor that this division needs. When respect is earned and appropriately extended, a judge president is willing and a judge president who is transparent and willing to listen. It will assist in building legitimacy, not only for its own court, but for the judiciary as a whole. I have seen firsthand how lack of transparency and accountability can have a negative impact on the legitimacy and morale of that court. I have observed an increase in the unrepresented litigant. We will strive to ensure that these litigants are not exposed to an intimidating environment, but one that is user-friendly, professional, efficient, and respectful. In inquiring how often informal potpourris are used in our court, it was clear that there is a huge need for legal assistance by litigants who do not qualify for legal aid or pro bono assistance. To this end, I intend to liaise with all the stakeholders to set up a help desk at the court building that would be manned by members of the profession in discharge of their pro bono obligations. They could assist the unrepresented litigant with completing forms, with explaining everyday legal jargon that we take for granted and which is completely foreign and intimidating to in-person litigants. Pro forma forms could also be drafted, which would make it easier for lay litigants to complete and to access the legal system. For example, you get first-year practitioners who are not yet able to act as small claims commissioners. They could discharge their pro bono obligations while sharpening their skills, increase their exposure to the practical side of a legal practice, while at the same time providing support to the unrepresented litigant. Generally, people don't come to court unless they have to or they are desperate. Being summoned to court is a daunting and intimidating thing, and we need to put these people at ease. By putting them at ease and making them comfortable, it goes to increasing access to the judicial system. We also need to take into account that the nature of crime has changed. It has become more structured, more organized, and is no longer localized. Therefore, I believe ongoing communication and cooperations between different divisions through the Office of the Chief Justice will become increasingly necessary. These organized crimes are national. They need to be addressed on a national level. They are not provincial. It would also facilitate creating uniformity in our jurisprudence in dealing with these matters, thereby preventing forum shopping. It could also result in the maximize of our shared resources and increase access to justice. Each division has its own strengths, and we can learn from one another. I would also have regular meetings that are minuted, which addresses substantive issues. By holding regular meetings that focus on issues of substance, it allows the division to transform as a whole, to brainstorm, and to formulate a collective response to common issues. Minutes will allow for institutional memory to be retained and for increased accountability. It also provides a means of measuring outcomes. This will ultimately result in buy-in and ownership by the judges of the division. I have a good relationship with all my fellow judges, the support staff who assist us, as well as other stakeholders, such as the Office of the Family Advocate, the Office of the Director of Public Prosecution, and members of the profession. My interpersonal skills will enhance my ability to fulfill my role as Judge President. I believe to be an effective and efficient Judge President, you need to continuously understand the interests and needs of those you lead. Therefore, it is essential that you remain in the trenches, so to speak. If afforded the privilege to serve as Judge President, I will continue to discharge the obligations generally expected of a judge. When you walk the same walk, it is easier to understand the developments in the profession and needs and challenges faced by the judicial officers and support staff under your care and address these effectively. I will use case allocation positively to empower and for the transfer of skills without sacrificing the quality of justice. This will ensure that each judicial officer is continuously provided with the opportunity to grow his or her skill set. This body has repeatedly heard that when senior judges retire, it leaves a gap of skill, of expertise. If all the judges are empowered and upskilled, there wouldn't be that gap. There shouldn't be a gap when members of the judiciary retire, because those that come afterwards that are appointed more recently should have been sufficiently upskilled and empowered, not only to be elevated to higher courts, but to lead the division jurisprudentially where they serve. Case allocation should also not continue skewed briefing patterns. This body has heard that there is a problem with skewed briefing patterns, but it's more problematic when case allocations perpetuate skewed briefing patterns, when matters are allocated on perceived expertise of judges based on their practice or the expertise that they had before. That is a means of disempowering and disheartening judges. We need to upskill, we need to empower, we need to realize that every judge, given the opportunity, can take his or her role in managing the judiciary, in contributing to the judiciary. I would also identify management tasks that can be rotated amongst the judges in the division to allow for those who have an appetite and a willingness to participate in the leadership of the division. Case allocation should also be done to prevent forum shopping, which is prevalent in the Western Cape. And it should also have as one of its objectives the finalization of matters and the prevention of parted matters. It must be done in an equitable, fair, and balanced manner, and must, as far as possible, be done in a transparent and open manner. Based on the latest update, there were 21 judgments that were outstanding for longer than 6 months, and 41 that were outstanding for longer than 3 months. In addressing this, I'd firstly ascertain whether the information captured is correct, and then engage with the individual judge to ascertain what, if anything, can be done to address the delay. Some of the outstanding judgments are by acting judges. The failure to get judgments out timeously is problematic. If acting judges are struggling and not prioritizing getting out of judgments, I would consider whether or not he or she should be invited back for a further term. This would bring me to how I would appoint acting judges. Judicial recruitment and selection process must maximize the diversity of each bench, not only in respect of race, gender, and ethnicity, but also in respect of professional background, abilities, and experience. I would look for judicial candidates who have the following characteristics: judicial temperament, intelligence, ethics. And in this regard, I would also liaise with the oversight bodies, such as the Bar Council, the LPC, Chief Magistrates, to ensure that the person who is invited to act is a person in good standing, that there are no complaints against the person, that the person has no disciplinary action pending or findings against him or her. I'd also liaise with the Chief Magistrate in respect of magistrates coming to act to ensure that they don't have parted matters that need the attention, and if needs be, to make the necessary arrangements that magistrates continue to get the opportunity to act without sacrificing their duties in the lower courts. And then I'd also look for legal courage and integrity, because sometimes we are required to make difficult decisions. And being a judge is often you are not well liked because you make unpopular decisions. You are forced to make hard decisions. So you need legal courage. I will also look for experience and education and the ability to communicate. I will look at a person's health and age. I would establish a practice whereby permanent judges could provide me with a list of potential candidates eligible for acting. I would establish whether by getting the input of other judges in identifying candidates, there would be enhanced transparency in identifying candidates to come and act. I believe that the reintroduction of the continuous role would ensure that cases are finalized sooner, and would also prevent the increase in parted matters. It would also be to the advantage of the legal aid and Director of Public Prosecutor's Office, who themselves have limited personnel and who are unable to deal with multiple cases running simultaneously. The increase in parted matters are counter to the right of a speedy trial. In the Western Cape, Fridays were previously kept for appeals. And if you are not allocated an appeal, you are expected to use the Friday either to prepare for the hearing scheduled for the Monday or to work on your outstanding judgments. However, more recently, applications and matters have been allocated to judges on a Friday. I intend to do away with this if appointed or recommended by this body. Preparation and judgment writing is a core part of our core function and should not be neglected. To ignore this core component could compromise the quality of justice being dispensed. Judges are human and are not machines, and therefore we need to ensure that our judges do not burn out and that their well-being is also considered. As Judge President, I will encourage cohesion by affording each judge to sit with one another and not to allocate matters to the same judges or the same panel of judges sitting together. By rotating bench allocations and providing opportunities for judges to speak together and work together with one another, it will result in greater understanding of one another. I will also identify specific judges who could assist with court-based mediation in matters that could be mediated. However, I do need to stress that when court-based mediation takes place, especially in family matters, we should not ignore the Office of the Family Advocate, because the rule that provides for mediation is silent on the child's voice. So we need to make sure that if we do court-based mediation, the child's voice is heard in that process. Chief Justice, that is in essential my vision and broad plans for the division, and I will address anything further based on questions from the commissioners. I understand it's been a long day for the commissioners and the Chief Justice.
No, that's comprehensive enough. I take it that all these great things you propose are not happening as we speak.
No, not to my knowledge, it's not. As I said, there's a lack of transparency at the moment.
Okay. Just to round off on your CV, there are many other things you do, including training of young practitioners, and you do that for the K-Bar and the PLA. And you also serve as a member of the Weinberg Small Claims Advisory Board.
That is correct, Chief Justice.
That's important work. All right, you're 51, so you still have about 19 years to look forward to on this bench?
I've got the time and I'm prepared to invest it.
You have all the time in the world. Okay. Judge Campbell.
Thank you, CJ. I have no questions for the committee.
Thank you. Mr. Bosho?
Thank you, CJ. And Judge Slingers, good evening.
Good evening.
I just have one question, or it's a two-part question. So, the GCB and various commenters made mention of, perhaps you're not ready, and CJ touched on that, and I noted your reply. And I suppose the nub of it is that, well, how can you gain the experience if you're not offered an acting opportunity, etc.? And I think that's a perfectly fair answer. Under normal circumstances, is my caveat. So my question is, given what we all know and we've been hearing this whole day, is the division really at this point in a state of health to have the luxury of focusing on rotations in critical leadership positions when what is actually now very obviously required is stability and continuity and an unfragmented vision of leadership, even in an acting capacity? And if the answer is, well, yes, perhaps not at the moment, then is your response perhaps not then revealing of a lack of awareness of the milieu in which you find yourself in that division, and perhaps missing the forest for the trees? And let me just finish by saying it's genuinely just a question. I'm not saying that is the case. Thank you.
Thank you, Commissioner. Let me answer it this way. I think you are correct. The division is at a stage where it needs strong leadership. If appointed as Judge President, I'm not going to circulate my responsibilities. I will be that leader. I will be the final accountability. The buck stops by me. As head of that court, I take responsibility. But at the same time, I need to empower and upskill the judges in my division. So I need to provide them with opportunities to do that. I need to provide them with the means to transfer skills. I need to provide them with the means of testing their appetite for taking on more responsibilities in the court. I need to provide them with the means of seeing how things are run. I think by rotating management tasks, leadership management tasks, not the leadership of the division, but tasks, it will result in greater transparency, greater trust in my leadership, and greater buy-in. I hope I've answered your question.
Yeah, thank you very much. Thank you, CJ.
Commissioner Baloy?
Thank you, CJ. Good evening, Judge.
Good evening.
I'm here, yes. Judge, it's really more a follow-up on your discussion with Mr. Boshoff. Your response to the GCB, and especially your references to the other candidates, in the way that you deal with it, you say, if the comments of the GCB are valid, then that also disqualifies the many other candidates because they don't have experience. Now, on the face of it, I think it's a fair comment, but you do appreciate surely that in this position, the GSC has reason to be concerned about absence of evidence of experience in leadership. I've looked at your CV. There's nothing in your CV, at least that I can see, that speaks to your leadership experience. And then, of course, your answers to the GCB's comments, they speak less to your experience in leadership position, but rather focus more on, well, it applies to the other candidates as well. Is it not fair, actually, to be concerned about absence of evidence of leadership?
Thank you, Commissioner. Perhaps my CV is a bit short on setting out my leadership role. As Deputy Director, I led multidisciplinary teams of different professionals. I was responsible for budgetary plans, for management, for allocating tasks. So I do consider that a leadership role. And yes, I've not had a leadership role in judiciary, and this body is correct to be concerned. And I don't mean to be flippant by what I'm going to say next, so I don't mean it with any disrespect or please take it in the sense in which it's meant. When I was reflecting on this issue, I realized that my role as a mother helped prepare me for this. Because as a mother, I've had to do conflict management. I've had to be transparent. I've had to be accountable. I've had to upskill. So there are lots of similarities between raising children or being a parent and judge president of a court, where the court is the home and the judges act like children. I don't mean to be flippant when I say that.
Thank you, Judge. I'm sure your colleagues at the division will have a further discussion with you about that last part.
I expect so.
Thank you, Chief Justice.
President Molemer.
Thank you very much. Good afternoon, Judge Slingers.
Good afternoon, Judge President.
I listened with interest to the vision that you shared with the Commission, and in response to one of the questions by one of the commissioners, you stated that, and I'm paraphrasing, you are not afraid to take the bull by the horns. And so you have alluded to a few weaknesses that you would correct if appointed. For example, the allocation of other matters other than appeals on Fridays. And your complaint, as I gathered from your response, was burnout because judges now no longer have an opportunity to use that Friday to prepare for cases on Mondays or to write judgments. Now, my question is, as a person who's not afraid to grab the bull by the horns and who has been in that division for quite some time. First of all, maybe let me ask this question. Do you serve in any of the judges' committees?
I serve on the Civil Practice Directive Committee that
Yes.
hasn't sat in a while. I also assist, well, I don't know if it's the Human Resources Committee, but I have been brought in to assist with the appointment of secretaries.
Yes, and you say this, the first one that you mentioned, the Civil Matters Committee has not sat for a while.
It's
Are
not
there
sat for a
any
while.
steps that you, as a member of the committee, took to at least, discuss with the chairperson of the committee with a view to convening meetings of that committee?
No, I have not. The practice directives that was last done was implemented. I think there was going to be a need to sit again after the case lines was rolled out, and at that stage I'd have taken steps so that we could do I would request a meeting so that appropriate directives could be put in place to facilitate that.
Now, as a judge, any judge in any division always has the right to place agenda items for discussion at the judges' meeting. Now, have you ever included these concerns that you have raised here? Have you ever at any stage included them as agenda matters for discussion in a judges' meeting, and have you raised them at the level of judges' meeting?
Thank you. Some of these issues were raised on agendas for the judges' meetings. Unfortunately, the judges' meetings never kept to the agenda, and no issue of substance was really discussed. It wasn't, judges' meetings were taking place once a term, if that. And even though matters were placed on agenda, such as the continuous role was indeed placed on the agenda at a judges' meeting, it simply wasn't gotten to, and the meeting wasn't reconvened to address it.
Yes, specifically with regard to this concern that you raised regarding allocation of other matters, let me call them non-appeal matters on Fridays. Have you ever raised it at a judges' meeting? And I'm talking specifically about you.
It wasn't necessary for me to raise it because it was placed on the agenda. The need for the issues, as I've noted to this committee, was placed on the judges' meetings agenda, just wasn't addressed.
It just wasn't?
It wasn't addressed. It was placed on the agenda for a judges' meeting, not necessarily by myself, but the issues that I've highlighted was brought to the attention of a judges' meeting by placing it on the agenda.
Thank you, Judge.
Thank you,
CJ.
President. Judge President Mlambo.
Thank you very much, Chief Justice. Good evening, Judge Lengers.
Good evening, Commissioner.
I think, let me first say, I listened closely to your vision, and I'm impressed, frankly speaking. You've never been in any leadership position in the division, but your vision is on point on what I've heard here for the whole day. So I want to congratulate you for that. Clearly, you've applied your mind to it. One thing that I didn't hear you speak on, maybe I missed it, is how would you, if you were appointed, resolve these skewed capacitation of criminal roles over civil roles?
Thank you. First of all, I think one of the steps I would take is identify acting judges who can do criminal matters. Because at the moment, the majority of judges or acting judges who are appointed are not able or have no criminal law experience. Therefore, the responsibility of doing criminal matters falls to the permanent judges, which removes them from the civil pool completely. So there's also a perception that only certain people can do criminal matters and that civil matters are reserved for others. So I would appoint more acting judges who are able to take some of the burden off the permanent judges, and I would ensure that judges who have parted criminal matters finalize that first before they get any other responsibility, including other criminal matters.
Just a comment before I go to my next question. You were a director in a law firm. That's a leadership position, isn't it?
It is. It is. Thank you, JP.
I think you should
Thank
have
you,
mentioned
Commissioner.
it because you're shortchanging yourself. But in terms of your judgment writing style, I was impressed. You mentioned here the British tobacco case that was had during COVID.
That's correct.
That's the one that differed from the Gauteng full court judgment. Am I correct?
You are correct,
And
Commissioner.
yours is the applicable law because the SCA upheld yours, and the appeal on the Gauteng one was settled. Am I correct?
That is correct.
Right. The only judgment that I could note of serious note is the Irankunda judgment that deals with a very obscure area in refugee law, the treatment of surplus claims. The SCA reversed you there.
They did. I understand, though, Commissioner, that the matter is going to go to the Constitutional Court, so I would be hesitant to go into the merits of the matter
Yes.
at this particular forum.
But I think the point I want to make is the SCA didn't make any critical comments about how you went about in that matter. Am I correct?
That's correct, Commissioner.
Thank you. Thank you very much, CJ.
Thank you, JP. Commissioner Mwimang?
Thank you, CJ. Good evening, Judge Slingers.
Good evening, Commissioner.
So just one question from my side, which I need to be upfront. It puzzles me that we have 5 judges from the same division contesting, getting interviewed for one position. In your judges' meeting, the issue of succession planning for the division, is it not sometimes discussed just in terms of ensuring that you take the division forward? I'll tell you why. In other divisions where we have had interviews of similar nature, you'll find 1 or 2 candidates which clearly relates the message that indeed the judges of that particular division are able to sit down, make a reflection, and come to a common agreement in terms of how do they take the institution forward. Thank you.
Commissioner, I don't want to speak poorly of other candidates who have appeared before this commission, but I think I'm not being unfair when I say that nothing of substance really was discussed at the judges' meetings, and there was no feedback provided. And the issue of succession plans was definitely not raised or discussed at the judges' meetings when they were held.
Thank you, CJ.
Commissioner Hassan? You'll pass.
It's okay. I think I was going to ask a question about uniting the division. Shall I take a stab at it?
Yes.
Okay, thank you. Judge, I'm over here. I just wanted to ask a very quick one, and it's something just to understand because we've asked a number of different candidates. Given some of the challenges, and you alluded to them, about the different camps and some of the different opportunities given, and I think it's also important to note that it's also become clear that there was only one person who was allowed to act in the position of DJP. So I don't think we should hold it against you that you haven't had that opportunity. But regardless, I'm interested in how you would build a bridge to ensure unity across that division line, but also to ensure maximum cooperation, because one thing that's come through very strongly today is that some people cooperate and some people don't. Thank you.
I think we should start out by acknowledging that a division is a social organization. We've got 33 permanent judges, maybe not the full complement at the moment, but we've got people with strong personalities and egos, so there are going to be disagreements. My role as judge president would not be to get them to like one another necessarily. We are entitled not to like everybody. But what my job as judge president would get them to respect one another and to work together. At the moment, if you look at the latest report on the productivity, the Western Cape is working. We're getting our judgments out. To my knowledge, at this stage, no judge has refused to sit with another judge. We are being productive. We may not necessarily always like one another, but we are sitting together and we are building respect. So, as I said, the more engagement one gives, the more we get to learn to speak, the more we get to learn to work with one another. We will start finding one another then. Once there's respect, it can go over to liking. And when I was newly appointed, there was a thing called Friday lunches. The invitation was extended. Those who wanted to attend could. Those who didn't want to attend didn't have to. And some judges would attend sometimes, others would not. Also, year-end functions, we haven't had that in years. But I don't think we should force the judges to be best friends. They're never going to be best friends. Part of their role as a judge is to bring an independent mind to bear, which means on occasion you disagree. And sometimes those disagreements can be quite robust. But what I will do is foster respect.
Thank you for making yourself available for this position and for your patience with us. You're excused.
Thank you, Chief Justice. Thank you, Commissioners. Thank you. Just this way.
Whoever said they must switch on the aircon.
Good evening, Judge Tulare.
Good evening, CJ and Commissioners.
I don't know where to begin to apologize to you. We've done you a huge disservice. But as I recall an interview you were put through late in the evening, not so long ago, so you are used to this.
I'm becoming famous for being the nocturnal one.
You are well otherwise?
I am okay under the circumstances, CJ. Thank you.
Good. All right. You have an interesting life story to tell. You hold 3 law degrees, all obtained from UNISA, whilst you were working.
That is correct, CJ.
A BUris, LLB, and LLM. You started out as a general laborer at SAB.
That is correct.
And then found your way to the Department of Justice, where you worked as a court interpreter and went through the usual ranks, court interpreter, public prosecutor.
That is correct.
But then you did not become a magistrate right then. Then you went to do your articles.
That is correct, CJ.
But then did not practice as an attorney.
Yes,
And
soon
became a
after I
magistrate.
started, I was invited to the bench, CJ.
So that was in 1999.
That is correct.
So you were a magistrate between 1999 and 2016.
That is correct.
No. And 2021, sorry.
Until the end of 2021.
Yes.
That's when I ceased being a magistrate and became a judge.
And you, in that period, you worked your way all the way to chief magistrate,
That is correct, CJ.
being head of court of a few courts.
Yes.
Okay, so you're no stranger to administration and managing people.
Yes, leadership and management.
Leadership and management, indeed. So just tell me about your acting stints until your permanent appointment in 2022. When and where did you act?
I started in Gauteng. The first judge president to invite me was Judge President Lambo. And I acted in both Pretoria and Johannesburg. And that was 2014 and 2016. In fact, at the time that I packed my bags to start as a chief magistrate for the Western Cape, I was acting in the Gauteng division. And then after my arrival in the Western Cape, in June 2016, in the last term of 2017, Judge President Lope invited me to act in the High Court. And I started acting there. There were times, a term or two, when I would go back to the magistracy, especially during COVID, just to provide the necessary guidance to my colleagues. And then I was appointed as a judge from January 2022.
All right. You've written a number of judgments.
That is correct.
In your time as a judge, 1 or 2 which are said to be questionable for one reason or the other.
Yes, CJ.
How many judgments would you venture you've written?
Around 150.
How many reported, if you know?
As of now, it's over 30.
And overturned only in 5 matters that were
Yes.
taken on appeal?
Yes.
All right. So what do you say to the GCP's comment that your findings in one case cast doubt on your understanding of constitutional law and administrative law, particularly in relation to the jurisdictions and powers of the courts, and that you occasionally stray outside the bounds of judicial power in a way that has the potential to affect public perceptions of your independence?
Yeah, I have commented on the judgment because, and the primary reason was just to indicate facts which I thought it is necessary for the Commission to know, which were not clearly obvious from the judgment.
That's the matter of executive mayor of the city of Cape Town.
That is
DPP
correct.
Western Cape.
That is correct, CJ. And I think it is important to note that I had no such matter with those parties before me, as a result of which I wrote a judgment. There's no judgment. Those parties in that case developed on appeal. And I'm mentioning this against the background of acknowledging the concerns that have been raised. And I accept that I'm a human being and fallible. I'm not here to say I'm perfect. I'm just saying I'm ready to make a contribution to the challenges that are being faced by the Western Cape Division of the High Court.
You've done, you're an activist. You've done and you continue to do many things in the legal sphere and outside the legal sphere, including being a bishop of a church.
That is correct, CJ.
You are described by some of the professional bodies as an accomplished leader and hard worker with the requisite attributes, skills, aptitude, and temperament to assume the responsibilities of this position for which you've applied.
That is correct, yes.
I think your leadership qualities are not in doubt. Well, not as far as I can discern from the reviews that have been submitted to this body.
Thank you,
and what
CJ.
one gathers from your CV. But then, and I ask this with the full reassurance that I have, because I personally know of the contribution you've made, your belief in the empowerment of women in the judiciary, and your contribution, for example, to the South African chapter of the International Association of Women Judges from way back when it was not fashionable for male judicial officers to be members or to take any interest in that body. But you were right there in the trenches with us, fighting the causes of gender equality in the judiciary. So I put this concern raised by the LSSA comfortable with that knowledge. They say they don't oppose your appointment as Judge President of that division, but caution us to consider that you are competing against several highly qualified female candidates who would help increase the number of female judges president. I know it's unfair to put this to you, but I have to. What would you say to this comment?
I acknowledge that the point at which we are in the country, it is important to assert the neglected role previously of women in the judiciary in general, but in particular in leadership. But I have also consciously decided, you've rightly commented that I'm a member amongst others of the SEC IAWJ, and obviously the advancement of women, especially in leadership positions, is something that is close to my heart as a member and as one of the objectives of the organization. But I also reflected on the challenges that are there in the division. And against the background of my, what I would call, for lack of better terminology, functional literacy of the environment of judicial leadership, and what I have observed happening in the division, I thought it is also my call to avail myself. At the end of the day, it is up to the Judicial Services Commission to make the call.
All right. What ideas do you have for that division of yours?
CJ,
as concisely as you possibly can make it.
I will try. I have already provided in writing, together with my submission of nomination documents, my vision. So I will only touch on a few areas in respect of what I deem to need some highlighting. First of all, I want to present myself to the commission as to who is Daniel Tulare. You have a record of my academic training and my path of travel to this point. But also, and things that I think are very necessary for that division, is what I call my indigenous heritage, the wisdom of my ancestors that I'm bringing to the division. In the far northwest corner of the Republic, there is a clan or a tribe called Babirwa. They are in the area called Malebogo, ordinarily referred to as the Blowback area. That is where my maternal side comes from. And I'm sharing this with the commission because I'm the grandson of one of the leaders there at his time known as Nalana Lehong. Now, one of the things that he has taught me around leadership, which I'm carrying if I'm appointed with me to the Western Cape, is to say, son, where there is a point of difference, always humble yourself to the possibility that you may be the one that is wrong. And where the logic of the other seems to be superior to yours, and or you're shown to be wrong, learn from that. And then towards the northeastern corner of the Republic, there is a family that leads the Bapedi nation. Chief Justice, I'm privileged to carry their surname. Now, one of the things that I have learned from the lineage of my ancestors from that area is that when there are challenges, there is a need for courage and resilience. One of the most known leaders coming from that surname would be Sikukuni. Those who know South African history would know about him. And lastly, talking about the indigenous wisdom that I'm bringing to the division and carrying with me, is that when I followed on my genealogy, it took me to a nation currently occupying the central part of Botswana. And it is a nation called Bangwatu. Now they have a saying, Pula Aene, let it rain for everybody. You can't want to dominate and want to be rained on only yourself. So this is against the background of the trail of the portfolio of evidence around leadership that you have in the academic training, part of the puzzle that I'm bringing to the division. And I'm mentioning this background as an introduction, Chief Justice, because my own view is that judgeship is a calling. When you have occasion to lead judicial officers in general, you are an equal amongst equals first. And then your position makes you the first amongst equals. And you represent the judicial authority of the Republic of South Africa in the division for which you are called as a judge president. Now, one of the areas of concern, CJ, in the division is collegiality. And this collegiality is not necessary only between judges serving in the division amongst themselves. The disturbance of collegiality in the Western Cape goes beyond the sitting judges. It involves and it includes other stakeholders. In my view, trust is lost amongst other colleagues and between colleagues and other role players. Now, to deal with that amongst others, there is a need to address two issues in particular. Number one is etiquette. Number two is communication. I'm mentioning etiquette as distinct from communication because, CJ, when I arrived in both Gauteng and the Western Cape itself, on the first day of term, both Judge Presidents Mlambo and Judge President Klope at the time took me to the tea room of the division. And they introduced me to colleagues in the division. So the first day of term, it was compulsory, for lack of better terminology, for all judges to be available for the judges' common room. You did not, during term, bump into somebody in the garage which even alerts you to issues of your own security in the evening when you leave the building. And when you ask, who are you? You are told, no, I'm an acting judge in the division. And unfortunately, this is what one is experiencing. So questions of etiquette, introducing your colleagues on the first day, how you communicate with judges. I mean, I was told in both divisions by both Judge President Mlambo and Judge President Klope to say, you do not, and that is etiquette 101, you do not communicate with your colleagues through the administration. You don't. If there's anything that you want to communicate to your colleague, you ask for their availability from them. If you are the junior judge, you are the one that has to walk to their chambers. It is unfortunate, CJ, that, and these things are not things that I'm raising for the first time at this interview. They are things that I've discussed with the leadership in the division. I've expressed my concern. For instance, when you communicate, if I write to you, CJ, in your capacity as the Chief Justice of the Republic, I expect you to respond to me in that capacity. It is unfortunate if I have to receive correspondence from an email from somebody within the administration pretending to be you. I think it is an affront to the judicial authority and the line function within the arm of the state of the judiciary. So when we complain, for lack of better terms, around the question of communication and consultation, is not only simple complaints because they affect, as I say, questions of etiquette and the location of the judicial authority in the discussion. Because I must know whether, in fact, I'm discussing with a member of another chapter in the Constitution, whether I'm talking to a chapter 10 or I'm still within chapter 8 talking to the judiciary or the judicial head of the division. So it's not simple things in my view. And where one observes that the judicial authority becomes subordinate, amongst others, in the manner in which communication is unfolding. It is alerting. And for a person with my background, it becomes very difficult to sustain that. And that is why, amongst others, because of acknowledgement of those kinds of concerns, in order to help assert the judicial authority of the Republic in the division, I'm saying I'm available. Moving to the other aspect, an impartial, courageous, and independent division. Let me hasten to say, judges in the division, individually, do their best. They work very hard. And I don't want us to take anything away from them. What needs attention is the environment under which judges are working. That really needs attention. So that the intellectual rigor in terms of the jurisprudence, the environment is created for that. I mean, when you deal with a complex matter, to produce a judgment, you need time. There must be engagement once you allocated a complex matter with the judicial leader, and there must be an understanding of, what time do you need in relation to further allocations, so as to camp the question of judgments outstanding for long, especially on complex matters. And then, CJ, the other aspect that I would like to touch on is the question of backlogs. I think there is a need for individualization. In the Western Cape, we have what we call various divisions. So you have Division 1 up until Division 16. And they all basically talk to line functions. Whether you're dealing with civil appeals, it has got its own division number or numbers. When you deal with criminal appeals, it has got its own division numbers. So it is very important to look at that breakdown, to have a template where you look at which judges have been allocated to which matters and which judges have been doing a particular line function for a longer period than others. What is the overall impact of their input in relation to the output of the division? And this is how I intend addressing the question of backlogs, whether in civil or family. I have raised a concern in a public meeting of judges around the question of allocation, including my observation, and I'll use the terminology that I used in the meeting, Chief Justice, because sometimes you have to use language to put that thing in for people to understand the nature of the concern and the extent to which you view its seriousness. And I've raised the concern that the manner in which we are operating, in my view, leads to what one may call privatization of private law in the division. If you have a pattern of allocations where consistently civil matters are given to acting judges, and primarily who come from the bar, and judges who are serving in the division are not dealing with civil matters, complex civil matters, you are heading to a situation where permanent judges become experts of criminal litigation. You are not building capacity. I have observed previous interviews, and what I've picked up is that the commission does attend to concerns around briefing patterns for practitioners. But I'm saying, from this interview, I think commissioners would have picked up that there is also a need to look at the allocation of matters. Otherwise, we are heading to a situation where, Chief Justice, you do not have Africans, for argument's sake in particular, an African female who leads a panel on a matter involving a dispute that arose in the National Assembly. You are not going to have that panel unless there is a disruption of leadership. That's my observation. You are never going to have a black, in the generic sense, female leading a panel on the questions of constitutional law or even complex civil matters. And against the background of our history, these are things we need to attend to. We need not pretend that all is well. I think it is very clear that all is not well, including on questions of allocation. So it is important to keep a template to say who has done what when, and where you observe an over-concentration of certain judges in certain areas to the exclusion of certain judges in certain areas, it is the purpose and the objective of leadership to interfere to make sure that the allocation does not create an impression that certain minds are intellectually inferior to engage with certain matters that come before our courts in the division. I'm saying this, CJ, against the background of what was a public comment by the previous CJ of a concern of lack of depth, for lack of better terminology, within current serving judges in terms of readiness for the Constitutional Court. So if it doesn't start at the High Court level, where there is exposure to complex civil matters, including constitutional and administrative law questions, if there is no exposure, how do we expect the experience to be built up? And I think against that background, I'm saying, Tulare, yes, Tulare, I'm available to assist the division. Perhaps in closing, CJ, I am not just saying things that I haven't been doing, including the training and preparation of aspirant magistrates and aspirant judges for the High Court. I am in discussions with the various organizations that are active within the legal fraternity. I avail myself, whether it's SEC-IWJ, whether it's NADEL, whether it's BLA, whether it's Advocates for Transformation, whether it's SAULA, when I'm invited for training on subject matter issues, I do avail myself as part of the strategy to capacity building. But I also do so in terms of acting judges who are appointed for the division. And not only for the division. I mean, I receive calls even outside the division from judges bouncing ideas with me on certain areas of the law that we are discussing. So the continued training and capacity building is one area that I will continue to deal with. And digitization, CJ, one of the immediate things that we can do, there are currently audiovisual remand facilities that the department provides. Let me say the Department of Justice, which ordinarily supports the magistracy. But there's collaboration in terms of infrastructure. I think it is still the Department of Justice that takes responsibility for infrastructure for the high courts, from my engagements with the administration. So those are things that we can do immediately. I mean, there's no reason, in my view, why every morning there should be always police running on the sidelines of the heavy traffic in the Western Cape, concerned about their security and safety, but also rushing awaiting trial prisoners to be at court before 9 o'clock, when we actually have audiovisual remand facilities as an avenue to explore, over and above the question of digitization. So I don't want to go further than that, CJ, in the light of time. I will deal with any areas that may be raised. But perhaps most importantly, on the question of courage, I have to state, and I think it's a matter of public record, that I am of the view, and still remain so, CJ, even after reading the latest report by JP Mwepe on the institutional model for the judiciary. I have read it. I haven't seen its discussion on Section 166 of the Constitution, which deals with the judicial system. And I still hold the view that whilst there's differentiation in the hierarchies of the courts, the high courts, the magistrates' courts, and the traditional courts, the fact of the matter is that what the Constitution refers to as the judicial system includes the judiciary, or otherwise, the judiciary includes the judicial system. So you are the Chief Justice, in my view, not only of the superior courts, you are the Chief Justice of the judicial system, which includes the magistrates' courts, which includes the traditional courts. Commissioners would have had the benefit of reading one of the latest papers that I wrote, where I'm saying South Africa is a reluctant and doubtful leader of nations when it comes to the inclusion of indigenous people's laws and courts in a judicial system of a country. And I still stand by that position, CJ, to say you are the Chief Justice, not only of the superior courts, but of the magistrates' courts, including the traditional courts, because they are courts through another act of parliament. And as a result, as we move forward, and here I'm talking long-term, CJ, I'm basically saying I'm an asset in your hands if appointed, because I have the functional literacy of what happens in the traditional courts. I've been involved in their training. As I indicated, by the incidence of my birth, I was born within that environment, so I know what is happening. Judge President Mlambo is on record as saying we must move towards mediation, and I'm closing here. And I'm saying there is no informed institutional memory in the Republic on mediation, conciliation, and arbitration better than the traditional courts. We need to tap into that resource. Thank you, CJ.
Thank you, Judge. Judge Gamble.
Thank you, CJ. I have nothing for the candidate.
Mr. Boshoff.
Thank you, CJ. Evening.
Good evening.
Judge Tulare. The matter of the executive mayor.
Yes.
I've had a look at your response, and I just have two brief comments to which I would appreciate your response.
Yes.
So, in your response, you say at one point in respect of, in your response to the objection or the criticism raised by some of the bodies, is that you say, I didn't have the heart to walk away from that child unattended by judicial intervention. Now, these were sentencing proceedings, and I certainly can empathize or sympathize and even admire the sentiment expressed there, but is that not what makes your job actually so difficult, and why this isn't a job just for any practitioner? Is the ability to not allow the emotional bleed into what your core duty is when dealing with a matter before you within the confines of the law. And did you not perhaps make yourself guilty of a misstep there by allowing that to happen in that regard? And maybe first respond to that, and then I can get to the second part.
Chief Justice, I held the view that when, remember as a point of departure, sentencing is an inquisitorial process, over and above when you then have a child before you. And I'm an upper guardian of minor children within the division. That's what I understand the law to be. I also moved from the premise that what we call a VIS, victim impact statements, during sentencing proceedings. My view was that that was not simply an academic ritual to be performed by a judge. My view was that in sentencing proceedings, when you are faced with a child in distress, you have a duty to intervene. That's the view that I held. I accept, as I said, referring to Nalana Lehum, my grandfather, I have seen the judgment of the full bench. I accept their authority. I've learned from that.
Thank you, Judge. And then just the second part, I mean, there are various issues raised by the full bench in dealing with your judgment. But I just want to touch on the issue of judicial overreach, and where they say, look, you fail to display deference to the constitutional limits of judicial powers. And then in your response, you make a statement which I find curious, in where you say the Western Cape Division still must develop jurisprudence of how the municipality deals with a vulnerable child in distress as a victim of crime. Now, does that not once again reveal a misunderstanding of your limits of power, in that what you described there, to me, strikes me as the domain of the lawmakers and the policymakers, the executive and the legislature, not the judiciary. And that, in essence, fundamentally strikes at the heart of the concept of administrative power and ultra vires and the limits of power in general.
Yeah, I have taken note of the criticism. As I say, when you are in the heat of the moment, there are matters that you consider, and that is why in our legal system there is a review and an appeal process, you see. And I'm not, as I indicated, I'm not here to present myself as Mr. Know-it-all. I accept that now and then, in the nature of our job, you may strive to do your best, but your best may not simply be enough. But I don't think one should be judged by one matter when you deal with multitudes of matters every day. So I have learned. There are what, CJ, I would call, for lack of better terminology, long shots, you know. I follow soccer, so when the national team plays, there was a guy called Kekana, he played for Sundowns. You know, even from afar, he tried to kick for goal. So if you look at matters where I have been criticized, the few that I've been criticized on, is where I had taken the long shot in the greater scheme of things. And I accept that sometimes you may not score from a long shot. Thank you.
Thank you, Judge. Thank you, CJ.
Commissioner Gotzel.
Thank you, CJ. Good evening. Yeah.
Good evening.
Good evening, Judge Tulore. You've been a judge now for 2 years, and you wish to lead the Western Cape Division.
Yes.
And you were the Chief Magistrate for Cape Town from 2016 to 2022. How many magistrates' courts resorted under you in that time? Because you're not just the magistrate for Cape Town, it's for the wider area.
Yes. When you are the magistrate of Cape Town, the chief magistrate of Cape Town, you're basically responsible for half of the province, not the entirety of the province. So it was over 80 magistrates' courts that reported to me.
All right. Now, earlier this year in a review judgment, you were quite critical of the magistrates in Cape Town. You said in a review judgment that magistrates in Cape Town have become recruiting agents for gang culture on the Cape Flats. You based this on the fact that, in your opinion, they do this by incarcerating accused persons rather than granting bail. Although this was based on one specific case, this is a very generalized comment. Now, you are applying for a leadership position, but what does this say about your leadership of the Cape Town magistracy between 2016 and 2022? Because this judgment was delivered earlier this year.
Yeah, but I think it was not an observation that simply came from a once-off thing. If you read quite a few judgments where I have raised issue, and it's not that those issues were not discussed with the magistracy at the time that I was their leader. They were discussed. So the question of how you deal within, you'd also recall that very early, whilst I was still acting, I complained about what I call judicial warehousing of poor people. And it spoke to the same issue, that when a person appears before you for the first time, in our constitutional democracy, as a judicial officer, you have to make an effort to ascertain that the person before you is actually a candidate for incarceration pre-trial. So it's not a once-off thing. There are quite a number of judgments where, and some of them were written even when I was acting. And remember, when you're acting, you only act during term. During recess, you go back to your station. So it was not a once-off thing. It's a concern that I have consistently raised. The incarceration, especially in the Western Cape, the incarceration of poor persons in circumstances where, if proper assessment of the facts was done, the return would have been different in my view.
But this was one specific review judgment. And if I understand correctly, reviews come to judges, they're allocated randomly. And you read through it, and you decide whether the magistrate made the correct decision or not.
Yes.
So this was a review judgment in which you generalized, and you used words like bad attitude, laziness, and dereliction of duty. So my final question to you is this the collegiality that you referred to earlier?
I don't understand collegiality to include not calling out things that you believe are not right. Collegiality includes that when you believe that things are not correct, you voice it out to the relevant persons. And that was my approach.
Sorry, CJ, but surely you can't use one review judgment to use these words to describe all the Cape Town magistrates.
I have indicated, CJ, that the question of how bail is handled and pre-trial decisions on incarceration of persons is a concern in the Western Cape. That's the premise from which I move.
Commissioner Nonkonyan?
Thank you, CJ. Good evening, Judge Tulare.
Good evening, Commissioner.
Yes. Two-pronged question. I'm impressed by what you term indigenous wisdom. Now, I take it you are from Limpopo, if I understood you.
My origins are from there, yes.
Yes, yes. And there has been kingship dispute, particularly within even Tulare Kingdom.
Yes.
Put it that way. Again, in the position in which you are applying, we know, I take it you know, that there have been some challenges around leadership. All what I want to find from you, can you share with us what did you do to prove your leadership skill in those difficult senior position, traditional leadership on the other hand, and the leadership of the judiciary in the Western Cape Division? What have you done to demonstrate that you will be a fit and proper person to lead that division? It is in that context that I'm asking you this question.
Yeah. Let me deal with the leadership dispute within the Tulare family first. You'd appreciate that because of the offices that I have held, it was necessary for me to stay away from those disputes, because it would be unfair for me to align with one particular extended family to the exclusion of the other when matters are before courts and I'm active within the court environment. So I'm not in that space. That's the first one. The second one is, as I've indicated, the concerns that I am raising here are not concerns that are not unknown to the leadership. As I say, I mean, Judge Gamble is sitting here. He doesn't hear for the first time that I am complaining that there is privatization of private law in the Western Cape. So it's not the question that these things have not been raised. I think the question is how they are responded to. Thank you.
You have finished?
Yes.
Oh, thank you, Chief Justice.
Thank you, Commissioner Inkosi. Commissioner Nuches?
Thank you, CJ. I'm not sure what I'm right when I say Jose Hulu Yabapet. Good evening.
Good evening. I carry the same name of that, but I don't carry that title.
Okay. Yeah. Look, I just wanted to address this question. I wanted to just to address this question.
If you want to be safe, you must just say Mushati.
Yeah. I wanted to address this question that Commissioner Malema often asks in circumstances such as this. I think you are in that division. You've been appointed as 2 years.
Yes.
I don't doubt your leadership background and all, as you have said. But would it not, if at this stage, I mean, just if you comment on that, if we are appointed now, is it not too soon? Or as Commissioner Madam simply put, that we are baptized today and we look for the seat of the bishops immediately. We are baptized and say, when coming from the water, say, hey, where are the bishops staying?
Yeah.
I mean, can't you deal with that just?
Yeah. I would indicate to say, look, as I indicated, leading the judiciary, it's quite different from ordinary leadership, because you're leading people who have distinguished themselves in various ways, all right? And that is why I'm saying at the end of the day, over and above the need to say, this is the way to go, you humble yourself to acknowledge that other judges may know certain things better than you do. And what you then do under those circumstances is you use the strengths of your judicial officers to attend to problem areas as you identify them. All that you need to do in the main is to provide a platform. Colleagues must be free to approach you to say, this is the way I think we should do things. And it is your responsibility then to assess the manner in which things are currently being done in the light of the new recommendations that comes through, and then weigh your options to say which one is the best. And sometimes you bounce ideas with other people, including other judge presidents. I mean, I'm not going to go there and be, the Mr. Know-it-all. There are resources. I mean, Justice Mlambo is an example. Judge presidents of other divisions are available. The CJ herself is available. So, and as I say, the challenges, some of the challenges that goes to the heart of what is the problem in the division, in my view, I have the experience of dealing with them. I mean, I've touched on the question of etiquette. I've touched on the question of asserting the judicial authority in the division so that it is known that this is the seat of the judiciary of the province.
Then my last question is,
Can I make a
if you
follow-up?
are appointed...
Can I make a follow-up, CJ?
There's a follow-up, Commissioner Regis.
Yes. No. I'm just following up on what he's saying. That in your 2 years, and even when we are happy with your leadership qualities and all of that, you don't see any leader. You see yourself. That you arrive and say, these ones, I'm going to be in charge of them. Just on arrival. Because a good leader is a leader who's able to identify leadership in others and be prepared to be led. That's where the context of Baruti comes from, that you get baptized today, and then immediately you say, where are the pastors sitting? You can't do that. And then where are you putting us? I mean, we all like you here. We interviewed you, we were so happy with your leadership and all of that. And then the next thing you come back to us, in a division like that, where there are senior judges, and then we must overlook where's African women in this interview came. Some of them demonstrated leadership, which you should have seen even before you come here as a leader and say, but there are African women here, there are black women here with capacity, there are other judges, senior judges with capacity. Why can't you just allow that, look, let me be led by others to avoid putting the JSC at a difficult position? Because, even if we like you, you put us in a position where we now have to go and speak against you. Think for us before. Just think for us. Please. Thank you.
You want to respond to that?
Yeah, I just have to say, CJ,